All right, hello everybody. If you've been hearing about this Stop Cop City Rico case and you're like, wow, that sounds ginormous. There's like 11,000 defendants. There's really 61. This is a lot. I can't get into it because there's got to be so much background information. I'll just be lost. That's not the case. We're going to get into it starting with yesterday's hearing. We're going to watch some arguments from Attorney Don Samuels and the response from the state. Even though we're going to feel like we're in Fulton County, this is really a case that's being brought by the state attorney general, Chris Carr. So it's not a Fonnie Willis case. I think that's a common question. But it's got a lot of the elements that we saw with the YSL trial. It might be worse. It might be worse. So the arguments we're going to look at from yesterday, and we're going to start watching some of today, center around flaws in the indictment. An indictment, as an instrument, it's a charging instrument, but it's also what tells the defendants what they need to defend themselves against. So if you're not alleging everything as you should in the indictment, well, then you're jeopardizing the defendant's right to fairly defend themselves because they don't know what they're supposed to defend against. We're going to hear some incredible arguments from Don Samuel. You might remember him if you paid attention to the Christopher Wolfenbarger case. This is going to be my second time watching this, kind of third, because I caught little bits and pieces yesterday morning and then watched this in full with Jim Robichaux, or Happily Angry Lawyer, as you guys know we give him his AKA. And I highly recommend anytime I'm not available to stream what's going on with this case, you either, if you want commentary, check it out with Jim, link in the description, or if you don't want the commentary or you want to watch it twice like a lot of us are doing, I see a lot of people that have watched it twice here in the building, like Factual Lie and Trikisha. Yeah, this is my third time. Also, really, really great channel to follow is Atlanta Community Press Collective. They are also linked in the description. Let me drop their link because that might be, besides a quick mention yesterday, that might be one of the first times. I think I mentioned them for a Suri Shada Jimenez interview a few weeks ago in relation to this case. Let's see. So we'll call this ATL Press Collective. But definitely worth subscribing to them. They're doing great work, not just making sure there's coverage of this case, but other things going on in Atlanta. So that's my start off roundup. If you guys want a quick summary of the case, guys, the Stop Cop City Rico case, the state is alleging a cohesive enterprise, a group of protesters that got together for this common purpose of opposing the planned construction of a giant, like huge police training center. This is going to be in Atlanta's South River Forest area, so that's why we're getting like Stop Cop City. We want to save the environment. Don't just clear cut all of this land and build this unnecessary facility. That's the gist of it. So the deforestation and over-militarization were the two grievances alleged to be the core purpose of this enterprise. We've got 61 activists in this indictment. They're being charged under Rico, conspiracy to violate Rico. And we're going to watch the prosecutor mess up Rico. If you guys don't feel like you understand Rico, that's fine. The prosecutor doesn't here either. But let's see. Ayla King. I want to mention Ayla King, and I don't remember the exact date offhand. But Ayla King, we'll take a quick look over here. Let me share this tab. And again, this is 61 and a million bajillion co-defendants. So they came up with this trial order. They're going to try in groups, right? So they're breaking up the 61 into different groups to make sure they go through and cross all the T's, dot all the I's. And the group we're looking at today and yesterday's hearing is really this group one. But Ayla King, she's not in the mix right now. So Ayla King, she filed a speedy trial motion and her trial started. This is like July maybe. And when it finally started, they seat the jury. And then the judge declares a mistrial because of jury issues. And the defense is like, well, no, we like took our time impaneling this jury. We want the same jury. You've sat them already. So we're actually going to oppose this mistrial because we think double jeopardy attaches. So that I'll look for updates, but I think that's being heard at the appellate level this month. So we'll look for updates this month on that. But yeah, already crazy stuff going on. I think that's a quick summary, you guys. There is a lot of information, but that's the gist of what we're going to get into. And yes, 2 pressers yesterday. I saw one with, let me look at this sheet quick. It was with Alex Papali. So one of the defendants spoke. They did an interview with the Atlanta Press Collective. So I think maybe I directly linked to that in the description. If not, it's like right on the top of their channel. So really, really, really cool. We'll get into your comments, say hello to everybody, and we'll get into this hearing. We're going to start with a quick housekeeping thing when we hit the play button, but we are skipping the arguments from one of the defense attorneys because we're going to get caught up with this first day of hearings. But I think you guys are going to love this housekeeping moment. So hey to Amanda and Anisha. Hey to Next Chapter. The chapters keep on going. Megan F. And again, we had a few people mention it, but if you've already watched these hearings and you're watching it again because it was that ridiculous, let us know. I can relate. Hey to Angel. Hey to Special Bendy Bros. Love your picture. Hey, Larry. Hey, hope you're doing well. We've got Kim in the building. We've got What the F. So, if you need to express yourself while watching this go down, we've got the perfect name in the building. Trikisha, we know, is here for like around at least 2.5, I think. Hey to Nino, ML. Crushing hard on Max Shart. I'm actually wondering, I don't remember if Max has a client in this case, but we are going to see a million familiar attorney faces and learn a lot more. Hey, Mavka, really good to see ya. We've got Kerman in the building, says I listen to music, so I'm part of the Rico now too. Yep, if you've ever protested anything, listened to music, read a blog. So that's another thing we're going to hear about. You write blog posts online. Uh-oh, chat. Hey, Robert, hanging out on YouTube today. Yeah, Kim says, had me cracking up last night with him laughing. Yeah, this judge is a great time. This judge is very, very animated with his facial expressions. Amanda is here for the second time watching through this. Lauren says, this is a mess. And this is a common question, you guys. This is brought by the State Attorney General, Chris Carr. So, not a Fani Willis Rico, but whatever. It's the same trying to make Rico happen, and where is the Rico? So, Michelle and Felicia, Deanne, good to see ya. Good to see ya. There will probably be a lot of sighs, especially when we get into the fresh content, today's hearing content. It might be a little reserved because I've watched this first one already, but I don't know. It's so bad you might get some sighs all over again. Sleepy, good to see you. I feel sleepy today. Yeah, Megan's here for the 3rd time. Anisha's here for the 3rd time. Guys, I'm telling you, it's ridiculous. Freedom Keeps Missing Me says this was insane yesterday. We've got Destin to Beat and KP. The gang's rolling in. And okay, Amanda says he has got a client on the case. So thank you, Amanda. So we're going to see Max Shart in one of these groups. I didn't see him in the courtroom yesterday, so probably for somewhere down here. And we'll keep this up. If I don't switch the tab now, I'll start playing without the screen shared. Factualize says appeal to your inner judge and give that like button a verdict of awesome. I would love that. I would love that. Hey, Corky. Hey, Peter Steele. Shaylee. I think you were watching this yesterday, too. I saw you somewhere. Mixed Chick, good to see you. Andrew Rodriguez, there is a quick description in the, a quick summary in the description of this video here. So check that out. Really, I think you'll get the gist of what the state's alleging or failing to allege, right? I can't summarize what the state's alleging because their indictment is so stupid that it's really more about what they're trying to allege but actually fail to do so in the instrument where they're supposed to do the alleging, if that makes sense. So, Kimmy, Butterfly Lover, good to see you. Anthony is here in the building. Ms. D, and let's see. We're going to get into this, guys. We're going to start with this housekeeping thing. And as soon as you realize what this attorney is going to ask for... Oh, I should boost the volume. We'll boost it. We'll have it. As soon as you realize what this attorney is asking for, drop the name in the chat that makes you think of it.
That I'm going to stop your interruption right there.
Housekeeping question.
Go ahead.
The court's made clear that for pleadings, we have to individualize our demurs, our motions. We can't just adopt. This is the first time in the case, I think, where we have an objection sort of procedurally that a defendant has lodged. Do you want the other three who are here adopting that contemporaneously?
So I have to have all four of you say I want in on that one?
And my recommendation is that
Yes.
should be practice.
Yes. Unless otherwise stated, the three others will be joining in the objection. Unless you say, hey, Judge, I'm not in on that objection.
So it's an opt-out?
It's an opt-out.
Okay.
Yes.
Understood. Thank you.
All right.
They're not going to do the Harvey rule,
Come on,
guys.
Mr.
They're not going to do it. And now this is Don Samuel. Guys, you are in for a treat. I might as well just start calling myself a Don Samuel stan. I don't want to steer the way you interpret his arguments, but my top level view of Don Samuel, he has this way of treating the entirety of the case as his chessboard. And he'll make the little in the moment, granular, very specific arguments. But he's just so astute and he's so big picture oriented, and his logic, his reasoning, his philosophy, his ability to take in all of the pieces of the puzzle and show you how one issue over here is going to become an issue here. It's really a treat to watch this guy argue. And he's going to throw in all the examples and the metaphors and a bit of the dramatics, and he does it all really well. But ultimately, the level of intellect he brings in, this is why I wanted to watch this with you guys. And I feel like people really thought this case was too big to get into. It's not. I hope that more people start paying attention to it, because I think it's going to be just as bad as the YSL Rico. So Don Samuel, everybody.
And just like we discussed, Your Honor, before Mr. Samuel begins, because Mr. Samuel doesn't represent any one of these defendants, we can just put it on the record. Defendants have no objection to Mr. Samuel arguing this for the purposes of waiver.
Fair enough.
So the defendants for the first group aren't his clients. But they're all like, yeah, we want him. We want him to do his argument. We're fine with it, Judge. We love it.
I think Mr. Hetzel actually, not only does he not object, he actually invited Mr. Samuel to testify on his client's behalf. So, any objection, Mr. Hetzel?
Not for me, Your Honor.
Okay. Any objection from any of the other counsel?
I'm not opting out, Judge.
There you go.
No objection.
There you go.
Just another housekeeping matter, just before we get started with Mr. Samuel.
I did not think my house was that dirty.
Mine is something after preparing for this motion, we're going to talk about my house. So, Judge, one request that the state would have is, when we talked about our scheduling conference, my understanding it was that we would handle, that each of them would argue, so Mr. Carroll, the attorneys for Carroll, Papali, and Marsicano, and Liberto would argue their motions to count, demurs to count one. And my request is, if we could go ahead and let everybody argue what they're going to argue on that issue where they filed it, and then I would respond all at one time, instead of, just my request, instead of responding to each, because it's going to get redundant, if that makes sense, to me, for me. Just a request.
Oh, it's going to be ugly. So, Mr. Samuel?
You want me to respond to that, or just make my...
Just
all right. Your Honor,
my response is, please proceed, Mr. Samuel.
all right. Your Honor, I represent Marlon Counts, Adele McLean, and Savannah Patterson, the members of the Atlanta Solidarity Fund, who were indicted being co-conspirators in this case. There are many issues raised in our demur. I'm sure you read the motion, the original motion, and the one that I filed again in accordance with your request on May 30th of this year. There are scores of issues. Maybe I could group them together in certain ways. Many of them deal with my clients and not necessarily with one of the first four in the first group. So it's a little confusing, but I am going to address all the issues in my demur. I don't think it makes sense, as you did with the prior argument, to take one issue at a time and have a response. But if that's what the court prefers, I'll break it down into different issues, and you can.
No, just Mr. Hetzel sat down after the date range, and he wanted to argue the date range first. I'm here for you all.
Okay. Well, I will. If you want a response from the prosecution at any point during my argument, then that's fine. Otherwise, I'm going to proceed from one argument to the next. Some of my arguments or blend into both general demur and special demur, dealing with specific overt acts, specific aspects of the indictment which we consider to be right for a special demur. But I'm going to discuss all the demur issues in this initial presentation. I would point out that the prosecution, since we originally filed our demurs close to 2 years ago, has never filed a response to our demurs. They haven't filed a response when we initially filed the demurs. They didn't file a response in anticipation of the oral argument before Judge Adams. They didn't brief the issue after the oral argument with Judge Adams. They haven't filed a response in anticipation of this argument today. So the only thing I know about the prosecution's response is the oral argument they made when we argued this before Judge Adams. I don't know if their response is the same today, so I'm a little bit at a loss to anticipate what their arguments are. I can't preempt what their responses are, but I will reserve time to reply to what I may be hearing for the first time when they finally reveal what their explanation is for some of the defects in the indictment. And of course, I'll respond to any questions you have. We have broken down the demur issues into several categories, as I said. One deals with the problem. I'm only in the Rico count, by the way. We were originally indicted on several money laundering counts.
Malprost.
They were malprost because we filed a demur because they were so defective that I don't think even the prosecution contended they could go forward with those counts.
So do you already, we're 2 minutes into his argument, and he's already rolling out, look, I'm representing 3 people on this case. We've already gotten, they're just facing this Rico count. That's all that's remaining, because everything else all the charges that the grand jury returned against my other clients, gone, off the table, because we've already successfully argued demur issues. And he's saying here it was so bad that the state didn't even fight us in our motion to kick those off the table. Hot mess. Hot mess.
Re-indicted, so we're just dealing with the Rico conspiracy here. My clients, as you know from reading the indictments, out of the 225 overt acts are listed in 80, 90 of them, maybe even more than that.
Captions.
But they do fit into general categories. There's a category I refer to as the seems no blog category of overt acts. There's this allegation, and I'm going to talk about this in great specificity, but I'm just kind of giving you the table of contents at this point. There's this allegation that our three clients, in addition to unknown co-conspirators, all authored calls to action, so to speak. We have seen no evidence of that in the discovery. Now, I'm not going to sit here and argue the insufficiency of the evidence, but it would have been nice had the indictment alleged some fact, any fact, that sufficiently alleged that the 3 members of the Solidarity Fund somehow had something to do with authoring documents that were, again, I'm going to refer to them as calls to action or suggestions that criminal conduct should occur. There's nothing in the discovery to verify that. And it also alleges in those counts that there were unindicted co-conspirators who participated. I don't know how many people in each one of those overt acts, the seems no blogs overt acts, I don't know how many people are alleged to have supposedly authored these documents or somehow responsible for what showed up in a magazine or magazine.
See no blogs?
Your Honor, if you take a look at the indictment, just the very first series of overt acts, look at just overt act 6, for example. That's the first one. 5, 6, 7, 8, 9.
Got it. What, the URL. Gotcha.
Yeah. And just so you know, and I'm not sure it's necessarily relevant to it, we've even sat down with Mr. Fowler a year and a half ago and said, where is the evidence?
Thank you,
That
Catfink.
either Mr. Couch or Ms. McLean or Ms. Patterson authored these, submitted them. What does it mean to say that they're co-conspirators along with unindicted, unknown co-conspirators who authored, these blog posts? And we were given essentially nothing. We were shown one document where the 2 names appeared on the same document. Atlanta Solidarity Fund and the Seams blog appeared on in one document together. There's no other evidence we've been shown. Now, again, I'm not sitting here arguing that they got to prove their case in the indictment, but they have to allege the facts, which put us on sufficient notice so we can defend the case. That's the essence of a special demur. Allege sufficient facts so that the defense can prepare for trial. And they've alleged.
And now we try to make these streams audio friendly for those that are in the bushes, or, you know, we want to make it accessible even if you can't see the screen. Look at this prosecutor. If you're able to look at the screen, puts you on notice. If you're not, this prosecutor's already looking stressed out, taking notes, scrabbling, and all we're talking about is what they alleged in their own indictment. Why are we taking notes on our own thing that we've already written? Oh, they are stressing. Thank you again, Cat Fink, becoming a member. You've been a member before. So welcome back to Green. Good to see you. And Freedom Keeps Missing Me. Always love to pull up your profile because of your very, very good-looking dog over there. So thank you for becoming a member as well. And we are watching the Stop Cop City Rico Madness. We're just going to call this Rico Madness because it is.
In the whatever you want to call them, scenes no block, overt acts, dozens of them. We're having to deal with trying to figure out who are unindicted, unknown co-conspirators. I assume they are not able to name them either, but at least by category. Where are these people located? What role did they play? What role did the 3 defendants who were listed in these overt acts? Over and over and over again. 3 people plus all the unindicted co-conspirators, all supposedly committed every one of these 30, 40 overt acts, all dealing with the scenes blog allegations. I'm going to talk about those allegations more when I discuss some of the First Amendment problems here. So there are also numerous overt acts where they say there are known co-conspirators, but don't identify them. They've given us no information, zero information, about who the known unindicted co-conspirators are. Take a look at the overt acts beginning at 63 through somewhere in the mid-70s. You know, maybe not quite a dozen, but almost a dozen overt acts where they say the defendants, again, always putting them as a group. They rarely, sometimes, but rarely even try to distinguish between Mr. Couch, Ms. McLean, and Ms. Patterson. But they say they engaged in various criminal acts with known unindicted co-conspirators, but never provide us information about who they are. That's a special demur issue. There are, out of the 224, 225 overt acts, it is impossible to figure out what are the actual predicate racketeering acts that are the object of the conspiracy versus...
Now, it drove us nuts in the YSL trial, looking at overt act after overt act. That was like somebody posted a story on Instagram lip syncing to a song. Or somebody posted a post on Instagram with a caption that was lyrics to a song. And the state's theory was those lyrics were actually a first-hand, direct personal statement about some behavior that whoever was in the picture just engaged in. An act in furtherance of the conspiracy. If that drove you nuts, buckle up, because it's so much worse in this case.
Overt acts which are perfectly innocent conduct. There's a clear distinction in the law between what is a racketeering act, a predicate act, has to be one of the codified crimes that satisfies the requirement in the Rico statute for to be a racketeering act, and an overt act, which could be perfectly innocent conduct in any conspiracy. If you and I decide we're going to go rob a bank, the object of the conspiracy is bank robbery. It's easy to identify, bank robbery. Give the elements of the offense, you know, FDIC insured bank, and et cetera, et cetera. An overt act might be that you and I had a phone call. That's not a crime that we had a phone call, or we drove to a store and purchased a gun legally. That would be an overt act, as opposed to the racketeering act, which is the actual bank robbery itself. The overt acts in this case don't differentiate between the two. And not a single overt act, not one, in this entire indictment, 224 overt acts, not one goes through the elements of any crime. So they really all are just overt acts, and there's never an identification of a predicate act in which they have alleged essential elements of the offense. And we've cited to you the Heath case and the Sanders case. We put them in various places in our brief, in which the court has said whenever there is a compound crime, and Rico is the essence of a compound crime, you have to set forth the elements of the underlying predicate offense. Not once in this indictment. The substantive crimes that I'm not involved in obviously go through the elements of the offense. But not one time in this indictment do they say that Mr. Couch, Ms. McLean, Ms. Patterson, committed the following, or conspired to, or did in fact commit any of the following crimes, or conspired to commit any of the following crimes, and then list the elements, so we can know that we're talking about, there's the conspiracy that the Rico allegation supposedly focuses on. They conspired to commit, the use of a Molotov cocktail to assault a police officer and go through the elements of the crime. Not once in this indictment does the indictment satisfy the Keith and Sanders rule that you have to set forth the underlying predicate offense with specificity, both factually, and Sanders in particular does that, both factually and the elements of the offense. So we have problems identifying unindicted co-conspirators. We have problems with somehow throwing in co-conspirators. We have no idea whether they're going to claim that we were simply a party to a crime to some unindicted co-conspirator who committed this offense. And you're just kind of responsible on kind of a Pinkerton theory. Pinkerton, where every conspirator is responsible for what everybody else does. So we challenge the indictment for those reasons. The failure to differentiate racketeering acts from overt acts in the indictment.
Because merely reimbursing someone for money is an overt act.
There's no doubt about it, it's an overt act.
Sure.
But you got to spell out in the indictment, and I'm going to come to this shortly, how did the overt act further the goals of the conspiracy? It's not just a question of proof at trial. When I gave you the example of a bank robbery, when you and I went to the store to buy a gun, yes, that's an overt act. But did we go to the store to buy the gun in order to go rob the bank? That's what's got to be in the indictment. You got to show how the overt act materially advances the cause or somehow is related. All this says is we bought food.
Is the word you're going for next.
Sorry, I froze it. Oh no, what did I do? Why won't it let me hit the play button? Uh-oh. I went to go pull up. I think it's the audio booster extension that I use, guys. I love it. I think it's important to be able to boost the volume and actually hear what's going on. But ever since I've plugged it in, anytime I open up a YouTube channel to try to pull a link, and because I was going to share the Atlanta Community Press Collective again, because they're live right now with today's hearings. We're catching up on yesterday's, and it's not letting me switch my tab over to it, so I can't even go and press play on this. So, I'll give it a second, but I might have to refresh, which is really annoying.
Yeah.
Oh, it fixed itself.
The essence of Rico is the nexus between the racketeering acts and the enterprise. The nexus between the racketeering acts and the overall scheme here, which is completely missing. But I'm
So
not there yet to talk about the relationship.
Let's get this volume back to where it was. We're at 3526.
Evident.
We'll get the captions back, and we're back in business. And I'm going to use a different browser to pull links next time.
I'm not even there yet to talk about the relationship. The enterprise itself is shockingly ill-defined, if you will.
Hey, Rhonda, over on Twitch.
Overwrought here, but that the enterprise is defined at various places in the indictment, most notably around pages 23, 24, 25. This is all in the indictment. This is not, the introductory stuff. This is count one. They allege the enterprise beginning on page 24, actually in 25. At various parts, the enterprise is defined as a movement. Can you imagine that an enterprise is a movement? The civil rights movement would be characterized as an enterprise, according to the Attorney General's office in this case. At other times, they describe it as a coalition. I don't even know what that means. I know the word coalition means, but a coalition they describe of environmentalists, plus anarchists, plus eco-terrorists. I know what Mr. Fowler is going to say, or Ms. Dixon's going to say, or representatives from the AG's office, they're going to say, well, an enterprise can be just association in fact, and that's true. It could be a police department. It could be a governor's office. It could be anything. But somehow it has to have some defined structure. That's the United States Supreme Court case. It's the leader of the Boyle case in my brief. That the enterprise can't just be the acts themselves. You can't define the enterprise, which is the essence of RICO, racketeer, influence, corrupt organization. That's the O in RICO. There has to be an enterprise which is separate and apart from the acts that are committed.
He's literally defining RICO, spelling out the
crimes, you don't
acronym.
have RICO. And you have all kinds of venue problems at that point. You can't prove that the acts occurred in Fulton County or DeKalb County. You even have statute of limitations problems. If they're all part of the enterprise, that's why you use RICO, is to try to get them all into one case. But the enterprise here is so ill-defined and so hard to grapple with. And I'll point out that my predecessor up here at the podium, his argument's fine. I think his argument's wonderful. I think another way to characterize his argument is if the enterprise throughout was to prevent Cop City or the training center, was to prevent building on the farm, how could they allege predicate acts that occurred before either of them existed? They couldn't have been predicate acts relating to the enterprise. That, to me, is the problem with the date ranges they've used, with the earlier overt acts. If the enterprise was designed, the whole purpose of the enterprise, the existence of the enterprise, was to stop the training center and to protect the forest. Those were the essence of what put these people into one group. And yet it occurred before any of those things happened. Then the enterprise has lost all structure. Ms. Dixon says, well, we'll just prove it at trial. But they're not going to prove what they allege, because what they alleged as the enterprise had nothing to do with Rayshard Brooks. That's the May and the shooting in May in Minneapolis, George Floyd.
Rayshard Brooks was here.
Rayshard Brooks was here, and George Floyd was in Minnesota. But that's the date range they're picking on. They're saying those events is when the enterprise began, and yet they go throughout the rest of the cases.
Real quirky.
The enterprise is the forest, either the training center or the environmental problems. I just add that because of what the argument was before. To me, the date range is inconsistent with the enterprise that they've defined. That's the problem. And I raise it in our brief as a problem with the definition of an enterprise. That they are incapable of defining the enterprise with any meaningful structure or membership. Lord knows how many unindicted co-conspirators they're going to end up talking about at trial without ever identifying them, or how many known co-conspirators they're going to identify at trial, maybe for the first time, since they haven't identified them yet. I mean, there may be thousands of people who they're going to say are members of this enterprise. They may say, because they suggest it, any anarchist in the country is a member of this enterprise. California, New York, Boston, they mention all of that. It's all in their indictment, in their introductory sections about we're going to commit crimes in New York and Boston and California, and we're going to go after this enterprise.
Now I've got to take a quick segue side story here, but months and months and months ago, I don't even know if it was a tweet or if I'm just hearing it in Jim's voice. Maybe he said it in a live stream. It was before Jim, Happily Angry Lawyer, did a deep dive into Stop Cop City. He made it like a sentence into something and found out that the state, that part of the indictment was alleging that they were using anarchist means to further the anarchist enterprise. What does anarchy mean, chat? Disorder. No organization. No authority. No leader. No system. And I think it might have been a tweet, but I can just imagine Jim's laugh at him going, how are you alleging an anarchist enterprise? So this is what we're dealing with. This is what we're dealing with.
It's larger than the Vietnam protests, as far as I can tell. As far as I'm concerned, if I was protesting the Vietnam War back in the 60s, I'd be part of the enterprise, because some of the people committed crimes during those protests. What are you going to do with the NAACP? There were crimes committed. There was trespassing that was committed, there was civil disobedience that was committed, and there were even some violent acts committed. And some of those people belonged to the NAACP. You're going to say that's an enterprise? And it was all part of one Rico case because some members of the enterprise or some members of the group engaged in criminal conduct. The United States Supreme Court says you can't do that. The NAACP versus Claiborne Hardware, which we've cited in our brief. You can join a group. You can be a member of an organization or a movement or a coalition and not be guilty of a crime even if other members of the movement or coalition do commit crimes.
Basically, Mr. Deadhead.
And that's what they've done here. They've taken all these people and thrown them in an enterprise and said, here's your Rico. They're all racketeers. So that's, the argument that we make in our brief and our demur challenging the definition of an enterprise. It is too amorphous. It is indistinguishable from the criminal acts that they claim that the enterprise members committed, and it sweeps in so many innocent people who were just members of a movement or members of a coalition, and then includes, as I said, how many hundreds or thousands of unindicted co-conspirators who were, quote, anarchists or defund the police individuals, or people who protested George Floyd, the BLM, or protested the Rayshard Brooks shooting. Now we know they're all part of it because they alleged it. That's when the enterprise began. The hundreds or thousands of people who protested, police brutality in this country. So that's our enterprise allegations. I don't even know where to begin with the 25 pages that count one starts with. I do a lot of practice in federal court. There's a lot of speaking indictments there. They have introductory language, which is, in my view, offensive, but clearly tied to the crime, right? There'll be introductory language, in healthcare fraud cases that explain a little bit about the history of Medicare and how it works, and it doesn't look like a typical indictment, but it's clearly focused on the actual crime that is set forth in the ensuing counts of the indictment. I'm talking about what we call speaking indictments in federal court. And I don't know if the Attorney General's office in this case tried to learn from that. But I seriously, Judge, ask you to really carefully read pages 25 through 49 of this indictment.
The court has read the entire indictment.
Yeah, well, you ought to read it again because it's shocking. It is absolutely shocking that any prosecutor in this country would think that belongs in an indictment. I am absolutely appalled if the Attorney General's office in this state believes that it's appropriate to present to a grand jury and to present to the jury in this case, to you, to the public, to the press, 25 pages that discuss, can I quote just a few excerpts?
It's your record, Mr. Samuel.
It's their indictment.
It's your record, we're just living in it.
That I don't have to read to a jury.
They read to the grand jury. The jury has to be told what the indictment is.
I'm going to run this back. This is what I was talking about with his chess map. There is a critical reason he's going to argue that, it's typical, it's allowable, we want it, we want this indictment to be read to a jury. This little point that he makes, this little ask that he's going to set the stage for, is one of the many cards of his argument on why this indictment just needs to go. So let's run this back, let's hear it out, but keep a pin in it.
Quote just a few excerpts.
It's your record, Mr. Samuel.
It's their indictment.
Mm-hmm. That I don't have to read to a jury.
They read to the grand jury. The jury has to be told what the indictment is that the grand jury returned. They can't return an indictment or a verdict for something the grand jury didn't indict for. And the grand jury, I've never been in a trial where the jury doesn't get the indictment to deliberate in state court. But this indictment begins with talking about anarchist ideals. We're anarchists, they clearly blame my three clients as being anarchists. Anarchist ideals date back centuries. Well, that's a hell of a thing we're going to have to defend against. Is that going to be something that the jury is going to have to find beyond a reasonable doubt? Are they going to be told about the history of anarchism? Are they going to present evidence of that at trial? Violence is part of the anarchism in some anarchist beliefs. Anarchists often point to law enforcement as one of the chief violent actors in society. Violent anarchists often engage in violent activity towards law enforcement. This is totally ill-defined. We're not talking about our case. We're not talking about our case at all at this point of the indictment. But you want to know some other examples? Well, they provide them in the indictment. Examples include 2020 movement in Portland, Oregon, Seattle, Washington, the latter known as the Capitol Hill Autonomous Zone, that's in Washington. And of course, later there was the Autonomous Zone in Atlanta. This is all in the indictment. This is all what the grand jury was asked to sign their names to. And then it goes on to start quoting anonymous people, black-clad, masked people who gave speeches about defending the Atlanta forest. They put that in the indictment, as if that's relevant to anything that's going to happen at this trial. Are they going to just abandon the confrontation clause? Are they going to put in evidence of what masked people said outside the courtroom, never going to be cross-examined, about what this movement should be doing? We need to kill more policemen. A known defend the Atlanta forest was recorded complaining that there were not enough violent members in protest against the training center. That's in the first 25 pages of this indictment. Then we get compared to Mexican Zapatistas, Syrian revolutionaries. That's what we're being compared to. Kurdish revolutionaries in Afghanistan. What is this doing in an indictment in this country, in this county? We raised all these arguments to Judge Adams, with all due respect, not a word in the original order in this case said there was anything improper about that. As if we all need a pseudo-history lesson from the Attorney General about
Pseudo-history lesson.
The background of my clients, their historical predecessors. This pseudo-history that has no business in an indictment. And I don't know what you're going to do with it. You're just going to throw it out and say, we'll let the prosecution prosecute whatever they want in this case. We're going to throw out the first 25 pages, because that's clearly inappropriate, full of hearsay and confrontation clause and, as I put in my brief, events that happened centuries ago. I would really like, if I can pose a request to you, that you ask them, what in the heck was that doing in this indictment? What were those 25 pages designed to do? Who was the audience?
And nobody is stopping this man. He is goated. The attorneys aren't supposed to, like on other sides of the aisle, I mean, they can go and, hey, I'm going to introduce a piece of evidence here, look at it. But they're not supposed to make arguments directly at the other side of the attorney. That's why you go up and you make your argument to the court. And he's just flat out saying, go and ask them what they were even thinking by doing this. Oh, man.
For those 25 pages. It is, I think I've already said it was offensive. That you may be able to gather from my tone of voice. It is inexplicable to me why this indictment wasn't dismissed within weeks of it being returned with that kind of BS in it.
Oh, there's the BS factual lie.
We have devoted a substantial part of our demurrer to the First Amendment issues in this case. And they are, the indictment is just saturated with assaults on the First Amendment.
Saturated with assaults.
Throughout the indictment, from beginning to end, there are allegations of conduct which is clearly protected by the First Amendment, as if it's a crime. From the definition of the enterprise, you're an anarchist. Clearly First Amendment protected. That's like saying the enterprise in this case is full of people who belong to the NAACP. Can you imagine something like that in an indictment? They say that the enterprise in this case was comprised of people who are anarchists, who are involved in protecting the environment, people who are engaged in direct action. I did that. Did you do that? I do it on weekends now, and I go out and do the No Kings marches. Is that an enterprise? Promoting anarchist ideas? Next thing you know, they're going to say it's a crime to promote democratic ideals or Republican ideals. As if that makes you part of an enterprise and violates everybody's First Amendment rights.
I'm a little more constrained than you are by the Judicial Code of Ethics, Mr. Samuel. I'm not out on weekends.
Say it again.
I said I'm a little more constrained than you are by the Judicial Canons of Ethics. I don't go out on weekends.
Yeah, well, I know I've seen members of my colleagues in the defense out there, and they wonder, I guess we're next, right? We're out there protesting, probably trespassing, not within the bounds of where the parade is supposed to be. The overt acts that so even the scenes block, even the offensive scenes block, it's going to offend the jury if you read some of these. But the United States Supreme Court has said, unless it's an immediate incitement of riot, Brandon versus Ohio and the United States versus Scales and all the cases we read about in law school, unless you are inciting a riot, you are not guilty, even if you're calling to action, even if you're encouraging what would be described as criminal activity. It's protected unless it is an immediate incitement to riot. We've cited those cases to you. I keep telling you that because I don't want you to blame me for bringing up cases here that weren't in the brief.
I wasn't blaming Mr. Hetzel. I was commenting.
Yeah, thank you, Your Honor. We're on the same side here.
Couldn't tell by that.
Couldn't tell. Then we have the problem in the indictment, not just the First Amendment, which is part of the
I wanted to pause.
Problem, but
good question here from Kat Fink. Let me see. I thought I clicked it to pull it up, and I didn't. She says, are judges not allowed to protest when they're on personal time? So it's not like flat out prohibited that they can't go and be somewhere, but at the same time, they're supposed to avoid anything that could show a potential perceived impartiality. So, I mean, it's not like explicitly outlined, and I think it varies by state, but if being at a protest, some people will say that if you're at a protest, you must align with these things, so that could cause arguments, that could give someone enough to say, hey, we think you're impartial. So, no, there's no, you cannot be somewhere. But at the same time, I think the door is open for people to make arguments that because you were somewhere, it therefore is likely you could be impartial. So, probably just the smartest move to not put yourself in that position, which I think is really what Farmer was emphasizing.
The lack of any connection between
oh yeah, I did mean impartial. So definitely impartial with the I am in front of it. They're supposed to not risk and give the appearance that they're not impartial. And I mean partial. He's not supposed to go and look partial. Sorry.
Mentioned this earlier. The lack of any connection between these alleged overt acts and any criminal conduct in the indictment. Right? Yeah. Now, Ms. Dixon may get up and say, well, we'll just have to prove it at trial. Well, these are demurs. And the basis of these demurs is you haven't given us the information to defend, number one. And number two, you haven't constrained what the jury can do. Because if you can say, well, you woke up in the morning, and that was an overt act, well, then they can prove anything at trial.
We're screwed.
They've got to prove what's alleged here, and then what's alleged here were overt acts that furthered the ends of the conspiracy.
We all woke up today.
Food. Dozens of overt acts. You reimburse someone who bought food with no allegation anywhere in this indictment what that had to do with anything. Where was the food eaten? Where was the food brought? There's nothing. And don't let them stand up here, the AG's office, and say, well, we'll show you a trial. They're supposed to show it in the indictment. That's what an indictment does. It's the blueprint for trial. It tells you where the structures are, where the steel beams go. Well, this doesn't tell us anything. You paid for food. You paid for Deep May, which was, maybe you remember seeing some of that in the indictment. And went, what the heck is Deep May? It was a computer training class for teenagers and young adults. There were professors who came from the university, came down here and taught people how to do troubleshooting on a computer. What is that doing in this indictment? And don't let them tell you, because it's not in the indictment. Don't let them stand up here and tell you, oh, I'll tell you what's bad about that. It's XYZ. It's in the indictment if it's going to be XYZ. That's why we have indictments. That's why we have all the rules of discovery. But even that's not enough. If it's not in the indictment, then how's the jury going to know whether they're convicting them of something with which they are charged? The relationship between the racketeering acts and the enterprise is exactly what Kimbrough's all about. I think you mentioned Kimbrough when I stood up here. And that's kind of the essence of the Demurrer problem. But that's just one problem. That just deals with the relationship between the crimes and the enterprise. And Kimbrough is clearly the lead case on that point. The First Amendment, there's just no shortage of cases, including, again, in a brief, the recent Ninth Circuit case that even found the federal statute defining riot act unconstitutional because it didn't clearly and directly focus the incitement and the crime. It wasn't a close enough link. And all these Seams Block allegations in the indictment are defective for that reason. I mentioned before this whole problem of all these overt acts that just have who knows how many different members, unidentified, some known, some unknown, and I have no idea. I've been working on this case for 2 years. I've been representing the clients for time before that. You know that from the filter team problems. To say that Counts, Patterson, McClain, and a bunch of unindicted co-conspirators all did X. How am I supposed to prepare for that? All three of them did it?
True.
One of them did it? The unindicted people did it? But you're all being held responsible. You're all being held responsible because you're parties to the crime without any definition of who did what. Your Honor, the indictment in this case is, with all due respect to my colleagues, it is a disgrace. It really is. It's a disgrace. It's an assault on the First Amendment. It's an assault on the right of people to protest. It is grouping all these people together and claiming that they're all a bunch of anarchists and criminals, that they should go to prison for the racketeering act of 20 years. Some of these people, were down here for one day. They went out, they protested, and they're now being labeled racketeers. My clients never are alleged to have gone out to the forest. Not once. They are firm believers in the First Amendment. They exercise their rights under the First Amendment. They have a right to do that. You should be protecting it. The AG's office should be protecting it. And if necessary, we will be asking the jury to protect it.
Yes, Don Samuel was
But
on
you
the
should put a stop
Wolfenbarger
to this,
case.
with all due respect, Your Honor. You should say, you want to indict someone for throwing a Molotov cocktail, indict him for throwing a Molotov cocktail, and don't indict 61 people. You want to indict someone for threatening a construction company, indict him for that, if you got venue. And I ask you to grant the general demurrer, grant the special demurrer, and tell the Attorney General this is not how we conduct criminal business in this state.
Ooh. Now, notice how silent the judge was through, really the bulk of Don Samuel's argument. If you joined late, if you joined in the middle of Don Samuel giving his argument, we heard right before he got up there that this first group of co-defendants, his law firm isn't representing any of the first that are going to this first trial. But he was invited and wanted to be there to make this argument. And he cooked it up. So now we're going to get a response from the state. Pay attention to the difference from the judge. And guys, brace yourself, because I don't know if it's because I haven't watched anything with Adrienne Love since we, like 2 months ago, we were doing the rewinds on the YSL trial. I think she grates my gears more. So prepare yourself for what we're going to hear in defense of this indictment from the state.
Steak?
It really is starfish and coffee.
Judge, I think I'm gonna start.
We're gonna have to slow her
do my
down.
best to answer what was alleged and argued.
If she's too,
and yes,
If she's too fast, let me know. We're only on 1.25. We'll see. But if it's too fast, we'll go to 1. Let me know.
Still stick somewhat to an organized presentation of the argument. To do that, I'm going to start with just a key point. Excuse me. First, one of the things that is important is there was an argument about the introduction as if it was separate from count 1. I would just like to point out for the record that the introduction to this, which talks about, defines, and articulates facts pertaining to the enterprise, is actually contained in count 1. It is part of count 1. So that introduction in the body of the indictment is part of count 1. That's just a housekeeping thing. However, there's a couple
I think
of...
that was part of his complaint.
Okay.
I think he agrees with you.
Agreed.
Mr. Samuel?
Yeah.
Again, they just panned to, and I don't know if they were showing, co-defendants or just, people that are there to support the co-defendants. But if you're not watching the screen, they just panned to members in the gallery who are like, yeah, already peeping what the judge is about to have to educate the state about.
Exactly, that's the problem. If it wasn't part of count 1, who would care?
Well, and Judge, so I'll get to that. And there's a separate motion, and I think Mr. Fowler will address, there's a motion specifically about the political rhetoric. And
There are many motions
Yes,
regarding the
agreed.
political rhetoric.
And Mr. Fowler will be predominantly addressing that. I'll hit on it a little bit. But there's a lot of issues to cover. I'm going to try to hit them all. And Your Honor, the indictment in this case charges the necessary elements of conspiracy to commit RICO. And I want to just, and I know this after in response, it seems kind of anticlimactic to get up and just talk to you about the elements, but that is what we're here to establish, is whether or not the state actually alleged sufficiently the elements of the offense. And I won't go through all of exactly what is said because the court has read and studied the indictment. But count 1 does specifically set out that the individuals charged acted together, individually and as parties to a crime, or as persons concerned with commission of the crime. That is in there. They acted together with unindicted co-conspirators, together and with unindicted co-conspirators. It alleges
A mile a
the date
minute.
range. It alleges that they did so while associated with an enterprise. They unlawfully conspired and endeavored. And it alleges the enterprise as well as the pattern of racketeering. And then, Judge, and I just need, there's a lot in this indictment, which the state is very well of, but Part 1 defines the enterprise.
Very
and that's
well
where
of.
they started a lot of complaints about the enterprise. And in Part 1, it gives the overarching intent of the enterprise. It gives how the racketeering activities are connected.
It's a bad political science paper. I never thought a political science degree would help me. It clearly is the first time since graduating other than from law school. There's problems with this.
And Judge, I will get back to.
Do you see the contrast? We had defense attorney Don Samuel, almost uninterrupted. We had the one correction about, Rashard Brooks was here. Well, yeah, he was here, but I'm also talking about George Floyd. That was Minnesota. That's why I said Minnesota. Really not any interruptions that are no, but what about this? And re-steering to the question and what we're supposed to actually be arguing. We're a minute into this, and he's like, this is junk. This is garbage. There are problems here. This is an uh-oh. And uh-oh, we need the boom. So there we go. And again, guys, definitely worth looking at the screen once in a while when you hear Judge Farmer speak, because his facial expressions are amazing.
To the or what might be surplusage or unnecessary in there. But the reality of it is that as far as whether we alleged, because one of the things they are saying is that
How is Aleppo?
I'm sorry?
How is Aleppo going to go in front of the jury?
I'm sorry.
How is Aleppo going to go in front of the jury?
Doesn't know what Aleppo is.
Okay. Mr. Fowler said he'll handle that.
Okay.
All right, Judge. So to address everything, because we need to establish the record, there are two key things that are in paragraphs A and B. Two instrumental and key things. Paragraph A, the indictment alleges that each individual charged in this indictment knowingly joined the conspiracy in an attempt to prevent the training center from being built. It also alleges that the conspiracy contained a common purpose to commit two or more acts of racketeering. And then in count B, Judge, The indictment goes on as in describing the enterprise.
In paragraph B?
Yes, paragraph B, excuse me, paragraph B in the introduction, Judge.
I don't know,
It goes
Kiana.
on to articulate and allege that the defend the Atlanta Force, which is the defined enterprise, is a self-identified coalition and enterprise, and then it goes on. And what is key, though, because we do have to allege the nexus, is that paragraph B to the introductions affirmatively alleges that Defend the Atlanta Forest, this enterprise, conducts direct action designed to prevent the construction of the Atlanta Public Safety Training Center and Shadowbox Studios and promote anarchist ideas. That the self-proclaimed direct action has included vandalizing private property, arson, destruction of government property, attacks on utility workers, attacks on law enforcement, attacks on private citizens, and gun violence. It also alleges that the purpose of these actions is to prevent the construction of the Atlanta Public Safety Training Center and a movie studio, all while promoting the virulent anarchist ideals. So in the intro paragraph to the indictment, it sets out what the enterprise is, who this group is. It gives a lot of other detail, which I'll get to, but it also establishes an allegation regarding a nexus between their activity and their end goal, or the motives and the end goal of the participants in the conspiracy or the enterprise, excuse me. And so then in count two, I'm just gonna, what do we have to allege? Count two says the defendant committed overt acts to affect the object of the conspiracy, which include acts of racketeering activity as described below. The indictment then sets out 225 overt acts, some of which are predicate acts. And I'm going to talk, unfortunately, extensively about which of those are and what the law is there. But those 225 overt acts contain allegations of a multitude of racketeering activity acts. And they include influencing witnesses, assault, aggravated assault with firearms, domestic terrorism, arson, and acts and threats involving arson and felony obstruction. And like I said, I'll address some of where that is in a moment. But as the court knows, and as the defendants have argued in a lot of their motions, the test for general demurrer is, can a defendant admit all of the facts in the count, in each and every count, the entirety of the indictment, and still remain innocent? And I'm going to come back to that because Mr. Samuel didn't really address it, and I believe others will. But that is what the test is. And the state asserts that, Judge, and we can bullet out, they absolutely, a general demurrer is not going to get them there. Because if they admit each and every allegation in this indictment, they are definitely going to be guilty of multiple offenses, including Rico. Now, I'm going to go ahead, Judge. Let me see.
You notice how she said, if they admit. So we heard Brian Steele make these arguments often. We even heard it with the in response to the probation revocation that the state wanted to make against Jeffrey Williams. You know, even if we accept their allegations as true, it still doesn't constitute a violation. Or in terms of an indictment where there's crimes being alleged rather than a violation of a probation condition. Even if we concede that, yes, for the sake of argument, we did all these things, it wouldn't actually be sufficient to establish the elements of the crime. So it's insufficient. And here you see how she carefully worded that. We heard arguments that certain charges were insufficient, or that certain charges were insufficiently alleged in relation to a given defendant. Look how she words this.
Asserts that, Judge, and we can bullet out, they absolutely, a general demurrer is not going to get them there. Because if they admit each and every allegation in this indictment.
If they admit each and every allegation in this indictment. So she's kind of arguing against something that wasn't the gist of the argument.
They are definitely going to be guilty of multiple offenses, including Rico. Now, I'm going to go ahead, Judge. Let Let me see.
Pin that on the Rico, by the way.
All right. Whether the enterprise was sufficiently alleged. There is a multitude of arguments from different defendants about the structure. Mr. Samuel did mention it. And I'm going to read for the court. All right. Yes. Thompson v. State, 211, Georgia App, 887 at 890. It's a 1994 case, Judge. That is just one of the things it says, is that appellants contend that they did not have requisite knowledge of the criminal element of enterprise to sustain their RICO convictions. But none of the provisions of the RICO Act, however, requires that each and every defendant in an enterprise have full knowledge of all facts or all facets and elements of the enterprise, and that all members or actors, and all of its members or actors. An enterprise is not a criminal act itself. It is a description of the entities involved in the RICO violations and may include activities involved in illicit as well as licit activities. It is the racketeering activity, the pattern of racketeering, the predicate acts, which is illegal, not the enterprise itself. Although the enterprise may be proved by the same evidence which proves a pattern of racketeering activity. And Judge, in addition, and we'll talk about the structure in a minute, but while some structure is required, this indictment more than does that. And in paragraph 3 of the indictment, as far as how we allege this enterprise, I mean, this indictment talks about how they recruit, how they're trained, what the connection to each other is, what their motive is, what their end goal is, what different, it alleges different...
Paragraph 3?
Excuse me, I'm sorry, I'm just going... Paragraph 3 of the introduction explains how the propaganda, recruiting, providing finance, it talks about...
Just give me a page number, because paragraph 3...
He wants to look for himself.
A, B, C. Part 1. You have part 1, then you have A, B, C, D, F, and you have part 2.
Gotcha.
So, chat, we have Judge Farmer. She's saying she's referencing something. He wants to look at the page for himself, and he's actually guiding her on where she thought that she was looking. When Don Samuel was up, did the judge have to do that for anything during Don Samuel's argument? In fact, Don Samuel said, read the indictment. And the judge is like, I have read the indictment. And he goes, well, you should read it again, Judge, because it's ridiculous. But here, the judge is making her walk through it.
So,
2 seconds, Judge. I didn't say paragraph 3, and I apologize.
part 2 is the overt act.
I think, what page is that? I think it's the bottom of page 28, Judge. And let me just generally characterize it, if I can. In the introduction, which the court has studied, the indictment sets out the propaganda, the recruiting. It sets out how finances are provided, who is provided, or what entities are providing, how they shift money and pay money and what they're paying it for. It sets out how the enterprise provides support, emotional, personal, preparation for arrest. It alleges that it provides premeditation, or the enterprise premeditates committing crimes, and that all of those things are part of this enterprise. On page 33, paragraph, anyway, it specifically talks about,
Game option anyway.
in the introduction, how this enterprise is designed and does promote and agree to promote conduct.
On page 27, a local
Yes.
anarchist supporting the Stop Cop City movement
Yes.
recently wrote, any idea who that is? Any idea how these people are supposed to know who that is? Any idea? As noted by the anarchist above.
Judge, I think it's, from what I understand, it's in the discovery, right? Is it a part of scenes logs, or is it one of the? It's in the discovery.
The indictment.
Yes.
Peach milkshake, they should have had ChatGPT write this. They should have just used it. Well, thank you, Num, for being a member for 13 months.
When a court considers whether an indictment is sufficient to withstand a special demur, it is useful to remember that a purpose of the indictment, not the discovery,
Yes.
is to allow a defendant to prepare her defense intelligently.
Oh, I'm blocking the caption.
Looking at the indictment, their argument is you can't fix an indictment with 10 terabytes of discovery.
And I understand.
Look at this,
They should
look
be
at
able to
him.
look at this 109-page document and go,
Yes.
here's what we got coming at us.
Yes.
And unnamed quotes, that's problematic.
Uh-oh. Uh-oh.
And as
It's in the discovery is not a good answer, is what I'm telling you.
So, and Judge, let me just go ahead and skip to this issue. So the indictment contains things, and I think in the last trial, in Ayla King's trial, when we had
We
it,
have not had an Ayla King trial.
okay, in the previous
We
court,
have not had a trial in this case.
right? Previously,
So if you missed the beginning of this stream or missed following this case, Ayla King, she filed a speedy trial motion. Her trial was ready to go. They impaneled a jury. Jury was set, and then judge declares a mistrial. There was some issue with the members of the jury. They didn't have enough jurors, and they said, well, we're going to dismiss this juror, and then the judge declared a mistrial due to manifest necessity, because we don't have enough jurors to move forward. The defense opposed that. They didn't want the mistrial, and that's caught up in appeals right now. I think there's action on that this month. The last I remember was a September update, so we'll see. But that's what they're referencing right now when they're mentioning Ayla King.
when we prepared for trial in front of a different judge, we, with the defense, the state and the defense got together and they agreed that certain items would be redacted, and that, or certain statements, certain portions of it would be redacted. And that is, again, what the state's position is.
That's because that defendant announced ready for trial by filing speedy. These folks have not announced ready.
And the state's position, and again, Mr. Fowler is going to, do you want him to go ahead and do it instead of coming back around to it, because he is prepared to
I'm here for the
articulate
duration. Y'all do whatever order you want to.
do you want to go ahead and address the rhetoric issue? Because I think there's a separate motion, but let's go ahead and.
Here for a long time, not a good time. Yeah, I thought it was Judge Farmer that declared the mistrial.
We call it whack-a-mole way of standing up and sitting down. I think that's how the game works, but the way that the motions were filed. So I'll go ahead and get right to it. And that is that one of the things.
I just want to keep up. What motion are we on that?
I believe it's number 17 on your list.
17?
Yes.
No.
Well, it's the same motion, and this is the issue that we had. It's the same motion that they just argued, but it overlaps with 17 is what I'm telling counsel. And this was our difficulty in getting prepared for this, is that there are separate motions that are filed by certain defendants that also contain the same argument in the first motion that Mr. Samuel just argued. So that's when I say 17. It's a separate motion that was filed by Mr. Carroll that is on the list, that is also included in the argument that Mr. Samuel makes. So when I tell him 17, that's why.
Yes, Mr. Schwartz?
No, we're happy to cooperate here. Let's see how it goes.
Look, there's no question that there's a ton of overlap. And I understand that's why the previous judge may have done things the way she did. That's the way she's used to working, and that's fine for her. and I made you guys parse it out separately, that doesn't stop the fact that there is overlap between y'all's motions. So, all the housekeeping in the world isn't going to stop us from being a little bit sloppy and piecemeal. Go ahead.
Thank you, Judge. So let me start with this, which is that one of the things that was raised was the complaint that the Scenes blog did not adequately allege in the indictment that they are able to attack that. Now let me give the court a little bit of background, because the court kind of made a little face when they started talking about the Scenes blog or scenes.blogs.com, whatever it is.
Calling out a facial expression.
Right, that the Scenes blog is outrageous, because what it does as part of this conspiracy is get online, post online, hey, we just burned this stuff to the ground, we're going to do it again, and if you don't stop the training center, stop building the training center, we're going to keep building your stuff down.
And correct me if I'm wrong, Mr. Samuel, I think his argument was there's nothing in the indictment tying his folks to it. We got the metadata from their whatever. We got something. It's just these folks, along with people we don't know, or unindicted co-conspirators that are unknown, along with people we don't know. So,
Did publish.
basically, keyboard warriors.
Did publish. Yeah, not just keyboard warriors. I mean, keyboard warriors get up and argue a purpose. This went further.
So, hold on.
This
Is
went
he...
further.
We're going to run this back. He seems personally offended that the judge just said, well, they seem like keyboard warriors. Does this sound like personal offense?
Along with people we don't know. So,
Did publish.
basically, keyboard warriors.
Did publish. Yeah, not just keyboard warriors. I mean, keyboard warriors get up and argue a purpose. This went further than that. This went further than that. This went much further than that. This was a purpose. This was intended
Subpoena
to intimidate witnesses, and that's the allegation. Because if you look at it, we give them the date, we give them the internet website, we give them the contents of the post, we give them the intent of the post, and we
Do
say
websites
who did
exist
it
off the
and that
internet?
they published it. That is a lot of information. That is a lot of information to be part of an allegation. We didn't just say that they believed this. We didn't just say that they did. We give them date. We give them date. We give them contents. We give them purpose and intent. We give them motive, and we allege who did it. That is plenty to do it. And in fact, we actually allege. If you take a look at it, we allege the elements of witness intimidation in that overt act right there, which would be sufficient as an independent crime in and of itself. But this is merely an overt act, and overt acts don't require that there are crimes. So not only did we sufficiently
Has to be in furtherance of a conspiracy.
Sufficiently alleged it. And I know that
Oh my
Mr.
God.
Samuel had his caffeine this morning when he got up here. But the reality is that we did more than we needed to do when it comes to the Scenes blog sort of stuff. They claim that it's First Amendment protected. And there are First Amendment protections, and we're starting to get into a little bit of a different argument over breadth, which I will address differently, which I will address a different argument, I think, unless I need to go ahead and do it now. But obviously, you can't just say anything that you want. You can't. There are limitations to the First Amendment when it comes to what you say and and the things that you do. But I will address over breadth later on. Coming back to this, you don't have to allege how it furthered the objective. That's the primary. You don't have, or how it furthered the nexus. You don't have to allege that. You simply have to allege that it is an overt act in furtherance of the conspiracy. That's all you have to allege. That is the only language that is required, and it is listed in a separate sentence after all 225 overt acts.
You got a cite for that?
But it's back. I will get it to the court.
Go get it. I want it now. No. If it's at your table, I want it.
This is the principle that you're reading the cycle.
Yeah. But you don't have
to
to.
allege something is an overt act in furtherance of the conspiracy. You don't need a nexus between that.
You said that real
Yes,
quietly.
the overt act. As to the political rhetoric, what the court called, I think, a bad political science paper. A bad political science paper we got from the defendants themselves in the documents that we located in search warrants, in the forest and documents that we found. This is where we get it. And it's important to understand that this is how we get here in this case. And I know it reads unlike anything we've seen before. It's certainly something that I've never seen before. And let me give the court a different example of indictments that are fine when you do something like this. And I know we've talked about gang cases before. This happens in gang indictments too.
Yeah,
How do
tell us about
gangs
that.
get where they are today, leading to the violence or the fraud that they do, kind of depending on the gang. And you can do that. You can make that part of it. And I'll cite to the court believe it's, and this is a second, I'm sorry, there's a Second Circuit case, United States versus Scarpa, where the defendants unsuccessfully moved to strike 16 paragraphs captioned Introduction to All Counts, which was devoted to an overview and history of the Genovese organized crime family, which was a racketeering prosecution, and how it began, and how it got where it got, and the beliefs of the organized crime family, and how all of those tied together. In addition to that, and even if the court doesn't think that that language should be in the indictment, what's interesting is that counsel filed a demur, but I'd point the court to a...
You gonna give me a cite on that one?
I'm sorry,
It's
if I
a
did not
Second Circuit
apologize.
case.
Yes, it's 913 F. 2nd 993, page 1013. I would also, I would also give the courts United States versus Bellomo, Bellomo, 263 F. 2nd 561. And so you don't have to scroll forever. It's pages 584 through 585. Now, I know that counsel filed a demur to the indictment, but demurs are not the proper vehicle for this. The proper vehicle and the remedy that counsel needs to ask for, and the proper remedy is if there is surplusage in the first part that this court does not think needs to go to the jury, in which case it would be surplusage. The state doesn't have to prove it, would be to ask for it to be redacted. And there's a case, it's just an opinion out of the Superior Court of Cobb County, so it's not persuasive on this court, but it's well written, I will say that.
It's not persuasive? Yeah, Cobb County.
It's not binding on this court. How's that? Maybe that's the better terminology. I don't know which judge wrote that, but I hope they're not listening right now. And it is 215 Georgia Super Lexus 7038. And it's a finding in a motion for new trial. The trial counsel was not ineffective for a failure to file a non-timely demur. And they don't really talk about the timeliness of it. But it does say, in such a situations, a motion to strike the surplusage, which was never filed, rather than a dismissal of the entire count, is the appropriate remedy. And it cites to United States versus Bortlen. That's 285 F. 2nd 378. It also says that even if an indictment is lengthy and needlessly verbose, it does not mandate that it need to be dismissed. Instead, the defendant's proper recourse is to file a motion to strike surplusage from the indictment. That's United States versus Watson, 2008, U.S. District, Lexus, 59323.
There seems like it,
There are
Kimmy.
Georgia cases on that as well, where the cases have found that refusing to strike surplusage in an indictment is harmless. That's, I think it's Malov, M-A-L-L-O-V. I don't think it cut it off in Malloy. I think it's Malov, however you say it, versus the state. 293, Georgia, 350. Supreme Court dealt with an indictment charging Medicare fraud, which included language beyond the statutory language. The court noted that surplusage does not vitiate an otherwise valid indictment. And that cites to State versus Barnett, 268, Georgia Appeals 900. I would note that in the Barnett case, the court ordered that the term family violence be redacted from the indictment in the introduction. It doesn't really get into how it wasn't, but somehow it made it to the jury. And the court later found that that wasn't an issue because it wasn't something that the state had to prove. And so this allegation that the jury read it and therefore convicted because they were somehow poisoned by that or tainted by that. The court dismissed that and said no, it has to do with the evidence that goes before the court. Finally, there's another case that stands for it. I'll go ahead and give it to the court. It's Eidson versus the state, EIDSON, 262 Georgia Appeals 664. That's a 2003 case. So I give the court all of that to let the court know that even if there is any a part of that that shouldn't be in there, the proper remedy is a redaction, like Ms. Dixon was getting at when we were preparing for the Ayla King in front of Judge Adams, that the proper remedy is to redact it. Now, we never reached that for a number of reasons, but that's a totally separate issue we're not addressing today. But that would be the proper way. I would suggest to the court that it's not. That these are things that these defendants had in documentation, things that they wrote, things that they said, all of that sort of stuff. And this history lesson, while I agree with you, it's an unusual history lesson, comes from these defendants themselves. It explains how we got here and the motive for the reason that they do things. And we talk about that a little bit in the indictment when we talk about the nexus while promoting anarchist ideals. And we talk about that as part of the nexus and part of the violence and the property damage, the gun violence, the arsons, the going after civilians who are just doing their jobs. All of that sort of stuff is part and parcel of this case. And for those reasons, we believe it should go out with the jury. If it doesn't, the proper remedy is merely redaction. And I believe that I will now turn it back over to my colleague, if I may.
Okay.
Round 2.
So that's the state's response regarding
Hello to Nick in Utah.
the alleged rhetoric in the introductory paragraph, Judge. The other things that the state has argued, or the defense has argued, particularly Mr. Samuels, is that the indictment is violative of the First Amendment, and in the speech and the assembly and the right to associate. And again, we'll have other motions, so I don't want to hammer the point. It was a passing reference or in multiple of these. But first and foremost, the reality of it is, read the indictment, because it is this argument that they're making that the state, through charging this, basically said if you protest you're a racketeer, is essentially ignoring the contents of the indictment. The indictment makes it very, very clear. And quite frankly, my co-counsel and I have talked about this, we unabashedly and absolutely unequivocally agree that who you associate with, what you believe, in the quiet of your own home particularly, what you may say to somebody, that you can believe completely different, you can believe unpopular, you can believe popular. None of that, all of that I should say, is protected, 1,000%. But what you can't do is, because of those beliefs or for any other reason or some other belief, you absolutely cannot agree and join in with a group of individuals who are associated in their conduct and in the way they conduct themselves, in their beliefs, whatever it may be. They are associated in their, in fact, in the way they are conducting their affairs. You cannot agree and become a part of this enterprise, therefore, and agree that you're going to, or your co-conspirators, or somebody else in the enterprise is going to go out and commit certain crimes or acts or threats involving certain crimes. And we'll get to that in a minute. So the reality of it is,
thank you, Flesh of the Gods, being a member 13 months. Holy moly.
And become insulted and indignant. But this indictment in no way is talking about this. The indictment is charging people not with their beliefs. Their beliefs are their motive, their evidence of their motive. What they say is evidence of their intent and their motive. Absolutely. The state will say, yes, that's true. That's established law in this state and elsewhere. That speech can be used as evidence of intent and motive. But the reality of it is that while you can associate with who you want, you can protest. You can peaceably assemble, you can protest, you can do all of those things. What you can't do, shoot a police officer, hold a gun on a guy's head who simply showed up. He's just a metal scrapper, and it's in the indictment. I'm not proffering. It is in the indictment. You can't hold a gun to a guy's head because he acted upon you and hold a gun to his head with a deadly weapon, by the way, so assault. You can't shoot fireworks at EMT and firefighters. You can't burn down or try to burn down buildings. You can't burn up the police cars of the Atlanta Police Department. You can't destroy construction equipment. You can't threaten and terrorize people. You can't do those things. And if you do those things, and you then also agree with others and take the steps and commit the other elements of conspiracy to commit RICO, yes, you have committed a RICO. And it's that basic. This is not about what they believe. This is about what they did. And what they did not to the police, just to the police, not just to firefighters, not just to EMTs, not just to law-abiding citizens who work and had built companies and had contracts to have something to do with this, or in some way to build or construct or to clean or whatever, the police public safety training center. It's a mouthful. It is not, in the end, it is about the criminal actions that they took, that they agreed to took, that they knowingly understood that this group and this enterprise was going to take. It is about that, and that is what the indictment charges. Now, does the indictment charge a pattern of racketeering activity? And I need my glasses. Excuse me, Judge, I apologize. And bear with me, Judge, if you will, please. This particular issue within this case is a little bit convoluted and complex, as seems like everything to do with RICO charges. But I'm going to start, Judge, with just pointing out, and some of these cases have been cited by the defense in their motions, but Borders v. State, 270 GA, Georgia, 804, 1999, the court said, the Supreme Court of Georgia said, an indictment apprises the defendant that he may be convicted of the crime named in the indictment, of a crime included as a matter of law in the crime named, and of a crime established by the facts alleged in the indictment regarding how the crime named was committed. And an indictment is void if it fails to establish or charge a necessary element.
Tell us
Second
more.
premise, Judge, is while a defendant may desire greater detail, and this is and specifically English v. State v. English, excuse me, 276 Georgia 343 at 346. Specifically, I know that they want more detail. They want everything and anything that we're going to argue, allege, our thought processes, how we plan on and strategizing for this trial. Yes, they want that. But in English, the Supreme Court of Georgia said it is not required that the defendant get every detail of the crime. In State v. Wyatt, 295 Georgia 257 at 263, and here's I know this goes back to what you mentioned already. However, Georgia Supreme Court says instead it's not necessary that the indictment contain everything they need to know. It's not. Instead, additional details the additional detail desired may be supplemented by pretrial discovery he or she receives and any investigation their counsel conducts. And so it is interpreted and it is anticipated for the obvious reason. I don't need to keep reiterating that. It's blatant. We don't have to allege every single fact that they may want to know in the indictment.
Let me stop you right
Yes.
there, Ms. Dixie.
Yes.
Let me stop you.
Yes.
One, I'm going to cite from Kimbrough,
Uh-oh.
which cites from English.
Yes.
To be clear, we do not mean to suggest that a RICO indictment must contain pages and pages of extensive detail about the connection between the enterprise and the pattern of racketeering activity. We hold only that the sparse allegations of this indictment, which says nothing at all about the nature of the connection, are insufficient to enable the defendants to prepare for trial. And in that regard, let's talk about hey, can you conspire with people that hold guns to scrappers' heads, etc.? No, but if you're Mr. Liberto, for instance, not picking on your guy, he is named in one overt act, number 143. That on or about January 18th, 2023, he did attempt to occupy the cab force with camouflage, camping gear, and living supplies. I don't know if you've been out on Martin Luther King Jr. Drive, but there's folks out there wearing camouflage with camping gear and living supplies. So any homeless person in that park should be part of this RICO?
No, Judge, not unless there is.
Not unless there's a nexus
Exactly.
to the RICO.
Exactly.
In the allegations, Judge?
She walked right. I don't even think he was intentionally trying to trap her. She thought she understood something and walked right into him having the opportunity, the judge having the opportunity to be like, exactly, that's what you are missing in your indictment. Where is the nexus?
This was done to prevent the construction of the Atlanta Public Safety Training Center. That's what you're going to point to.
Yes. And the introduction that talks about the direct actions as well as the common purpose. And I'll go back, Judge. You're going to ask me for a cite, but let me say it and then I'll go find my cite with the court's permission. The bottom line is that one of the things we will have to prove is not that each defendant agreed ahead of time or then later committed predicate acts themselves. So what we will have to prove at trial is that the defendants knowingly joined a conspiracy that they knew had a common purpose of committing predicate acts for the goal of the enterprise in this situation. I'll just apply it to this case. And so an overt act is alleged against Mr. Liberto. That's all we have to allege in the indictment. And again, I'm not saying that the indictment couldn't be better. It could, of course,
My
in
God.
the indictment. But
No, lady.
is it sufficient to put him on notice? Yes. The indictment tells him, or tells them all, that what the DPAF, the Defendant Atlanta Force Enterprise is, where it got its beginning, some of the things that surrounded it, how it's structured, it does allege that, how it is financed, all of that. And then it says, these defendants, each individually and as a group, as parties to the commission of the crime, conspired to commit RICO, and the law will be that we have to establish, and then it alleges the predicate acts. So while I understand that he's charged in one paragraph, that's his overt act. And we allege that it's in furtherance of the conspiracy and that it's in furtherance of the purpose of the enterprise, more important. And just that's what we have to allege. Now, that's not all we have to prove, again, but that is what we have to allege. Does that answer your question?
Harvey appearance.
It's an answer.
Okay.
The answer.
And so, as far as going back to the issue of whether there's sufficient do you have other questions about the stuff I've talked about before I move on? The issue of whether there's predicate acts, and we've argued this before, Judge, but let me hit a few more points. One is there's
Few more.
Mr. Samuel didn't argue,
Have
but
you
I'll
hit
go ahead
any?
and pointed out that it is not simply just within count one that the court must look. The court must look to the entirety of the indictment along with the statute, that State v. Bear 303.
The Kimbrough case that got overturned seemed to say otherwise.
Well, so
Because that was, the Court of Appeals was like, well, if you look at the whole indictment, you get the main picture. And the Supreme Court said, no, that's not how it works.
So, Judge, for example, Sanders, which is a 2022 case, which is cited by the defense, 313 Georgia 191 200. When an indictment charges a compound felony, and maybe that's the issue. This is a conspiracy. Maybe that's the issue. I would need to look back at Kimbrough. I apologize.
Because there, Kimbrough, the Gwinnett County folks took an indictment, and they said, and they incorporated counts 5 through 20, and then 25 through, they incorporated the counts into the RICO count. And while the Court of Appeals thought that was fine, the Supreme Court said, we disagree. And I understand the state's argument is, hey, that's why we put all these overt acts into count 1.
Put them on notice, and then the elements are filled out with the remaining count, or 2 of them at least. And that's not my only argument, Judge, but Sanders, was Kimber a conspiracy case? I don't know.
Sanders a murder case.
Okay, well, so if it's a direct murder, Judge, then the distinction, then I can answer you what the distinction is. The distinction is that when an indictment charges a compound felony, that is different, or a compound crime. And are you should I just hush and let you read Sanders real quick?
No, I'm listening.
Okay. Basically, Sanders stands for the proposition, and it's well adopted, it's not in question, that when an indictment charges a compound felony, such as conspiracy, the count charging the compound offense must contain the essential elements of the predicate offense, or the indictment must contain a separate count charging the predicate offense completely, or the indictment must elsewhere allege facts showing how the compound offense was committed. And a challenge that a count in the indictment must be vacated because it did not allege the essential elements of the underlying offense is a challenge to the form. Anyway, so in this, we have to prove that the defendant conspired with one or more people to conduct or participate in the defendant Atlanta Forest through a pattern of racketeering activity, and that one or more of the co-conspirators committed overt acts in furtherance, which goes back to somewhat of what you mentioned before, Judge, and technically, we don't have to prove that each defendant or alleged actually did the overt acts. One of the co-conspirators must do an overt act. So it's to Mr. Liberto, and I'm sorry to jump around, but as to your point about Mr. Liberto earlier, we've alleged a conspiracy, so every single one of those 225 overt acts are attributable to him, because once we prove, of course, but in allegation, because he is alleged co-conspirator, and he is responsible for the overt acts of his co-conspirators. That's it. Again, we do not have to allege that an individual defendant committed racketeering acts, but rather that the defendant committed overt acts in furtherance of the conspiracy, and those acts don't even have to be crimes. So, we do not have to allege or prove that the defendant agreed to that he himself will commit predicate acts. And I'm going to cite, it's 2025, Jordan versus State, 375, and Judge, I have some of these cases if you want copies, but 375 Georgia App 552 2025 case, that is citing the Cotman case. And Jordan says a person may be found guilty of RICO conspiracy if they knowingly and willfully join a conspiracy which itself contains a common plan or purpose to commit 2 or more predicate acts. They don't actually have to intend to commit the acts themselves. Now, as to whether we alleged predicate acts, one of the most important aspects of the RICO statute that I think has been missed, and not just by these defendants, but a lot, is that the plain reading of racketeering activity under 1314.3 and its many subdivisions leads to the conclusion that has been adopted by the Supreme Court of Georgia.
1614.
Excuse me. I'm probably going to do some things like that. I apologize, Judge. 1614.3. That not every act of racketeering activity actually has to be a full and self-contained crime. And so as the court knows, but I'm going to go through it for the record, that we have to allege a pattern of racketeering activity. And under 1614.3 subsection 4, we have to allege either at least two acts of racketeering activity in furtherance of one or more incidents with the proper relationship, and I'll just abbreviate it that way. Or we have to allege that they engaged in one or more acts of domestic terrorism. And then racketeering activity, so it's one of two ways. Either it's at least two acts of racketeering activity, or at least one count or at least one accusation of domestic terrorism. So when you come to it, how is racketeering activity? And this is where it gets interesting, Judge. Yes, everybody knows about 1614.3.5a. Everybody is aware of it. It says that racketeering activity includes to commit, attempt to commit, to solicit, coerce, intimidate another person. And then it goes on to say, gives, I think it's 43 categorical or categories of criminal offenses. So for example, assault, and then it'd be any of those assaults under that article and chapter. But that's one way. B is the second way. So 1614.3.5b says that racketeering activity shall also mean any act or threat involving ... So murder, robbery, things of that nature, arson, and felony obstruction of justice is arson and obstruction of justice, which is punishable by imprisonment for more than 1 year. So with the plain reading of that means that if we allege in our indictment domestic terrorism one or more time, two, adequately, two, predicate acts under 5A, which would involve the criminal offenses, or three, acts involving arson or felony arson or felony obstruction of justice, that if within the entirety of our indictment we have done that, then we survive the mirror. And I'm going to give you the case that specifically says that 5B includes not only, or adds to the list of criminal offenses by saying acts or threat involving. And that is in 2005, it's Dorsey v. State, 279 GA 534 at 540 through 541. And in that particular case, Judge, the state had alleged multiple different paragraphs of predicate acts for the racketeering activity. One of those was, I think, paragraph 5. It doesn't really matter. They had a paragraph, and in that paragraph, they alleged that defendant, let me get it right, committed acts involving murder, which is one of the allowed crimes. And then it says, in that he met with 4 co-conspirators for purpose of planning, that the conspirators conducted surveillance and obtained firearms, that Dorsey covered for Cuffey and that when Cuffey was questioned by law enforcement, and that Dorsey employed co-conspirators in the sheriff's office as consideration for their participation, and, lastly, that he discussed alibis. None of those were criminal offenses. And so what the court in Dorsey said was that, and specifically, that Dorsey argued that those were not sufficient because they didn't establish all of the elements of a criminal offense, and the court rejected that and pointed out that 3.5b includes acts involving. And in saying so, they actually reference and cite to
Her inflection is crazy.
a case, United States versus Miller. It's in the other case, which says, interpreting the federal RICO statute, defines racketeering activities as encompassing any act involving murder to include an act which need not be
Racketeering
murder,
is count
so long
one.
as it directly concerns murder. All that to be said, under this acts involving, all right, we do not have to allege that the defendant or defendants committed an act of arson.
Guys, I made a shirt. I made a t-shirt.
We do
Oh,
not
it's really
have
tiny.
to allege
This is the
as a
indictment could be
separate
better.
fully set out, accused charge that they committed felony obstruction. Under B, according to the Supreme Court and according to a plain reading of the statute, which differentiates itself from A, we have to allege acts or threats involving a narrow amount, narrow classification of charges, but one of those charges is arson and another is obstruction, with the modifier that it has to be felony. So felony arson and felony obstruction. So, again, I cite to that case as adopting that practical and plain reading of the statute. And so those are the three ways we can do it. And so going back to what I indicated earlier, Judge, bottom line is you have to read, the question becomes, is within count one or within count one referencing other counts, or basically are there facts anywhere in the indictment pulled together that can establish the racketeering activity? And my assertion is that we have done all three, and just for the record. All right, under 4B, under 4B, if we sufficiently allege domestic terrorism, one-time, done deal, pattern of racketeering activity is alleged. You don't have to allege, unlike the other issues, you don't have to allege multiple incidences of domestic terrorism activity. You have to set it out fully and completely, but only one time. And the indictment does so. Section 2, paragraph 152 of count 1, in the overt acts that include predicate acts by the language of the indictment, expressly stated, states that on or about January 21st, 2023, Naja Gear, Madeline Fiola, Emily Murphy, Francis Carroll, and Ivan Ferguson joined the Night of Rage in Atlanta, caused arson and property damage, and thereby committed the offense of domestic terrorism. Now, obviously, as far as domestic terrorism, that doesn't lay out the elements of domestic terrorism. The state's not saying that. However,
slow down, Ms.
yes,
Dixon.
I'm going too fast.
Catch your breath.
I know you're going too fast for Mr.
Yes,
Forehead.
I apologize.
So you're going to 162,
Yes. Oh, 152.
150.
You're just hitting her glasses.
Not to put Mr. Liberto on the spot here. But is it going to make a difference that post dates his one day in the park?
Very specific.
I'm sorry, Judge. I apologize. I can't.
Okay, Mr. Liberto is alleged to have camped on January 18th of 2023.
Okay.
This predicate act of which you speak in paragraph 152 occurred on January 21st,
That Morse code.
after Mr. Liberto went camping in DeKalb County.
Right. It's an ongoing, continuous litany of activity. And so I see what you're...
So how does that tie him in? You got to show how that ties him in, because if somebody goes camping and then 3 weeks later somebody burns something down,
So it's really a
so if I go by an Italian ice and a mafia-sponsored parade, I'm cooked.
no,
Oh,
no,
Okay?
absolutely not. If there is evidence, however, that beyond what overt act, again, we don't even have
Exactly.
to allege an overt act, but we
I paid $1 for that Italian ice.
then that might have been a crime, because that sounds really cheap, Judge.
he's making this I paid $1 comment for a specific reason.
You know what they say about, if it's too good to
It
be
was a
true.
mafia-sponsored event.
Okay, but if it's too good to be true, anyway.
Amanda, we can be twins. Thank you, Amanda.
So bottom line is, Judge, no, obviously, because there's no evidence of other, well, if that's all you did, okay?
How's he on notice? That's his point.
Because
How am I on notice that camping furthered this conspiracy?
Because he's alleged to have. He's alleged, and it's explained, and now given, there is not a specific for each of these 62 argument or about how the state knows what it knows about Mr. Liberto, for example. But it accuses and alleges, which is what we're here for, and it says, Mr. Liberto, we are telling you to be on notice that you are accused of conspiring to do these things and to commit this Rico Act. And then, of course, how Rico is defined, that comes from the statute, it comes from case law. But maybe this answers your question, I'm not sure. The bottom line is, Judge, he doesn't have to have agreed specifically to certain criminal acts. He has to have agreed that predicate offenses or acts, not offenses, not just offenses, predicate acts.
She caught herself there.
Will be committed, and these words get so overlapping, but that predicate acts will be committed in pursuit of the purpose of the enterprise. At least two.
This reminds me, so when I was in school, you had to either be in choir or chorus or whatever, or band. You had to do one or the other for your music credits. And I remember in chorus, our choir teacher would every day drill into our heads, you need to enunciate. Because when you're singing and multiple voices are singing together, if you aren't enunciating, going out of your way to enunciate, the consonants get lost. It just becomes like musical blather without the consonants being enunciated. I just think of that every time she says a word, like purpose, pursuit.
Will be committed. He has to do so knowingly. And the conspiracy itself, or the enterprise itself, has to have a common purpose. And that's what we have to prove. So while one overt act is alleged in the indictment, that is not the extent to which the state has accused him of being involved. The state has accused him of conspiring to commit Rico, which 2 or more acts, it's in the indictment. So that's one act. Let me keep going, which is after the fact, but it is a continuing enterprise. And I understand what you're arguing. Your argument is, okay, well, if
I'm not arguing, I'm just pointing out facts.
Your point is, if he was in
God.
But that's not the only, but again, it's not the only incident that he's aware of, or he was involved in, or that we have information on.
How does he know that from looking at the indictment?
Because he's accused with conspiring to commit, and that he knows at least 2 predicate acts occurred, or conspiring to commit 2 predicate acts, basically. And so that's how he knows, because he's charged with it.
Go on.
Go on.
Again, Judge, he doesn't.
Hey. You laugh, you leave. It's real simple. It's
We
real
can't help
simple.
it, Judge.
Sheriff, next person that makes a noise, gone. You want to get out of the
Unfair.
hall? Fine. We're not doing that in here. A little decorum, folks.
And people can giggle, and people can laugh, and
Not in my room.
They can. Bottom line is, Judge, we don't have to even we don't have to allege or prove that he committed an overt act. We don't have to allege or prove that he committed a predicate act. We have to allege and prove what is alleged, which are the essential elements of conspiracy.
You don't have to prove that he committed an overt act?
But he or one of his co-conspirators. Yeah.
So you don't have to prove he did anything?
No, well, I mean, not an overt act. No, we do not have to allege or prove he committed it. It's he or any of his co-conspirators. That's the law on this conspiracy.
You don't have to prove that Spencer Libero did anything? I think that's a good time for lunch. That's a good time for lunch.
No,
See y'all at
predicate
1
act. Let me correct that predicate act.
Sure.
Panic.
After she talks to me.
A quick summary of the state's argument. So they go for lunch. The judge is like, what? You don't have to, what? We're going to lunch. We're going to lunch. Right after he says, court, you can't laugh at this mess. You can't laugh at this mess. So he's giving the gallery a break so they can go outside and laugh. They came back after lunch. There was a part 2. Again, they are live right now. Let me give you the link again to Atlanta Community Press Collective on YouTube if you want to watch the live. We're gonna get caught up, you guys. I'm entrenched in this. I can't look away. I'm rubbernecking the car wreck. I'm looking over. I can't look away. So we're going all in. Again, because of my schedule, I'm always gonna say go check this out. It looks like Atlanta Community Press Collective. They were at 800 subs yesterday. They're at 900 today. It'd be cool to get them into those ranks where they can start monetizing and earning from the coverage that they're doing on YouTube. I'm also always going to suggest Jim, Happily Angry Lawyer, I think is also going to be entrenched in watching this train wreck proceed. But when I can go live and we can talk about it together, even if I've watched it already, I'm hooked. I'm hooked. But if you do want to watch in real time, we're catching up still. I'll put ATL Press Collective. And then Jim also said he was going to go live today. He's on the West Coast, and I don't know if he's up and about quite yet, because I think he was up at like 6 in the morning tweeting. So let's get to part 2 of yesterday's. Okay. And it like seems to start right in the middle. We'll figure it out. Get this boosted. Again, the extension and kernel audits in the chat is who initially recommended this months ago. It's been a lifesaver. It's Enhancer for YouTube. It's a browser extension. It gives you this little thing here where you can boost the volume up. Really helpful. This isn't that bad. But some other cases, some other stuff we've watched, we wouldn't be able to hear without it. So super awesome. I don't know if there's an equivalent for mobile devices. Sorry. But it's really, really nice to have when the court is quiet. We'll try to kick this up to 125 again if it ends up being too fast. She was told to slow down. We'll see. Oh, that's quite loud.
In May of 2020.
There we go. And again, sorry, this second part starts here.
Our argument.
And that is in the indictment.
Yes.
That is the stated purpose of this corrupt organization.
So yes, Judge, yes. And
So why are we predating that? Because they could not have been Shadowbox Studio, Public Safety Training Center, not a thing in May of 2020.
so
And like I said, I hate to backpedal.
No, you're fine. Of course you're fine. Excuse me, Judge. No.
My job is to be curious.
My argument regarding that is that the enterprise, which had this goal of this trifold goal, and that the evidence will bear it out, but that the argument is that the conspiracy, notably, Judge, that the conspiracy, okay, existed from those dates. And let me make sure I've got I want to get technically accurate. Excuse me. Here we go. Where is it? Okay. So that they were associated with an enterprise, and you're, I think, saying how can the enterprise with this purpose exist before the public announcement before. What I will tell you is that the date range of that conspiracy is alleged based on the information that we obtained through evidence that we received and during the course of the investigation, whether it be statements of an alleged co-conspirator, which were not testimonial, so don't invoke the confrontation clause, but statements of a non-indicted or statements of a masked co-conspirator, we'll say it that way. We believe we know who it was, but regardless, statements of a masked co-conspirator. And again, Judge, under that logic, under their argument, the Network for Strong Communities, which was a core part of this whole thing, I mean, the record shows that they were created, incorporated in August of 2020. So my argument is that while the indictment alleges a date range, it then follows up with specific dates that actions occurred. And so as far as notice and all the case law they cited about notice, every single act charged as either predicate act or overt act has a specific date. So none of those cases are applicable to us.
Is Atlanta Forest the corrupt organization, or is Network for Strong Communities the corrupt organization?
Atlanta in the indictment, it's defending the Atlanta Forest. Network for Strong Communities is part and parcel of it. It gets very convoluted, but it's part and parcel.
I think that's exactly what the defense is telling me, and they're asking me. It's way too convoluted. I look at it, I can't see it.
Well, I'm not saying that
And the point is, if it's too convoluted, you're not being clear. And she just acknowledged it wasn't clear in the indictment. Well, it's Atlanta Forest in the indictment, but that's part and parcel part of it now that I'm arguing orally. But you're supposed to put everything in the indictment so the defense knows what they're defending against. Are you going to present this as some type of hybrid enterprise? We need to know. We need to be on notice for this so we can strategize and argue that. If you're going to argue that it's just defend Atlanta Forest that's the enterprise, but there was activity happening for another organization for other means and purposes, criminal or not, then the defense can say, well, you have the wrong enterprise. Whether or not it's criminal offenses or not, or that these overt acts are in the furtherance of anything, you have to allege the correct enterprise that the thing is supposed to be furthering.
indictment can't be seen. I'm saying that the facts of the case are convoluted because, I mean, that's part of the intent. I won't get into that, but it is. We alleged the beginning of the conspiracy on that date based on evidence we received to include a unindicted co-conspirator's statement. That is part of why we included the date that we included. The specific overt acts are then alleged, and we're going to be restricted to allegations of those overt acts. However, Judge, I mean, under anybody's rational, just common sense approach, before the first overt act, an enterprise can exist. I mean, that's just common sense. I mean, it can exist before they first take an act or before they take an act that we charge. And so, yes, we have alleged that the enterprise and the conspiracy.
I agree with you.
Yes, okay.
An organization can exist.
Yes.
Now let's talk about purpose. Okay?
Okay.
It can exist.
Got it.
They could have, Atlanta Force could have been in existence since, I don't know, 1900. But Public Safety Training Center didn't come to existence then. I mean, how are they acting with a purpose for something that doesn't exist?
Judge,
Or
it can be in the planning stages of it. They may know it's coming. I mean, and probably
You need
Ms.
to
Fowler
allege
may
that.
speak better to this, but
well, I mean, he was up here saying, hey, that's when they heard about it,
Right.
and that's when Mr. Hetzel was like, okay, fantastic, let's hear it. Where is that in the indictment? Mr. Hetzel, was I wrong there?
clarify, I'm asking for the state to produce a witness or some other evidence that somehow gets us to May 25, 2020, instead of the first overt act listed, which is July 2020, instead of August 2020, when some organization incorporates, instead of September 2021, when the land swap happened.
Anyway,
So Judge,
a simple
my
ask.
first intention to all of that is, in order for us to need to put a witness on to explain why it can't be further delineated and narrowed, it has to be determined that it is insufficiently broad. And again, this is an indictment. It is about what the accusation is. I've explained to the court why we accused it the way we did, alleged it the way we did, which I don't think is even necessary. I mean, it is not an overbroad. We have to allege a pattern. Again, all of those cases regarding, and I haven't read the one that he provided earlier. I have not read that. But I did read a short blurb. The child-involved child crime cases, Judge, literally part of the rationale behind that is that a defendant charged with rape or incest, it's not permissible for the state to just generally allege sort of this pattern of conduct, and that's not fair. That is the exact opposite of what the law requires for us to allege and prove RICO. RICO requires us to allege a time frame in which the conspiracy exists, because we must allege the pattern of racketeering activity. As to that one case whose name I do not remember, I pulled it up, I didn't read it in full, but I can tell you in the holding section, one of the things it said was, it's not valid because the 43 predicate acts, or the 43 separate acts, were not, there was no date given. That's the exact opposite of what we've got here. So we have a date range that we say in our indictment. I'm not saying what's going to happen at trial, but we have accused these defendants of participating and conspiring in this enterprise, or while associated with this enterprise, in RICO activity between these two dates, and then allege specific instances of overt act and predicate acts with specificity and dates. In that scenario, we don't get to put on a witness because they haven't satisfied the burden that we would need to narrow it. And that's the state's position with regard to that. Now, moving back, and I understand why it was a little discombobulating when I started back in on the indictment. However, let me go back, Judge, and I was before the break talking about how the indictment alleges racketeering activity, or a pattern of racketeering activity, and I started off by saying all we have to do is sufficiently allege a single incident of domestic terrorism to establish a pattern of racketeering activity. In section 2 of our indictment, in paragraph 152 of count 1, we allege that Guy, on January 21st, 2023, Naja Geyer, Madeline Fiola, Emily Murphy, Francis Carroll, and Ivan Ferguson did join the Night of Rage in Atlanta and caused arson and property damage, and thereby committed the offense of domestic terrorism. However, going back to the Sanders case, Judge, which talked about compound crimes, conspiracy being a compound crime, that you can look to the other counts for the rest of the details to support your predicate act offense and whether they've been put on notice. And corresponding count 2 of the indictment further sets forth all of the elements of that exact same domestic terrorism. It relates back to it, it follows the language, same date, same individuals involved. So there and then, under the law, whether people think it should be enough or not, but under the law, we have alleged that as an overt act, these participants, these 4 on this date, participated in domestic terrorism, and then in count 2, as allowed by Sanders, and a lot of other cases too, but Sanders in 2022, then we then supply the necessary factual specificity, or alleged specifications or specificity to the domestic terrorism and how they committed it. So that's one. So right there, Judge, we've established a pattern of racketeering activity. Then you get to, did we establish a pattern of racketeering activity under 1614.3.4a, which is the subsection that says at least 2 acts of racketeering activity in furtherance of one or more incidents, schemes, or transactions that have the same or similar intents, results, accomplices, victims, or methods of commission, or otherwise are interpreted by this, are interrelated by distinguishing characteristics
Yes,
and are
Peter.
not isolated incidents. And then it goes on to give you the time boundaries of when those can occur. Racketeering activity then gets defined. So what are incidents of racketeering activity? And this is where I was talking earlier. Racketeering activity includes 2 different things. One is the commission, attempt to commission, etc., of enumerated offenses, and it's like through 43. And it's not just 43 offenses, it's 43 categories of offenses. So, for example, assault under the chapter and article, and so it would be any of those assaults. But 43 categories of offenses. Or B, which is what I was talking to you earlier about.
B's in the chat.
The fact that if the court, the indictment can allege acts or threats involving felony arson and felony obstruction of justice. And so if we have then, within the entirety of this indictment, alleged either, we have already argued that we allege domestic terrorism,
B
so
for
we're done with
blurbing.
pattern of racketeering activity, however, if the court thinks otherwise, then have we done it through one of those 43 categorical crimes under A, which would have to include all of the elements of those underlying offenses because they are, in fact, the commission of an offense. Or under B, which is allegations of acts or threats involving the arson and the felony obstruction. So, and I quoted that case to you already, Judge, so we won't reiterate. So going to the specifics, and I'm going to start with A, which is the racketeering activity that is in and of itself a crime. And the state asserts to the court that the indictment in its entirety sets out multiple allegations that are sufficient to establish an assault. And this goes back to the beginning, Judge. I quoted, I think it's still Sanders. Yes, Sanders v. State, where it says the indictment must, one of the 3 ways is if the indictment alleges elsewhere facts showing how the compound offense was committed. So one of those 3 ways, either in count 1, setting out all the elements, and the elements are all set out in in the entirety of the indictment, or we've alleged sufficient facts to establish the elements essentially of the compound crime. So starting with assault, the state would assert to the court that the indictment in its recitation of 225 overt acts that specifically the indictment says include racketeering activities, that we have alleged assault in paragraph 72, in which it gives a certain date, says specific individuals, Abigail Stapyak, Philip Flagg, Madeline Kodak, Brooke Quartermont, Mariana Hoyt Lane, and Anna Gypsy Lee, and 2 unindicted co-conspirators did throw Molotov cocktails and glass bottles at police officers. 2, the state asserts that we have alleged an aggravated assault in paragraph 110. On November 8, 2022, Abigail Stapyak did provide information to a masked unknown individual that held Richard Porter, a metal scraper, at gunpoint in Increasement Park, thus committing aggravated assault against Richard Porter. The 3rd example of an assault is paragraph 116 on...
She provided information.
Information to the person, yes.
What time of day it was, what kind of information? She provided information to somebody committing a crime.
To somebody who held him at gunpoint, yes.
Okay. And what kind of information was that?
It's not alleged in the indictment. I mean, I can tell you that, and it's in the discovery, but it's not alleged in the indictment.
So how is Ms. Skapek supposed to look at number 110 and go, I'm not prepared for that? I provide information.
I mean, I think she has to know what she needs to defend against, and I think it puts her on notice that what she needs to defend against.
Provide
And
information to wit, the information provided to an unknown individual.
it could be more specific. I'm not arguing with you about that. Our contention is that it is sufficient to put them on notice and sufficient to plead a predicate act.
You allege it as an overt act, not a predicate act.
Well, it's both, and it's alleged as both. It's, I mean,
This is an overt act in furtherance of conspiracy.
yes, but at the heading,
Thus committing an aggravated assault?
yes, but at the forefront of those 225 paragraphs, in part 2, it says, the defendant committed overt acts to affect the object of the conspiracy, which include acts of racketeering activity as described below.
Then you're going back to paragraph B. Is that where you are?
Part 2, no, it's the beginning. Excuse me, Judge. Let me pull up the indictment real quick so I can make sure that I'm directing you to the right portion. Do you have the indictment pulled up?
I've got it pulled up. Part 2 of the indictment?
It should be right above the beginning of the recitation of the 225. This is part 2.
Page 49.
Thank you.
The defendants committed overt acts to affect the object of the conspiracy, which includes sets of racketeering activity as described below. Acts of racketeering activity as described below.
Yes.
The zoom in.
Okay.
Okay.
And I think you're getting to something that will be covered in a later argument. So, Judge, then we move to, I think I left off with paragraph 116 on December 13th, 2022. And I'm going to just kind of abbreviate instead of exactly quoting, but Carroll, Tilbury, Olson, all named defendants in this indictment, did throw rocks, a bottle, shoot fireworks at firefighters and EMTs. Paragraph 121 is another simple assault. December 13th, 2022, Serena Hotel did cut a rope in an attempt to cause an arborist to fall during climbing. This is an overt act in furtherance of the conspiracy, which is at the end of every one of them because it's required for us to allege that they overt acts are in furtherance. Fifth incident of assault or aggravated assault alleged in the indictment is paragraph 124. December 14th, 2022, Ariel Ebaugh did approach to cab law enforcement with a rifle, knives, and a pistol in a threatening manner in an attempt to intimidate the officers, thus committing an aggravated assault against cab law enforcement. So right there, based on that, our allegation or our assertion to the court is that first and foremost, we established domestic terrorism. We supplied the necessary elements and details in count 2, which is completely permissible under the law of the state, and because it's a compound crime, and that we have also in these predicate acts set forth the necessary facts to allege either assault or aggravated assault. Then judge number 27, or the 27th, because it's not number 27, it's like XXLL, whatever it may be. The 27th category or list of offenses under 5A that can be alleged as racketeering activity is influencing a witness. And the elements of that are, it shall be unlawful for any person knowingly to use intimidation, physical force, or threats to persuade another person by means of corruption or attempt to do so, with the intent, B, to cause or induce any person to withhold testimony or a record, document, or other object from an official proceeding. And that's obviously not the entire statute, Judge. I have sort of culled it down to include only the portions of the statute that we assert are relevant to our indictment. And so the state asserts to the court that the indictment contains 41 separate allegations of co-conspirators using threats with the intent to cause and induce construction officials to withhold records, documents, or testimony in official proceeding. Those paragraphs are 5 and 6, 8 through 11, 13 through 15, 17 through 24, 32 through 37, 71, 103, 125, 127, 128, 130, 133, 134, 149 through 151, and 158 through 164. Each one of those paragraphs sets out every element necessary to prove and charge influencing a witness under the section of the statute that I read to you earlier. I know that there was an argument from somebody, I'll just go ahead and address it, that we did not allege that there was, and there in fact wasn't a pending proceeding, and I'll provide the statute to you, but the statute just directly states that there is no burden to prove, much less plead, that there is an ongoing pending proceeding. So based on that, we allege those things, Judge, according to the state, we have alleged domestic terrorism, so check off pattern of activity being alleged, pattern of racketeering activity being alleged. We have alleged multiple counts, I think it was 20-something counts of assault, either aggravated or simple, but then we alleged 41 distinct allegations of influencing a witness in the paragraphs that I referenced to you before. So those are our 5A offenses in which we assert that we have met the burden through Sanders, and the Sanders standard, I don't remember if it's Sanders and state, the Sanders standard that all of the necessary elements that are provided to the defense through either recitation of the statutory language, or recitation of facts that would support the elements of the offense or prove the elements of the offense. However, we're not limited to those 5A offenses because of subsection 5B. And again, I read to you from the case, it is a direct Supreme Court of Georgia case that says 5B, racketeering activity, it does not equal a criminal offense, rejects that notion and says it's different. You don't have to prove that they committed murder, arson, obstruction. Those things are under 5A. But it provides a different and additional way for the state to allege and later prove racketeering activity through acts or threats involving felony arson and felony obstruction. So where do we allege those, Judge? Our contention is that acts or threats involving arson are alleged in paragraph 1, where we allege that a Molotov cocktail was thrown at Georgia State Patrol headquarters, and that is an act or a threat involving arson. Not that we've laid out the offense of arson, but it's that we have alleged an act or a threat involving arson. Paragraph 130 is an act or threat involving arson when it alleges on or about January 1st, 2023, Cox, McLean, and Patterson, and again, I'm summarizing a little bit. They published these scenes blogs posts claiming responsibility for an arson of a bank and thereby made threats against construction officials committed and influencing a witness, the rest of that paragraph. So we've alleged acts involving an arson when they used, threats. We've alleged threats involving arson when we allege that those three individuals made a post and claimed credit for an arson and then used that arson to threaten and intimidate witnesses. That's our allegation.
I'm looking at 161093, influencing witnesses. Person who, with intent to deter a witness from testifying freely, fully, truthfully to any matter pending in any court,
Yes.
in any administrative proceeding, or before a grand jury, communicates directly or indirectly to such witness any threat of injury or damage to the person, property, or employment of the witness, or to the person, property, or employment of any relative or associate of the witness, or who offers or delivers any benefit, reward. First part was the stick, now they get to the carrot part of it. Okay, and you're saying publishing this stuff was an indirect communication.
Judge, I'm saying that it fits under, if you will give me 2 seconds.
Court reporter gets a break.
There it is. That it fits under, it shall be unlawful for any person to knowingly use intimidation, physical force, or threats to persuade another person by means of corruption or to attempt to do so, or to engage in misleading conduct towards another person with the intent to influence, delay, or prevent the testimony of the person in an official proceeding. B, and this is what we've alleged, to cause or induce any person to withhold testimony or a record, document, or other object from an official proceeding. And official proceeding is not just is defined, and it is not limited to court cases. I'm trying to find, there it is. In 3A, it includes hearing or trial conducted by the court of the state or its, sorry, I'll just read. Any hearing or trial conducted by a court of the state or its political subdivisions, a grand jury, or an agency of the executive, legislative, or judicial branches of government of this state or its political subdivisions and authorities. So it does not have to be a court case. If there is a hearing in an administrative hearing that falls within those branches of government, and that type of hearing is defined in that statute, and somebody does something and threatens with the requisite intent, and that's what we've alleged in this.
I'm going to pause now that she sort of stopped her argument. So there's actually a local case involving the death of a 3-year-old. Mom is on trial, Erica Dotson. And I just got a ping that there was a mistrial declared. And the last thing I knew is she was on the stand herself. All right, no, I don't see any current videos, so I guess nobody's streaming that case. I wonder what happened. So, and I don't know if she looks familiar. I'll switch over to a picture of her really quickly. But yeah, this is all that's known to me, is that a judge has declared a mistrial in the murder of a 3-year-old boy over a discovery violation involving an interview. So you guys know, what do we say? It's the prosecution messing up their own case. Discovery violation now resulting in a mistrial. So I can't wait to get more info on that. We'll keep looking at that, you guys. But you don't hear that happening every day, that a judge grants the mistrial.
Okay.
So we've alleged that's one of the ways, but that they use these threats to intimidate and influence construction officials from doing the elements of the crime. I'm not going to read it all again. To prevent them from providing documents, etc., in an official proceeding. Now, let's see, where was it? All right. Yes, acts involving arson. Paragraph 152, on or about January 21st, 2023, Geyer, Fiola, Murphy, Carroll, and Ferguson, and this is that paragraph we read earlier, did join the night of rage, and caused arson and property damage, and thereby committed the offense of domestic terrorism. So, at a minimum, that is not only directing them to the count 2, but it is also an act involving arson. Paragraph 153, on or about January 21st of 2023, Ivan Ferguson and Naja Geyer rode together in the night of rage inside a truck with a gas can and camping gear and a climbing gear. I withdraw that, Judge. I don't think it's clear enough as I read it. I don't think that's clearly enough that it is involving. Now, it is later charged as part of the arson, and so you can argue that it is that paragraph in conjunction with count 2 puts them on notice that it is a act involving arson. However, I will go with count 2 as a definite way of putting them on notice and providing them with all the necessary details that they've been charged with an act involving arson.
It's not 153 and 154 the exact same sentence?
Let me check, Judge. Yes, I do believe there's one that's repeated. I do believe there's a duplicate, Judge. Let me check, though, if you don't mind. I may have just a moment. 153. I think that's correct. I think I noticed that. They're duplicative, Judge, so we can agree that one of those would be direct or struck. All right, and then, Judge, in paragraph 155, on the same day, Carroll is alleged to possess a lighter and accelerant while attempting to break into 191 Peachtree Street in Atlanta, and did commit the offense of domestic terrorism, referring to count 2, of course, where all the rest of the details. However, that plus count 2 definitely puts him on notice, because count 2 explains that he was doing so in pursuit or while attempting to commit an arson, so that puts him on notice that he is thereby charged with a predicate act involving arson. Number 6, in 24 different times, paragraphs 194 through 217 allege that the different co-conspirators, so everyone is, it doesn't allege that vaguely, it says on or about March 5th, 2023, so-and-so, and so there's 62, or so, not 62, it's however many were there. Each one of the defendants are then named, and it says they did join an organized mob and succeed in overwhelming police force, thereby aiding and abetting in the offense of arson and domestic terrorism in an attempt to occupy the force and prevent the building of Atlanta Public Safety Training Center. That each one of those paragraphs, and then it also has the overt act language.
The arson and domestic terrorism that happened back in January?
No.
Okay.
No, sir. It's a separate date. It's a separate incident.
But we're talking about January.
You don't need me to get into all the facts. This was the March 5th incident where they burned a bunch of stuff and set things on fire. Anyway, so that specific allegation definitely 24 separate times against 24 separate defendants alleges that each one of those 24 co-conspirators, as alleged in the indictment, committed acts involving arson. So those are so that's 29, I believe, Judge, and I'm not the best at math, but 29 acts involving arson have been alleged. Then we get to acts or threats involving felony obstruction. We've got 27 of those alleged, Judge. That's paragraphs 119 through 121, and that's December 13th. Did issue a call to action on Instagram for forest defenders to deliver a physical response to prevent her arrest. So we allege that is sufficient to put them on notice that they are charged with a act or a threat involving felony obstruction. 120, it's the same date, same person, attached a wooden board with metal spikes to a treehouse to prevent law enforcement from reaching the treehouse. 121, the same person on the same date, cut a rope in an attempt to cause an arborist to fall during climbing. And then in 24 times, paragraphs 170 through 193, similar to the other ones I referenced with the arson, but these paragraphs say and allege that on or about March 5th, and then there's 24 different of these co-conspirators named individually in each one of these paragraphs, that person did join an organized mob of individuals designed to overwhelm police in an in the police force in an attempt to occupy the cab force and cause property damage. That particular, all of those, the state alleges alleged sufficient facts that would support a predicate act of act or threat involving felony obstruction of justice, Judge. So in summation, the allegation is we did not allege predicate acts. Some of them say no acts of racketeering activity. Some of them say no pattern of racketeering activity. I'm addressing whether we alleged pattern of racketeering activity through racketeering acts. And in summation, Judge, we have alleged 27 allegations of threats involving felony obstruction, 29 allegations of acts or threats involving arson, 41 allegations, I'll slow down, of influencing a witness, 3 allegations of simple assault, 2 allegations of aggravated assault, paragraphs 155 and 156 in correspondence or corresponding to count 2 alleged domestic terrorism. Yeah, that's all we had to do. One count, one
She
charge of domestic terrorism. And then paragraph 152 puts defendant on notice of the racketeering activity crimes of domestic terrorism and attempted arson with corresponding counts 2 and 3. That then, so you've got 2 is domestic terrorism, 3 is arson, and count
Nice
count
name for ya,
152
everything.
puts them on notice that they are charged with conduct that then is arson or domestic terrorism, and that those offenses are later defined in counts 2 and 3, which is allowed under the Sanders case and many other cases. So, Judge, as far as the arguments of Mr. Sanders, I don't think I will have to take up the court's time because many other defendants argue the same thing, and I believe that I have covered what our position is with regard to that. And again, Judge, so in essence, in response, this is not targeting or subjecting these defendants to illegal prosecution under the First Amendment under any way. And the state has sufficiently alleged for an indictment that the elements of Rico conspiracy, including a pattern of racketeering activity and the specific racketeering acts or racketeering activity that support that. All right. Thank you for your time, Judge. Do you have any questions?
Not right now. Nope.
Thank you.
You want to
Was
follow
that
back
good?
up? It's y'all's motion. I'm going to take that as a yes.
All right, here comes Don, guys. Let's get Don back in the banner.
All right. A lot of issues that she raised, some of which, as I told you before, we got no briefing from the prosecution before this hearing today. So none of the cases they've cited, nothing that they've cited here today was ever previewed with the defense over the last 2 years. So it makes it a little difficult to reply to some of these. But I'm going to do the best I can. First of all, with regard to the issue of the impropriety of the introductory language, the 25 pages of the, as you put it, the Aleppo allegations. This is not a case
Aleppo
like
allegations?
Mr. Fowler referred to in the Second Circuit case involving a prosecution of the Genovese crime family. Of course there are going to be allegations about the history of the Genovese crime family, just like there can be allegations about the history of the actual enterprise in this case, as opposed to going back literally hundreds of years with allegations about the history of anarchism and violent anarchism. There's a world of difference between alleging the background of the Genovese crime family in a Genovese crime family prosecution and allegations about the history of the philosophy of anarchism in the world. Second of all, the allegations in our case include all kinds of allegations from taped interviews of people who are masked and who make allegations that are never identified. And we have no idea who these people are. People making violent allegations, violent suggestions, supposedly, to members of the enterprise here. A clear violation of the Confrontation Clause, no matter how you dress it up. They can, whatever Mr. Fowler claims about where they derived this information from, I don't know, I have no idea, because it doesn't allege where they found it or gathered it. So the idea that they can present to the jury, either in the indictment or even in evidence, a masked person reading a script saying we should kill more policemen would never be tolerated in an American courtroom. So, you know, Mr. Fowler's closing remarks where he says, we think this does go to the jury. The entire indictment goes to the jury, including this language. And these allegations by, you know, unidentified people is a clear violation of the Confrontation Clause and due process. With regard to the suggestion that we should just simply strike it, that we could use the vehicle of a motion to strike surplusage, that is actually not done very often in Georgia. It's done frequently, much more frequently in federal court, but in Georgia, it tends to be done with as an errant word or an alias that didn't, you know, we're going to call some guy, you know, murdering Joe or something. We can strike that kind of surplusage. We're talking about striking 25 pages of this indictment. That's what we're talking about, is the only remedy which we believe is more akin to a special demurrer, as opposed to, you know, dressing up the indictment a little bit or cleaning it up a little bit through a motion for surplusage. So we stand on the position that it is a remedy, that the remedy we seek, which is dismissal of the entire indictment, go to a grand jury without polluting the grand jury with this information and inducing the grand jury, because of these masked people, you can assume that all these defendants out here are murderers, and they all advocate for murder and killing policemen, which is what the introductory language suggests with these masked people who are giving speeches. The only possible remedy is to, the only reasonable remedy is to dismiss the indictment, grant the special demurrer with regard to that, and let the grand jury return a more an indictment which is more befitting a courtroom in this county and in this state. With regard to the demurrers, and I'll start with where Ms. Dixon finished, which was these allegations dealing with intimidation of witnesses. If you look at the overt acts that we're dealing with here, time and time again, they talk about my clients, as well as many of the other clients, engaging in some kind of conduct to effect an official proceeding. Ms. Dixon's correct. It doesn't have to be a pending proceeding, but it has to be an official proceeding. And they've never identified, nowhere in this indictment does it allege what official proceeding we're supposedly going to be impacting. And there's nothing in either the federal intimidation statutes, the obstruction statutes, or the state statutes that say you can just allege an official proceeding and we'll just let the jury decide. Because we sure have no clue what they're talking about. We have no clue what the prosecution's intending to present before the grand jury, before the...
Also, a little bit of an aside, and I'm not that caught up on the details, but something that, you know, in cartoons when somebody's paying attention, like one eyeball comes out of the head and like moves to pay attention to something happening over here. Trying to follow the stuff that's going on with Aiden Kearney, Turtle Boy, and what's going on in Massachusetts. Their witness intimidation statute in Massachusetts is scarily broad to me. So I'm thinking of that case in parallel. I haven't been following it. But here we're hearing Don Samuel argue like the intimidation needs to happen in relation to preventing somebody from giving some type of testimony. They're too intimidated, somebody intimidated, and they don't want to show up for this proceeding where they would give their testimony and help in the prosecution of the case. Reading what the statute lays out in Massachusetts, it's so broad. It doesn't specify that to prevent somebody from showing up to testify somewhere. And these are important issues to pay attention to. I think, obviously, he's got a better statute to work with here. But what a crazy thing to think that somebody can claim intimidation, and it's not delineated in the law what actually constitutes intimidation. And then there doesn't need to necessarily be a direct connection between that intimidation caused person to no longer want to do XYZ thing. If we don't have those specifics in the legislation, that's a really, really wide open door for prosecution and having a chilling effect on somebody's free speech. So I need to catch up on that, but if you're interested in issues like that, I did want to shout out that what's going on in Massachusetts with the Aiden Kearney case relates to claims of witness intimidation with crazy, vague legislation.
Trial jury as to what official proceeding could possibly
Daisy!
be envisioned
Hi,
by the
Daisy!
defendants who were engaged in this conduct.
It's very demure, very mindful.
And given their argument today, I will give you a case, a recent case. It's not in my case. The case is State versus Eastman. This is the Trump case in which we argued to Judge McAfee exactly this issue, that there was a solicitation to the legislature. I don't know if you've ever read the Trump indictment, but the defendants are alleged to have solicited legislators to violate the Constitution by uncertifying the election. That's the allegation against the Trump co-conspirators. And we argued to Judge McAfee that the indictment was defective because it didn't say what part of the Constitution do you claim we were violating. And he agreed, and the Georgia Court of Appeals agreed. And the case is State versus Eastman. The citation is 374 Georgia Appeals 484 this year. That's Judge McAfee
Hey, pass, Britta.
in the trial court last year and the Georgia Court of Appeals this year. 374 Georgia Appeals 484, granting a special demurrer, dismissing all those counts of the indictment. There were many counts of the indictment dismissed. Agreeing with our argument that you've got to be specific when you're talking about, what part of the Constitution you were soliciting the legislators to violate. Clearly analogous to the argument we're making here is you have to tell us what official proceeding you're claiming we were trying to obstruct. Doesn't have to be pending, it could be envisioned, but at least we have to have been thinking of an official proceeding, and they have to identify what kind of official proceeding and what specifically official proceeding we were envisioning. With regard to, Mr. Garland's going to be arguing either next, or I'm not quite sure what the order of proof is going to be here, but he's going through a lot of the special demurs that surely apply to my three defendants. He's representing someone else. It's just count after count after count where we're having to guess what the prosecution is going to try to prove, which is exactly what the office of a special demur is. The prosecution is wrong when they say you already contested this. Just look at the discovery, you can find out. Federal courts, sometimes they allow that. They allow it with a bill of particulars. We don't have bill of particulars in Fulton County Superior Court or the courts of Georgia. They have to allege the facts that are needed. The facts that are needed, not just the law that is violated. And the Jackson case that we put in our brief, 301 Georgia 137. In our brief, the Georgia Supreme Court explains that a special demur can demand facts that allow us to prepare a defense. And I'll go back to the Scenes blog allegations again. And Mr. Fowler says, it's as clear as can be. We've identified every fact you could possibly want to know. You authored something, and then describes the supposed statement that we authored, and it ended up on some blog site somewhere. Dozens of counts, many of them dealing with the official proceeding claim as well. And yet they never say how we supposedly authored it or who authored it. Because each of those counts says some undefined number of unindicted co-conspirators and Marlon Katz and Adele McClain and Savannah Patterson all authored something that ended on a blog post. We have no idea what the actual allegation is. We could find the blog post. It doesn't have anybody's name on it. We don't know who the unindicted co-conspirators are. Apparently they don't either. We don't even know categorically who the unindicted co-conspirators are. There's no defense we can do. We could have started the trial the day after the indictment was returned, because we knew as much then as we know today. And the prosecution also says, you can find it in the discovery. You can't find it in the discovery. I went to Mr. Fowler's office. Me and Mr. McDermott went to Mr. Fowler's office. Would you tell us how you have facts that show that either Katz or McLean or Patterson authored these things in the Scenes blog? I told you this morning. They gave us one piece of paper that has the Atlanta Solidarity Fund and Scenes blog on the same page. We don't even know who authored that page or what it was. It was from what they call a zine. But nobody knows who authored those or who it was a fundraiser. We have no idea that has anything to do at all with proof that we authored it. And the Jackson case says where you need facts to prepare a defense, facts should be supplied. And just saying you authored it without giving us any information whatsoever requires that those predicate acts be dismissed, that a special demur be granted. And I was going to go through a number of these overt acts, but I think Mr. Garland's going to do that and shows all the special demurs that are needed. So if I could just defer to him. Plus, most of them have nothing to do with these four defendants. So it's,
You might find that
Hey,
another
Amy,
day.
good to see you.
some of them,
Hope you're doing well.
and I'm concerned that I may not understand the proper protocol here. I mean, there are many, many issues dealing with our three clients. I say our, my law firm's three clients, that have nothing to do with them. And I'm sure you don't want to hear about, for example, the motion to suppress is still pending. Has nothing to do with these four people. It's been sitting there for, 2 years now. We have the whole filter team issues that we're working through at least, and close, but not done, resolving. But just dealing with the demur, if I can.
Britta, the Blooming
The other
Onion was
thing
amazing.
I wanna
An amazing
talk just
time.
briefly about the Dorsey case. This is Sheriff Dorsey. You remember Sheriff Dorsey was alleged to have assassinated or arranged for the assassination of Derwin Brown in DeKalb County. I represented Sheriff Dorsey, unfortunately, because I lost that case that Ms. Dixon is talking a lot about. And it does have troubling language about the definition. My definition is troubling language about the definition of a racketeering act. The structure of the statute is, and Ms. Dixon talked about this a little bit, is there's a list of 43 specific generic crimes in Georgia, including homicides, everything in chapter 1651, various sex offenses, 16.6. If you look at section 5 of 1614, whatever, there's 3, Georgia code sections. And then if you look at 5B, it says any crime in any state involving murder, arson, and the whole list. It is clear from the legislation that what the intention was to bring in the laws of all 50 states, because Rico allows you to prosecute for crimes that occurred outside the venue.
Bingo.
So first they identify all the Georgia crimes, including murder, including arson, including intimidating witnesses. That's all in A. And then it says, and in any state, crimes involving arson, murder, and intimidation. Because they're trying to bring in reality, another 49 states' laws in Section B.
Don't forget the territories.
And D.C. And
Guam.
Huh?
Guam.
Listen to the judges. The judge is playing right into the argument that Don is making here. So not only do I think he's agreeing with what Don is arguing within this case, but it seems like on a broader level, the judge doesn't really like the way that the state can use Rico.
that's right, Greenland.
Right?
No?
Not yet.
Not yet. So, but listen, I'm gonna be honest. The Supreme Court didn't agree with this, and the Supreme Court agreed with Ms. Dixon. And again, I suppose we're going to have to honor that here. they did say, when the statute said, "and any state," even though it is abundantly clear they're trying to bring in 49 states,
It meant Georgia too.
we're one of the 50.
Yep.
So the question is how to limit Dorsey somehow to make sense. Because why would you say you have to prove a predicate act, murder, arson, and then say, or any act involving murder? It's completely duplicative. There's no reason to have had Section A at all if you're going to say any act involving murder. It doesn't say any overt act in B. And in Dorsey, they never defined what they meant by an act involving. We know what the legislature meant. It meant the crimes in Maryland involving murder, the crimes in Kentucky involving murder, the crimes in South Carolina and Alabama, because they didn't want to have to go through every code section of every state. So, but the point is that has nothing to do with the demurs that we've filed. Because none of my clients are charged with, my clients, my law firm's clients, none of them are alleged to have violated an act involving murder or an act involving any of these other code sections that they're alleging. Nor do the predicate acts say that that's what they're relying on, a 5B allegation. As she said, calls them 5B claims. None of them say that. We're just left to guess. What is the predicate? What are we defending here?
Does the indictment have to delineate between 5A and 5B? I mean,
I would think so. They have to say, they can't just, they don't give us
FFS.
many facts, and then they don't give us the appropriate code section. That's what Jackson says. Jackson even says you shouldn't even rely just on code section. It should be code section plus element plus facts. And, if it's obvious, and sometimes it is obvious, like in Sanders with some of the counts were thrown out in Sanders. I mean, Sanders has some counts that survived the Supreme Court, and other counts, I think Judge Bethel wrote the decision, other counts where he said, you allege they violated the Biocontrolled Substances Act. He didn't say what drug. Well, I think under their analysis here today, you don't really have to do that. Just say VGCSA. But Judge Bethel said, no, you got to be precise. You got to be precise, exactly what drug. And that's for a solicitation count, where it's the predicate offense for a solicitation count. Were you with me? The defendant asked someone else to sell him some methamphetamines, and the indictment said, you solicited someone to sell
a drug.
drugs. And Bethel said, in violation of VGCSA. And Justice Bethel said, that's not enough. You got to identify the specific drug. Well, that's like the official proceeding in these counts. You got to identify the official proceeding. You have to be precise so we can at least prepare a defense. I'm back to surplusage for 1 second. Mr. Fowler says one of the reasons we can put it in is because it came out of their own language or their own mouths, the defendants. I seriously doubt that. I seriously doubt the accuracy of what he said there, not intentionally, but...
Hey, Allie B. So Allie B says, isn't this the attorney that represented Christopher, meaning Christopher Wolfenbarger, that was actually a Fulton County indictment. Guys, this one was brought by the State Attorney General Chris Carr. I know it's very familiar to Fulton County Ricos, but it's really the Attorney General bringing this one forward. But yeah, so Don Samuel with his co-counsel Joel McDermott, who's also working to represent 3 defendants in this case. So we haven't seen Joel yet with this hearing, but he is working on this case. But this is Don Samuel. I think he is a gem. Hearing his arguments, you can just see how he has on every tile, he has his chess piece, and he knows what argument he needs to make with each chess piece. But he does it all within the context of playing the whole game, the whole strategy, the big picture. And it's really, really a treat to watch. Even aside from an interest in the substance of the case, just seeing someone think and reason and use logic and make arguments the way he is really, really something interesting to watch. So thank you for the super. And yes, it is the man, the myth, the legend, Don Samuel.
Is he claiming that they have one of the defendants reciting 25 pages worth of the history of anarchism somewhere? We certainly haven't seen that in the discovery. And so I think what he's doing is he's saying we've got these masked people talking. So we're not going to tell you who said it. We're not going to tell the jury who said it. Just someone wearing a mask said, you know, during the night of rage or day of rage, we ought to kill some cops. And says, well, that's why it's in the indictment, because some masked person said it. And then he said, well, maybe it came out of books or articles. Well, let me remind him of the First Amendment and you know, the Anarchist Cookbook. A lot of people have got a copy of the Anarchist Cookbook. I bet you've got a copy of the Anarchist Cookbook in your library. But
Does
nobody
he?
would
The
say
judge?
that you're making bombs, you know, or that you believe in bomb making, or that you advocate bomb making. And we all have books in our library that we don't actually advocate for. I mean, criminal defense lawyers have all kinds of books in their libraries about the crimes that we defend against, our clients who were charged, you know, and you may remember from our motion to suppress the types of materials they seized from our client's house. The voluminous amount of books and magazines and pamphlets. Some of them were in fact written at the beginning of the century, and they're claiming they're going to use that in our trial. So strike the surplus or not, they plan to put it in anyways because it was in Marlin's library. And we quote 100 cases to you saying you can't put the Anarchist Cookbook in evidence. It's the same as, you know, rap music cases. So,
Wait, is this deja vu or did he just repeat that?
I'm going to defer to Mr. Garland if I can, with all due respect to these four folks. When their special demur gets raised, I think he's been invited
Hey,
to
Tally.
deal with those facts. But we maintain general demur should be granted in this case because of the various flaws with the indictment. Can you imagine, can I just finish with this? Can you imagine trying to instruct the jury consistent with everything that Ms. Nixon just said for the last 2 or 3 hours? Can you imagine trying to explain to a jury the way this indictment is framed? The intricacies of the verdict, either guilty or not guilty on count one. How are they going to do that with this indictment?
I would look forward to reading the proposed jury charges provided by the parties.
Well, we have tried actually to start working on that. It is impossible. It is impossible. Okay? I mean, you've read the indictment, right? You've read the motions, you've read the demurs, you certainly know the statute. Can you imagine trying to explain to a jury how, take my clients who've never set foot in the forest, who paid for people, who arranged for the payment, they didn't pay, arranged for payment for people for hot dogs, veggie dogs actually. that is.
So earlier in this stream, I said pay attention to, and he's right, Don is right. This judge has read the indictment, despite him saying, read it again. But this judge started to give the example earlier in case you missed it. So if I go and buy a Italian ice, I pay $1 for an Italian ice. And that Italian ice stand happens to be owned by the Genovese family, the mob. And he goes into his example. But I said pin that. It's going to become relevant. Well, part of these overt acts, some of the overt acts in the indictment relate to, you know, and cash payment companies like Zelle and Chase. They run commercials on national TV. Oh, you're going out to dinner with your group friends, me for Always Forever for Life, Allie B from Tennessee, Daisy, K Tally, we're going out to lunch. For the sake of it, K Tally says, look, I'll just put it on my card, you guys, just send me your split. So we all send the money to pay each other back to make it easy for the server, right? Cool. Companies advertise for this sort of thing. But if we look over at the indictment, one of the things that they're saying is an overt act in furtherance of the enterprise is that there were like a $50 payment for food. That's the overt act they're alleging has some nexus to some criminal activity and growing enterprise that's just racketeering out here in these streets. Think about that. That's why he's hyping on this, paying them back for a hot dog. Well, a veggie dog, actually. And the judge happened to give an example about making a purchase earlier. And when he made that, the judge did it first, but seeing Don make this argument after the fact shows me that the judge has already picked up what Don is now putting down and made his own example when speaking to the prosecutor earlier. It's just a beautiful thing.
Or is not an overt act that you can use to
I like
hold
the
them
two of them.
responsible, hold my clients responsible because they're paying for food. You about to ask me a question? Or
John
about to
Floyd.
be frustrated?
No. I was just supposed to make a Godfather reference. Marlon Brando never pulled the trigger. Marlon Brando never went on the scene.
Yeah. Well, we don't know about that, but but
That's kind of what Rico was originally designed for. Was it not?
Well, it wasn't necessarily for Marlon Brando. It was for racketeering. It was for organized crime families who have a vast array of crimes being committed by a vast array of people in various jurisdictions.
And
Yes.
it's how to get those people that manage to keep their hands clean.
Oh, I don't know about that. It's always been that the ringleader is certainly subject to being prosecuted. There's nothing about Rico that makes that unusual. There's nothing about Rico that says go after the kingpin. I mean, it's the same level of proof as before Rico was enacted. But, I'm sorry, you got me off track a little bit. The fact that my clients didn't go to the forest is certainly an issue here. They're not charged with trespassing. They're not charged with...
Michael didn't get in the boat with Fredo.
Say it again.
Michael didn't get in the boat with Fredo.
I assume there's cement shoes somewhere in that, right?
You've never seen The Godfather?
Many times. All right, all right.
Fredo doesn't make it out of the boat. Let's just leave it that way.
Okay. Thank you.
Okay, 1:30, where are we? We were in this, are we?
Which is the motion Mr. Garland's arguing?
Where?
We're at number 3 on the list, which is the motion Mr. Garland is arguing.
Or number 3.
All right, so now we're going to have Garland make the next separate argument here. Also, thank you to Wendy for the 2. So this case is a hot mess. That's the type of trial we love to watch. At least, I'm assuming if you guys are here, you guys like to watch these hot mess trials. But really, speaking for myself, that's absolutely my type of case, is what we're watching right here. So let's get into Garland. Let's see what he's got going on. Yeah, veggie dogs are the real crime. Oh, wait, one more thing. So the Don Samuels, the chessboard thing, he's pointing out problems with the indictment. He, at the morning session of the hearing, when he was first making his arguments, he started saying, like, hey, we always ask that the indictment goes back with the jury. He's setting the stage that if the indictment has problems, it can't just be, well, the indictment could be better, but it's sufficient. He's teeing it up that that's not going to be good enough because we're going to send the indictment back to the jury. We're allowed to ask for that. It's done all the time. People ask for it. We do it. We've done it in these courts. And if you give them this indictment, even if the state is trying to orally explain their way out of it being a hot mess, this hot mess is still going to be on paper going back to the jury. And that's just such a beautiful thing, a big picture argument that he teed up in little ways from the morning session and now what we got with this afternoon session from yesterday. Just great, great lawyering.
3 is the general and special demurs to count 1 for insufficiency. And then number 4, if we get to it today, is the lack of prosecutorial authority.
Yes, Your Honor, for both 3 and 4, we've estimated roughly an hour each. Mr. Hall will be arguing number 4.
Yeah, I think you guys estimated an hour on 1 and 2 also. So you guys keep time about as well as other lawyers.
Your Honor, if Marcia Connick could go after Mr. Garland's partner number 3, just to clarify the record.
We'll cross that bridge when we get there.
Thank you, Judge.
Mr. Garland.
Good afternoon, Your Honor.
Indeed.
You hanging in there?
Always.
All right, this demur raises both general and special demurs, but I'm going to focus on the special demur aspect of it. And when addressing a special demur, some of this argument has been couched in terms of general demurs. Has the state alleged enough to pass a general demur? But I want you to focus on the requirements of the special demur here. The court's got to apply the rule that a defendant who timely demurs is entitled to an indictment perfect in form and substance. And this isn't a horseshoes kind of test, like close enough is good enough. If the state wants to put people in jeopardy of losing their liberty, at minimum, the indictment must be perfect. And I'm going to start with a topic that's already been touched upon, but which is the indictment's failure to adequately allege the underlying acts of racketeering. As has been discussed.
Can we talk about that perfection real quick? I'm going to go back to Kimbrough again. To be clear, we do not mean to suggest that a RICO indictment must contain pages and pages of extensive detail about the connection between the enterprise and the pattern of racketeering activity. Just in that case, they hold that the sparse allegations in that indictment that say nothing at all about the nature of the connection are insufficient to enable the defendants to prepare for trial. So yes, they use the word perfection, and then they qualify it immediately.
Yeah, and I would suggest that the pages and pages of detail in this case, Your Honor,
This sucker's 109 pages long.
are anything but.
Okay.
So let's start with these underlying acts of racketeering that the state has to prove in order to establish their case. You know, we've talked about how it's a compound offense, right? You got to prove the RICO, and you got to prove the underlying racketeering acts, which are themselves crimes. And the Supreme Court has said the indictment must clearly set forth the elements of those underlying compound crimes and the facts that support them. This indictment may do that in a few occasions, but the state has repeatedly alluded to and argued there are a variety of other spots in the indictment that satisfy the racketeering act proof that don't contain the elements, that don't contain an adequate application of the facts.
Let me ask you this. Are you going to make a differentiation between predicate acts and overt acts?
Yes, yeah. I'm specifically at this point in my argument talking about those acts of racketeering we call the predicate acts.
Okay.
Right? Those things they have to prove as part of establishing.
That are criminal acts standing on their own.
Yeah, that the conspiracy engaged in.
That fit within 5A or 5B.
Right. Either the domestic terrorism or two other acts of racketeering activity, or the act involving that was discussed extensively before. I'm talking about those.
Okay.
Those are compound crimes that must be adequately alleged, and the courts have told us that. And as Mr. Samuel noted, the indictment doesn't identify any act of racketeering other than to say some undefined number included within the overt acts. There's nowhere in this indictment that says this is a racketeering act.
None of them say predicate act. They all say overt act.
And it says any of these the racketeering acts are included somewhere in these overt acts. It never identifies one racketeering act. We are left to guess. We are left unable to intelligently prepare our defense.
The defendants committed overt acts. This is the beginning of part 2 on page 49 of the indictment. The defendants committed overt acts to affect the object of the conspiracy, which include acts of racketeering as described below. And then all 225 say they're overt acts. None of them distinguish themselves as acts of racketeering. That's your argument?
We are left to guess, Your Honor.
Okay.
We are unable to intelligently prepare our defense, as the law requires us to.
And I think Ms. Dixon was saying some of them set forth in their facts. Let's see. I'm going to go with, on page 84, overt act 152, 153, which is talking about arson.
Shout out to True Crime Junkie over on the Purple app.
Specifically mentions did commit the offense of domestic terrorism, would that not put a defendant on notice that that's a racketeering act?
Well, then I can talk to you about those.
If it's talking about domestic terrorism and it actually states domestic terrorism or arson, both of which would qualify as racketeering acts, for the purpose of getting to the magic number of 2, does that not put you guys on notice?
Well, it puts us on notice that they're claiming it's an act of domestic terrorism or arson. It does not put us on notice whether they intend to rely on that or whether there will be proof that that can be one of the acts of racketeering. If you look at this indictment and you listen to the argument of counsel, there is an unlimited possibility of possible racketeering acts. We are left just to go through the indictment and try to figure out which ones they are. Now, as Your Honor points out, where they use the words domestic terrorism, where they use the words arson, that's certainly a key, right?
Look at the purple gang.
I'll go back to Mr. Liberto, because I can. He attempted to occupy. That's an overt act. There's not a crime described, a separate, independent. There's no second part of a compound crime there, right? Okay. So you can read that. Does that not put you on notice that that's not a racketeering?
It does to some extent, Your Honor. I agree with you. But for the state to be able to prove to a jury and for a jury to rely on a racketeering act, we've got to know which ones, right? And it's not enough to say that they've adequately alleged some, but they can still prove others, because that's a problem for the special demurrer. We need to know all the ones that the state would be able to rely on so we could adequately prepare our defense. And so, domestic terrorism, arson, it's alleged in separate counts 2 and 3 for January 21st, 2023. So that's probably the state's strongest argument, that that one's adequately alleged, that we're on notice that those are acts of racketeering, right? And there are concerns with that domestic terrorism statute that will be addressed in other demurrers, so I want to address those here. And then
We're not addressing the constitutionality of arson, are we?
No, Judge, but there is a demur on it, so both of those could be.
I've read it.
But the indictment makes references to domestic terrorism and arson that didn't occur on the number of counts on January 21st, 2023, right? But they don't adequately allege the underlying facts as they apply to the elements of arson in those paragraphs. They mention the word domestic terrorism, they mention the word arson, but remember, the law requires them to allege the elements and the facts that apply to those elements.
And the predicate acts cannot be overt acts.
I broke it. I jumped forward. Sorry, guys. Hold on, wait. I think I can find this in the transcript. Let's see where we find. Let's see if they have one. Yeah. Because I don't know exactly where we were. I know he was up there for a little bit. We're somewhere near here.
Acts of racketeering.
Let's search for predicate acts. Unfortunately, I think that's a popular term. Let's go down to like an hour in. Yeah, that's not going to be a good term to get us in the right spot. I think this was it.
Differentiation between predicate acts and overt acts?
Yes, yeah. I'm specifically at this point in my argument talking about those acts of racketeering we call the predicate acts.
Okay.
Right? Those things they have to prove as part of establishing.
That are criminal acts standing on their own.
Yeah, that the conspiracy engaged in.
That fit within 5A or 5B.
Right. Either the domestic terrorism or 2 other acts of racketeering activity or the act involving that was discussed extensively before. I'm talking about those.
Okay.
Those are compound crimes that must be adequately alleged, and the courts have told us that. And as Mr. Samuel noted, the indictment doesn't identify any act of racketeering other than to say some undefined number included within the overt acts. There's nowhere in this indictment that says this is a racketeering act.
None of them say predicate act, they all say overt act.
And it says any of these the racketeering acts are included somewhere in these overt acts. It never identifies one racketeering act. We are left to guess. We are left unable to intelligently prepare our defense.
The defendants committed overt acts. This is the beginning of part 2 on page 49 of the indictment. The defendants committed overt acts to affect the object of the conspiracy, which include acts of racketeering as described below. And then all 225 say they're overt acts. None of them distinguish themselves as acts of racketeering. That's your argument?
We are left to guess, Your Honor.
Okay.
We are unable to intelligently prepare our defense, as the law requires us
And I
to
think
be
Ms.
able to.
Dixon was saying some of
Imagine if he said, and the state is unable to prepare an intelligent indictment. Because that's what I'm hearing in my head.
them set forth in their facts. Let's see. I'm going to go with, on page 84, overt act 152, 153, which is talking about arson. 155 specifically mentions did commit the offense of domestic terrorism. Would that not put a defendant on notice that that's a racketeering act?
Well, then I can talk to you about those.
If it's talking about domestic terrorism and it actually states domestic terrorism or arson, both of which would qualify as racketeering acts, for the purpose of getting to the magic number of 2, does that not put you guys on notice?
Well, it puts us on notice that they're claiming it's an act of domestic terrorism or arson. It does not put us on notice whether they intend to rely on that or whether there will be proof that that can be one of the acts of racketeering. If you look at this indictment and you listen to the argument of counsel, there is an unlimited possibility of possible racketeering acts. We are left just to go through the indictment and try to figure out which ones they are. Now, as Your Honor points out, where they use the words domestic terrorism, where they use the words arson, that's certainly a key, right?
Now I'll go back to Mr. Roberto, because I can. He attempted to occupy. That's an overt act. There's not a crime described, a separate independent. There's no second part of a compound crime there, right? Okay, so you can read that. Does that not put you on notice that that's not a racketeering?
It does to some extent, Your Honor. I agree with you. But for the state to be able to prove to a jury and for a jury to rely on a racketeering act, we've got to know which ones, right? And it's not enough to say that they've adequately alleged some, but they can still prove others, because that's a problem for the special demurrer. We need to know all the ones that the state would be able to rely on so we could adequately prepare our defense. And so, domestic terrorism, arson, it's alleged in separate counts 2 and 3 for January 21st, 2023. So that's probably the state's strongest argument, that that one's adequately alleged, and that we're on notice that those are acts of racketeering, right? And there are concerns with that domestic terrorism statute that will be addressed in other demurrers, so I want to address those here. And then there's the...
We're not addressing the constitutionality of arson, are we?
No, Judge, but there is a demur on it, so both of those could be.
But we will.
But the indictment makes references to domestic terrorism and arson that didn't occur on the number of counts on January 21st, 2023.
So if you're joining a little bit late, the judge was actually asking the state to focus in on this January 21st, 2023 date and get to certain issues. And she kept going off and talking about other examples, things that happened in March. And the judge was like, but that was in March. What about January? So, in hearing this argument play out, the judge is trying to get, I think he's trying to hear certain arguments. I think Neri's right, doing it for the record. But getting into this specific date and time frame, this defense attorney, Attorney Garland, is arguing, like, okay, there's arson mentioned in the indictment, but it didn't occur on January 21st, which is why we have issues with the indictment. One of the many reasons.
Right? But they don't adequately allege the underlying facts as they apply to the elements of arson in those paragraphs. They mention the words domestic terrorism, they mention the word arson, but remember, the law requires them to allege the elements and the facts that apply to those elements.
And the predicate acts would not be overt acts.
Correct.
Okay.
And they haven't done that. Not only do they not mention the elements in regard to the acts on those dates, for instance, the March 5th music festival and the damage to the construction equipment that's alleged to have occurred on that day. They don't mention the elements of arson or domestic terrorism in those counts. They don't mention the code section. They don't explain how the facts alleged in those counts satisfy those elements, Your Honor. So while Your Honor's right, saying there is some indication that those could be acts of racketeering, I don't know that. It doesn't meet the requirements that the law imposes. We're left to guess. There is a mention of assault in the indictment. It's mentioned a couple times. Nowhere in the indictment does it mention the code section. Nowhere does it set out the elements of the crime. Nowhere does it explain how those elements, how the facts meet those elements of the crime. It completely fails the test of setting forth the elements and the facts required for compound crimes. If they mentioned assault, the indictment mentions assault, but how can that be enough to put us on notice of what is, that it will be an act of racketeering?
And I think that's the Kimbrough case. It's like, okay, this crime could have occurred in 6 different ways. We don't know which one.
I mean, I'm, Your Honor, preparing for this argument. I'm reading through the indictment, and I'm just saying, what fanciful argument could be made to this paragraph to claim that it alleges an act of racketeering? Because that's essentially what the state has done up here. We're left to guess because the indictment doesn't tell us, but the indictment has to tell us. We have to know what the racketeering acts so we can prepare our defense. We shouldn't have to guess. In fact, we don't have to guess because the indictment must be perfect and tell us. Then there's influencing a witness. It never mentions the statute by name. It never cites the code section. It never gives a complete recitation of the necessary elements of the crime or an adequate description of how the facts satisfy those elements. All it does is it mentions some of the language from the statute in various overt acts in the indictment.
Don't forget which official received it.
Right. It just talks about some of the elements. So it fails the test. It doesn't set forth all the essential elements. It doesn't set forth how the facts apply to those elements. And then there are, for instance, it makes no mention of the element that it must be done to persuade another person by means of corruption or an attempt to do so, or to engage in misleading conduct towards another person. It makes no mention of that element. It makes no description of how the facts would satisfy that element. Again, it's a passing reference. We are left to guess. Is this just flourish in the indictment? Or is this an act of racketeering? We don't know. It hasn't been identified. And then, of course, there's the official proceeding problem. The statute defines official proceeding. None of that language is in the indictment. Nowhere is there any description of what this official proceeding that is contemplated to keep the documents from appearing in it. How do we prepare for that, Your Honor? We're just left to guess. But we don't have to guess because we're entitled to a perfect indictment. They talk about obstruction. Ask the state to tell you where the elements of obstruction are shown in the indictment. They're not there. And the state rattled off various paragraphs during their argument earlier that they claim alleged facts sufficient to show obstruction. Which ones are those? Are they the only ones? Are there others? How do we know if the indictment doesn't tell us? We are going to prepare our defense by the sketchy notes from an argument here by counsel. No, that's not what the law requires. The law requires it to be in the indictment, and they fail to do so. We can't intelligently prepare our defense. There's some talk of money laundering. Nowhere in this indictment as it stands now are the words money laundering used. The elements aren't set forth.
Hey, Jenny,
How the facts
over on the
apply to those
purple
elements
gang.
isn't described. There were counts that originally alleged money laundering, but as you know, those have been dismissed, so they're no longer part of the indictment. It can't inform this inquiry. I mean, I started writing down a list of potential crimes. It's just a pointless exercise, Your Honor, because the state is limited only by the list of predicate crimes and their own creativity to argue to you what's in here. But that's not what the law requires. You got to allege the elements of those underlying crimes. You got to allege how the facts apply to those elements. And they repeatedly fail to do that. Now, it's not enough to say, like it might be for general demur, they did it once, right? They did it for the named counts in the indictment. They did it for the corresponding overt acts that can correspond to the named counts in that date. But that's not what we're addressing here with the special. We need to know every racketeering act that the state would be allowed to try to prove from this indictment. And we don't know that. And then turning to any act involving murder, kidnapping, gambling, arson, robbery, theft, receipt of stolen property, bribery, extortion, obstruction of justice, dealing in narcotic or dangerous drugs, or dealing in securities, so long as those things are a felony. There's nowhere in the indictment that says this is an act involving ... We know they haven't identified any racketeering act specifically, and they certainly haven't identified them as being one of these 5B any other act types. Let's talk about obstruction and murder. What are the elements of obstruction? What are the elements of murder? Where does it show us that in the indictment? It doesn't. What are the facts supporting the existence of those acts as the law requires? We don't know. What are the dates? Who did it? What did they do? We're left to guess. So if we're going to guess, Judge, let's guess. What about the acts described in Part 1 of the indictment? They're explicitly incorporated into Part 2, describing the overt acts, and they say all the overt acts could be acts of racketeering. Could some of those things from Part 1 be the racketeering? Did the state prove at trial to a jury to support a conviction? It talks about Rayshard Brooks. Well, he was shot while pointing a taser at an officer. Is that not an act involving obstruction? Is that a racketeering act that the state can rely on to prove these defendants guilty of Rico conspiracy? It talks about the murder of George Floyd. Are we to assume that the murder of George Floyd is an act involving murder that qualifies as an act of racketeering, supporting a conviction, that we defendants must now be prepared to meet and address at trial? Judge, these examples seem absurd, but they flow directly from the state's theory and argument as to what they have to show in this indictment. Just wrong. The law requires the state to tell us what we're defending against so we can prepare our defense. The state's theory would make it wholly impossible for us to do that. What about acts involving arson? Again, as we talked about, there are some specific numbered counts that address arson on a specific date. The state's arguments, pretty strong, setting aside the other arguments, that they've done what they need to do to identify those acts as acts of racketeering. But as we know, it goes far beyond that. How many of the alleged overt acts involved arson? The indictment doesn't tell us. Which other ones involved arson? How do the facts of those yet unidentified overt acts map onto the elements of arson? We have to guess. It seems that the state's argument is the only limit to the act involving style overt act, predicate act, is they have to allege some fact somewhere that might arguably support it, without notifying us, without setting out what the elements are, and without explaining what the elements apply to that. That's simply contravened, as Your Honor has pointed out, by Kimbrough and the other cases addressing compound crimes. They focus on other acts involving arson and obstruction today. What are they going to say at the next hearing, the next motion? What would they allow to be think of next time? How will we know? When will we know? When will the jury know? Will we find out before the jury finds out? The parade of horribles, Your Honor, is endless. That's why we have the law that requires them to identify everything. And, even if we were to concede the aspect that some of these overt acts adequately set out the facts of some crimes, which we don't, and the indictment doesn't, the indictment still fails the test of a special demurrer in many ways. It fails to identify the facts that support any given racketeering act. It fails to set out the essential evidence, and sometimes it suffers from both problems, as I previously discussed with some of the other potential hypothetical racketeering acts yet unidentified in the indictment. The Supreme Court's clear. The state must provide us this information so that we can prepare our defense. And this indictment makes such preparation impossible. And then from there, we can zoom out beyond. My argument to this point has been focused exclusively on the acts of racketeering, those predicate acts. But we can zoom out from there because the state has to prove more. They have to prove all the elements of the Rico conspiracy itself beyond the underlying acts. And I won't bore you with going through all the elements of that.
Oh, no, please, by all means, bore me.
So the defendants got to endeavor or conspire to violate subsection B as alleged in the indictment. So they have to be, that requires them to be associated with an enterprise. And so they've got, that enterprise must exist. And that enterprise is at a minimum an association or group of individuals associated in fact.
Right. I mean, you said B. There's many B's here. We're talking code section.
Yeah, 16, 14, 4. And I'm referring to the sort of start of count one of the code sections they refer to in the indictment.
Mm-hmm. Okay.
And they must endeavor or conspire for someone in that enterprise to be engaged in a pattern of racketeering activity. That's all the things we've just been talking about. Either the two racketeering acts or the one act of the domestic terrorism. And the defendant must commit an overt act. Right? That's kind of gets us to our universe of elements that they must prove and frames what the indictment's got to put us on notice of. And Your Honor's honed in right away on one of the big ones. What's the nexus between the overt acts and the conspiracy?
What is the nexus?
It's hard to answer that question because we don't know what the enterprise is, Judge.
Listen to this guy.
What's the nexus between the overt acts and the conspiracy and enterprise? It's hard to answer that question because we don't know what the enterprise is, Judge.
Isn't the enterprise set out in?
Is it the Defending Atlanta Forest? Is it Network for Strong Communities?
That's
Is it one or the other? Is it both? We can't tell.
According to the indictment, defend the Atlanta Forest is a self-adopted coalition and enterprise of militant anarchists, eco-activists, and community organizers. But that is the enterprise. That is even, because part one is the enterprise. A, introduction. B, defend the Atlanta Forest. Then we get into the background of the Atlanta Forest. And C, B, beginning of the defend the informant enterprise. And that's where we get Mr. Floyd and Mr. Brooks. So the indictment says defend the Atlanta Forest is the enterprise.
Right, but what is it? That enterprise must engage in a pattern of racketeering activity, right? And so it has to have, that enterprise has to be the vehicle through which the conspiracy is committed that has an object or a goal. And that is, what those objects and goals are so broad and ill-defined. It's unintelligible. It's so broad, as Your Honor pointed out, it talks about the black-clad defendant Atlanta Forest participant states that the fate of the Kurdish revolutionaries in Kobani and Seri Nave, in all these places, it was partially determined by the bloodbath in Damascus and Aleppo. That's one of the objectives of this enterprise inside the conspiracy. We have to be prepared to defend against that. Does that mark one of the outer limits of it? Is there going to be proof of Aleppo? Is there going to be proof of the unidentified person at trial? We don't know who it is by the indictment. We don't know their relevance. But not only does it say too much, it gives such a broad and vague universe of things that are included in this enterprise and conspiracy that it then fails to give enough detail about the ground it does cover. It would require at least another 100 pages to give us enough information to put us on notice of what these things are that they are even talking about in this section. Aleppo, Damascus, masked individuals that are unnamed. And the jury's going to have the same problem if a case like this is allowed to go to the jury as indicted. How's the jury going to know what the enterprise is, what the conspiracy is, what the objects are? Now, we've talked about ways that you can limit that beyond a demur, redacting the indictment, striking surplusage. But we're not, as Mr. Samuel pointed out, we're not talking about removing a word here or there. We're talking about the need for wholesale change to this indictment that fundamentally changes what it is. It's hard for me to even identify what demurs would remain if we start striking whole swaths of the indictment. Of course, the ones where the state fails to allege the elements of the compound crimes and the facts that apply to it will still be there. But what about the rest? I don't even know. The jury's got to know what's been alleged, right? We need to be able to determine if there's a fatal variance between what's alleged and what's proven. That's why they've got to tell us what these racketeering acts are. Because we have to know, have they alleged it or have they not? We need that to prepare our defense. I go through in my motion that detail, and it seems like Your Honor had a chance to review it, of all the questions, count one, the part one, just defining the enterprise phrases, failing to define certain things, failing to identify other things, failing to explain how the enterprise is a subject, define the enterprise.
Well,
how
we're talking about Mr. Schwartz's motion here, right?
Which I think was my motion, Your Honor. Sorry, Mr. Schwartz's motion.
He's feeling any thunder? He's co-opting your, I've got, on number 3, I've got Mr. Schwartz's signature on the last page.
He's arguing, we filed a motion, I think 3 of the 4.
Pardon?
3 of the 4 of us filed the same demurrer.
Okay.
But it
I
was-
just got the one with your signature. I look under your client, I'm gonna find the same motion with your signature.
Yeah, I don't think I'm talking out of turn if I say it was just a copy and paste of my motion.
Was it good?
We'll see when I rule, won't we?
And so I hate to go through, this 53-page demurrer, right? I hate to go through every question that this indictment raises. I think Your Honor has
46, but okay.
Okay. It has reviewed and sees all the questions this indictment raises. It doesn't describe the alleged criminal purpose of defendant Atlanta Forest. It doesn't describe how individuals joined the conspiracy. It fails to describe the acts of racketeering activity, and the list goes on and on about all these vague concepts that are introduced but not tied in, not given a nexus to what we're dealing with here. All right, and then turning to part 2, which the overt acts. The indictment sort of breaks these down into various categories. Payments, online, the indictment. The demurrer breaks these down into payments, online postings, the January 21st protest, the March 23rd event, the flyers in Super Sosado's neighborhood, the forced occupation, property destruction, and uncategorized.
You're on part 2?
Yeah, the indictment.
Oh, the indictment, okay.
Yeah.
I thought part 2 of your demurrer.
Well, which is titled, part 2.
Online postings.
Yeah. Roman numeral 2. Number 2 is number 2 within Roman numeral 2. So you have to back up to get to Roman numeral 2. Payments would be 1, online postings is 2, and above that is Roman numeral 2, describing Roman numeral 2 of the indictment, which are the overt acts. Am I making sense yet, Judge?
No.
Okay. The indictment alleges overt acts as we've talked about. And part 2 of the Rico count, pages 49 through 100, alleges 225 overt acts, right? And so those acts raise all kinds of special demurrer problems. So I just want to turn
225 of them, I imagine.
greater than 225 problems for the 225 alleged acts. And those are the ones that I just described, payments, online postings, and so on. They kind of break out into categories, even though they're not explicitly done that way in the indictment.
I think both sides have categorized them.
Yeah. And so a variety of questions keep rearing their head with these overt acts. What's the nexus between these acts, either racketeering or overt, and the alleged enterprise and conspiracy? How are the alleged acts connected to the enterprise? How did the alleged acts further the purposes of the conspiracy? How did the defendants not named in the acts conspire or endeavor to further them? For example, when you look at the January 21st protest, the quote-unquote night of rage.
Now, at some point, there is a difference between a proper indictment and adequate proof of trial. We can agree on that, right?
Absolutely.
They don't have to prove their case in the indictment.
Absolutely.
Okay? They allege the nexus, but then they're going to have to prove that nexus, right? You're just saying the allegation needs a little better, a little more work.
Yeah, I'm not sure they allege the nexus, Your Honor, in
I'm
these.
saying they have to.
They have to, that's right. And that requires answering some of these questions that we raised. Maybe not every question, Your Honor, right? It's kind of one of those things.
There's a lot of questions.
There's a lot of questions, but you may not have to get all of them, but you got to get some of them to put us on notice. I raised every question that could be asked. Not every question has to be answered, but somewhere, some fundamental aspect, some of those questions have to be answered to put us on notice. And I agree. They could answer some, but not all of them, and they meet their obligation. They haven't answered any of them, Judge. This January 21st, night of rage. How did an individual on a different date that wasn't there conspire or endeavor to have that happen? Well, we don't know. We just have to guess. And so, turning to the overt acts alleged, the category of payments. There's all kinds of these alleged payments that mostly allege Savannah Patterson, Marlon Cox, and Adele McLean reimbursed others for various items with the funds from the Network for Strong Communities.
And given that the money laundering charges have gone by the wayside,
Is this a racketeering act? We don't know, Judge. We don't have to guess because the indictment has to tell us, and this indictment doesn't. And it talks about all kinds of items that were paid for. Forest monitoring equipment, you saw it in the demurrer. Forest monitoring tools, food, gloves, tarps, power packs, deep May tuition, glue, bins, generator, restroom support, tools. I mean, the list goes on and on and on and on and on. How did any of those things further the conspiracy? What's the nexus between a tool and the conspiracy? Between a power bank and the conspiracy? I don't know. It fails to describe how each item was used to further the conspiracy. It fails to describe how the transfer of funds was made. It fails to describe how or if the act was connected to the enterprise, how they furthered the Rico conspiracy. Like I said, maybe you don't have to answer every question, but you've got to answer some. We've got to know what we're facing. And of course, as previously been identified, and who are the unidentified co-conspirators whose identities are unknown to the grand jury. Not only do we not know if it was the three named defendants, it could have been any number of people that we don't know that did these. How do we defend against that, Judge? We can't. Then we turn to the online postings. They generally allege that cops, Patterson, and McLean, and then again other unindicted co-conspirators, posted to scenes.noblogs.org to threaten others. We don't know how they posted the post. We don't know the content of the post. We don't know how it furthered the conspiracy. We don't know who's the target of the threats. We don't know how these posts demonstrate that they intended to cause and induce the alleged target of the threat to withhold record documents and testimony in official proceedings. Is this a witness influencing act, predicate act, active racketeering? I mean, it mentions some of the language from the statute, but it doesn't meet the requirements of setting out all the elements and how the facts apply to them. What are the documents that they're trying to get them to withhold? What's the official proceeding? How's it connected to the enterprise? How did it further the Rico conspiracy? I mean, these questions repeat over and over and over again in this indictment. This indictment raises many more questions than information it provides to us on how to prepare a defense. And then we turn to the quote-unquote night of rage on January 21st, 2023. What's the night of rage, Judge?
What is the night of
Do you
rage?
know what it is after reading the indictment? I don't.
I want to host one
How did these actors join the night of rage?
on Twitch. Let's do it on
It
Twitch.
doesn't. What was the arson that was committed? How was it committed? Again, what were the elements? How did the facts apply to the elements of arson? Is this an act of racketeering? Or is it not? Is it just an overt act?
Does it not appear from the indictment that someone took a hammer to try and break into a building and set it on fire? Now, where the night of rage moniker came from, that's a whole other issue.
I would submit that it doesn't, Your Honor. Let's go to Act 152.
I'm getting there. Yes, 152.
And are you referring to 156? Did possess a hammer while attempting to break into 191 Peachtree Street?
Well, 155, possess an accelerant while attempting to break into 191. Possess a hammer while trying to break into. Now, I don't know how spray paint has anything to do with arson. That's 157.
How's that connected to the night of rage? We don't know. What the night of rage is, we don't know. We don't know what the property damage might be. Maybe it's breaking a window. Say they had a hammer. And then,
As I said, there's perfect, and then there's perfect.
and how is this domestic terrorism, Judge? How does this describe?
That's a different motion.
Well, I mean, it says it right there
Oh, I know.
in 155. Commit the offense of domestic terrorism. How do these facts establish the elements of domestic terrorism? We don't. They don't, Your Honor. The allegations of these facts is wholly insufficient. Had a gas can, had a hammer, some spray paint, attempted to break in. And that's supposed to satisfy the elements of domestic terrorism? I don't think so. The indictment doesn't meet the requirements of adequately alleging these predicate underlying crimes that's required when they allege a compound crime like Rico.
Interesting, it says domestic terrorism would lean more toward arson, but okay.
Is that a racketeering act that we have to be prepared to meet, Judge? Might be, but that's not enough. For me to say it might be, for you to say it might be, for them to argue, oh, it is. The indictment has to tell us. They don't get to tell us. The indictment has to tell us. And these questions repeat over and over and over again. Like I said, it doesn't have to have every fact we want to know, but it's got to give us enough to know how's this domestic terrorism, right? And let's turn to the March 5th event. This is the music festival and the damage to the construction equipment. Many questions arise here. Where did the criminal trespass occur? How were the elements of criminal trespass committed? How did the criminal trespass further the occupation of the DeKalb forest? How was it connected to the enterprise? We don't have to answer everyone. We got to answer some of these. I mean, we don't even know where the trespass was supposed to occur. Was it where the music festival was? Was it where the construction equipment was? Was it both? These are areas where the ownership and ability to exclude people from the land is not clear based on an indictment. And we know that there are areas that the city had under control and areas that the city didn't have under control. Which one was it? How do we know? We can't.
The Rico
How was the
web.
mob organized? How did the mob cause property damage? Where did the mob attempt to cause property damage? These are things that are not in the indictment, but we don't know. And they're set out in detail in the Demurrer Judge, all the different questions that can be asked. But it also talks about domestic terrorism, talks about arson. We need to know the elements. We need to know how the facts apply to those, and the indictment doesn't do that for us. How it was connected to the enterprise and how it furthered it. Then we've got the flyers in Trooper Salcedo's neighborhood. How were those connected to the enterprise? How did they further the conspiracy? There's the forest occupation. Where did it occur? How is it connected to the enterprise? How is it connected to the conspiracy?
Are you looking for GPS coordinates, sir?
Well, I mean, when it comes to the trespass, when it comes to the forest occupation, we need some definition, some description of where they were allowed to be and where they weren't. And this indictment doesn't point us to that. And the questions are the same in the group of the property destruction group of acts. For instance, how does the indictment tell us that by vandalizing a Brassfield and Gorey office building in Cotton County, they demonstrated that they had the intent to cause and induce Brassfield Gorey officials to withhold record documents and testimony in official proceeding? What's the nexus between those two things? What's the connection? We're left to guess. What's the official proceeding? And how do those acts connect to an effort to get them to withhold documents? For each group of acts, the same questions can be asked over and over again because they remain unanswered. In the end, Judge, we're left with an indictment that doesn't tell us what we need to meet. We're left to guess. And that's a result prohibited by Georgia law. And that calls for granting the discretion of honor.
Okay. Before we jump up, I'm going to take 7 to 10 minutes, and then we'll be back. And who's going to the state?
So this one is Dixon is going to continue on this one.
Okay. Take 10, y'all.
All right. And we can time travel, but not before I say, hey, to happily angry lawyer. Did you wake up this morning as an overt act in furtherance of the enterprise? I don't even need to ask what enterprise. Whatever enterprise you want it to be, it will be. But waking up could be an overt act in the furtherance of some type of thing, according to the state. Also want to give a big shout out. What's kind of weird with StreamYard back here, StreamYard does a great job at pinning like super chats and signups from YouTube. But I guess it doesn't pin, I can see your chats from Twitch, but it doesn't pin gifts. And Jenny gifted a membership over on Twitch. So big thank you to Jenny. I'll have to make sure to manually check that because that's super, super sweet. So big thanks there. Happily Angry Lawyer says, I hope so, F 'em. Yeah, I hope it's considered an overt act. Also, can you tell us when you're going to go live? There was the hearing from this morning still. We haven't gotten into it. And really the point of this is it's just so ridiculous. I need to watch this for the second/third time. And I want everybody who would be interested in this, if they stumbled upon it, a lot of you guys watching this today are like, oh my gosh, this is crazy. I wanted to go live to get more people to stumble upon this case because it's ridiculous. It's a hot mess. And Hal is saying maybe around 1. So that would be 4 p.m. Eastern, you guys. And remember, I try not to only think about myself, but when it comes to time zones, my world revolves around East Coast time zones. I get very confused with time zone math. I have to Google and say like current time in anywhere that's not West Coast to figure out the time zone change. So very self-centered when it comes to that. But yeah, so 4 p.m. Pacific will be, and we'll probably redirect over there from here. If you guys want to watch for your second time or you join late, we're just going to keep watching this because there's so much to take in. We still haven't really gotten to the nitty-gritty of what the state actually thinks happened. As Robert said earlier when we pulled it up on the screen, it's just that you take a bunch of stuff, just a mess of facts that are alleged to be associated in a somewhat chaotic manner, and just make it sound so bad that you hope a jury goes, yeah, that's bad, we don't like that, we're going to find them guilty. So, it's one of those things we can't turn away from. We are going to time travel a little bit past this little break. And yesterday, Jim said that when the judge told the gallery they can't laugh, that it's entrapment. I don't know, are they coming back here? Are they doing something? Let me just make sure he's not speaking here. There's no judge on the bench, but what is this guy doing? Oh, he's just yapping over there. So we'll keep going. Any familiar faces? That's one of the defendants here. And I put it in the chat, but the Bortlen hearing is delayed until 2:15 or 2:30 Eastern. So I have that open in another window. All right, judge is back. The judge is bracing himself.
State?
One clarification as this Dixon comes up. You asked Mr. Garland if it's a fair deduction that an overt act that clearly doesn't allege a criminal offense couldn't be a predicate to Rico. And that's not what the state said at some point today. But then, just based on that comment, I want to make sure we're on the same page. The state has conceded that a predicate act must be a criminal act?
No.
No, okay. Good.
Okay.
Judge, first off, let me apologize if I just overspoke.
No, I'm curious to hear this now.
Okay.
So a predicate act doesn't have to be a criminal act?
No, not one of their racketeering activities. And let me, okay, Judge.
And you're basing that on 5B?
Yes, and the case, well, particularly on Dorsey, this Georgia
Yeah,
Supreme Court
slow her
case
down.
that specifically held that. And I know I get to reading too fast at times. I'll try to make sure and let me just read a little bit more and not try to go so fast. Okay. Dorsey challenges, oh, excuse me, this is the Dorsey v. State case.
Right, no, I remember that.
Okay, all right.
That Mr. Samuels vehemently disagrees with, but it's still good law.
It's still good law. And just so that we understand just why Mr. Samuel's so vehemently, and I
Because it's not
understand.
good for his client.
Well, and I mean, I.
Or for Sheriff Dorsey.
Definitely, definitely. But Judge, just to give it some perspective on why, my answer to that is no. Dorsey challenged category 5, which I talked to you before, predicate offenses. Each concerning an act involving murder. The basis for his challenge is that a preparatory act, which standing alone may not be criminal, cannot constitute a RICO predicate. And then it goes on to say it belies that claim. And then it goes on to explain that the under subsection B, 5B, so it's, you know what I'm talking about. It does not have to be a criminal offense.
Gotcha.
Okay, all right. So that's the answer to that. As far as the argument raised by Mr. Bortlen, I'm going to.
But if it is a criminal act,
Yes.
then you have to delineate
Yes.
and put forth all of the elements of that?
If it is a criminal act, you have to put forth all of the elements, all of the essential allegations and elements of the offense within the indictment. Yes, sir. Not within that one.
Even if
count.
it's, not if it's one of the 225 overt acts?
It does not have, okay. So for a predicate act, yes, somewhere in that indictment.
If the predicate act
Yes.
is also a criminal act,
Yes,
then if it is enumerated within the RICO count, it needs the elements of the offense.
the state's contention is that as long as the indictment, read in the whole, sets out all of the elements of that underlying offense.
That's exactly what Kimbrough said you can't do.
That Kimbrough was not a compound felony case, I don't believe, Judge. I don't believe, because that Sanders,
It was a RICO case that dealt
It was a
with
big-
drugs.
but it was not a conspiracy to commit RICO. And technically, a conspiracy to commit RICO is like a doubly compounded case. And I mean, to be quite frank, I haven't read the Kimbrough case since September of last year in great detail, but I have read the Sanders case, which is in 2022, and it specifically states that in compound cases, or twice compounded cases, like conspiracy to commit RICO,
Well, I think Kimbrough's even worse for you because it's not compound. Compound, you got to do it, but Kimbrough says you got to do it in a non-compound case because in Kimbrough, because I read the Court of Appeals one first, read what they did wrong, and then go see what the Court of Appeals tells them they did wrong. And in the case at the Court of Appeals level, they said, hey, see as follows below. Not unlike your page, part 2 on page 49. The defendant committed overt acts to affect the object of the conspiracy, which include acts of racketeering activity as described. See below.
yes, sir.
Okay. Now, this is all in one count. The problem with Kimbrough was that was count 1, and then they enumerated the other counts. You just enumerate them as separate overt acts.
Yes.
But they still wanted, you couldn't read it, specifically they said it's not a read as whole kind of thing.
I don't know, Judge, quite frankly. I mean, I would have to really compare, and we can do that. But what I know is,
We have held that an indictment not only must state the essential elements of the offense charged,
yes,
but it also must allege the underlying facts with enough detail to sufficiently apprise the defendant of what he must be prepared to meet.
yes.
Okay, and that's the English case also as well.
Yes.
And they also kind of get a little upset that the indictment says nothing more, however, about the nature of the alleged connection between the enterprise and the pattern of racketeering. These folks are asking for greater detail about the connection by their special demurs. And this is Kimbrough on page 880. Go ahead.
So, Judge, I don't know where we're.
Where we are was not every predicate act has to be a criminal act.
Yes.
Endorsed.
Yes. And
But if it is a criminal act,
if it is alleged under A, yes, sir. Or domestic terrorism, yes,
if it's a criminal act,
yes,
because it can also be a criminal act, it can be a criminal act under
Yes.
B.
Yes.
If it's a criminal act, you have to set forth the elements.
within the indictment, yes, sir. Or facts. What does this? Let me quote it. The state's position is that
And you're at Sanders.
yes, sir.
All right.
On page 200, and
In order to satisfy due process, when an indictment charges a compound felony, such as felony murder, but here it's conspiracy to commit RICO.
Rico.
The count charging the compound offense, which here's count 1,
Yes, sir.
and the listing of overt acts I insert that, but the count charging the compound offense must contain the essential elements of the predicate offense, or the indictment must contain a separate count charging the predicate offense completely. That didn't happen here. It did as far as the arson and domestic terrorism.
Yes, sir.
But the rest of the stuff, not so much.
Right.
Or the indictment must elsewhere allege facts showing how the compound offense was committed. Okay?
Yes.
So Mr. Garland was up here saying, show me my essential elements. When you say where there's one count where it's just, this is domestic terrorism, I'm going to hope that you will admit that that's a predicate act.
Yes.
Okay, so he wants to know where are the essential elements of that. And let's count.
Which paragraph, Judge?
152.
Oh, I know that one, Judge.
To join the night of rage in Atlanta and cause arson and property damage and thereby commit the offense of domestic terrorism.
Yes. So my answer to the question of where are my essential elements is count 2 of the indictment, which is allowed under Sanders. With that, you said or. So it's either in count 1 or alleges another count in the indictment, count 2, or sufficient facts to show how the compound offense was created. We're under 2 for that.
So you're relying on count 2 for that?
Yes. To establish the, yes, sir, for the domestic terrorism.
Oh my god, what? Guys, why did it just cut to this? What? Oh, that's so painful. Let me turn it down more. Sorry. I was not prepared for it to have the emergency alert without that warning. What? Is this a symbolic representation of the indictment? Oh my god. Are they incinerating it? What is this? I don't know. This is better. Hey, Auntie Joy. Good to see you. Is this the construction site, right? So maybe this is just some breaking news that happened and they cut to it with the wrong feed? What the heck? I don't know. Or is this supposed to be the arson? Usually they have like some type of overlay. Did I miss it? She was queuing this up? What date is this? What date is this supposed to be happening?
How the compound offense was created. We're under 2 for that.
So you're relying on count 2 for that?
Yes. To establish the, yes, sir, for the domestic terrorism.
Because she's just going to start playing
Yes.
it.
Okay, so he wants to know where are the essential elements of that. And let's count.
Which paragraph, Judge?
And cause arson and property damage and thereby commit the offense of domestic terrorism.
Yes. So my answer to the question of where are my essential elements is count 2 of the indictment, which is allowed under Sanders. With that, you said or. So it's either in count 1
Count 2 is the
or
domestic
alleges another
terrorism.
count in the indictment, count 2.
So this is
or
the March one.
sufficient facts to show how the compound offense was created. We're under 2 for that.
Night of Rage
So
or
you're
Day of
relying on count
Rage?
2 for that.
Yes. To establish the, yes, sir, for the domestic terrorism.
But we're still not answering the January question then. Okay, so they're gonna go through this annoying thing, guys, to say that this is what they're talking about. This happened on March in 2023. We're gonna skip ahead to her continuing her explanation of how it's supposed to answer Garland's question.
Are predicate acts,
No, sir, it's not.
and none of them are individually identified as predicate acts. So how is that not leaving it up to the defense to figure out which predicate?
Okay, so it seems like when they share the media, like you see how we're not watching it through the Zoom, we're coming in mid-sentence, but the judge is not having it. It sure seems clear that the judge is not having that. Just having this mentioned somewhere in the indictment is sufficient. Sorry.
Are predicate acts,
No, sir, it's not.
and none of them are individually identified as predicate acts. So how is that not leaving it up to the defense to figure out which predicate acts they need to defend against? Because let's say there's only 5 of them, they can knock out 3. They win, right? Because, well, you gotta have 2 predicate acts.
Yeah, that's what I was thinking of, peach
You only
milkshake.
gotta get 3 to win, okay? Mrs. Samuels,
I did mention that I'm not good at math. Could y'all quit?
I'm mathematically correct, am I not, Mr. Samuels?
You win if you knock out 4.
You win if you knock out 3.
There's still 2 left in here.
No. If there's only 4 and you knock out 3, there's only 1 left. Okay.
I'm lost. I thought he said 5.
So,
Yes, sir.
if they don't know how many predicate acts they have to defend against, how is that not leading them to guess? Because they're going to marshal their energies. Because if somebody bought food, and that's an overt act, they might not give a fat ladies behind about fighting that one. They may say, yeah, my guy bought food.
Yeah.
Okay, so how are they not left to guess which ones are and which ones aren't? Because some of them are crimes, and you're saying, well, it's pretty obvious that this is a crime. But on the other hand, you're now telling the court, well, predicate acts don't even have to be crimes.
That's true.
Under Dorsey, agreed.
Yes, sir.
How are they supposed to know which is which?
Based on the contents of the indictment and the allegations and the statute and how it's defined. And in fact,
And I think if you would have said, hey, this is a predicate act under 5B, this is a predicate act under 5A, Roman numeral, whatever, if you had identified that, instead of leaving it up to them to guess, they would know how many out of 225 are the predicate acts that they've got to marshal their resources for.
I do not disagree that if we had delineated, that it would make it easier and better for the defense.
How about
and
we
for the-
call it perfect?
Well, perfect in the sense that it's not actually required as the state's position. Because they offer no authority whatsoever for the position that the state must delineate or with nomenclature. So there is, and I did look, maybe there's a case out there. If so, I'd like to see it. I have not been able to find it. But there is no authority that the state is aware of or that I have seen cited by the defense that says that to be a sufficient allegation in the indictment, that a Rico count charge must delineate these are predicate acts. And Judge, in that context, there is a case, Brown v. Friedman, 222, Georgia Appeal, Georgia App 213 on page, I'm sorry.
How about just the fact that an indictment has to enable the defendants to prepare for trial? And if they don't know what predicate acts that make up one of the 3 counts, if they don't know which acts are going to get their clients in trouble for that 1 count, how are they able to prepare?
W's for Kyle in the chat.
225. Because, like I said, if there's 5, then they got to knock out 4. If there's 200, then they got to knock out 199. But they're left to guess.
And Judge, I would go back and I'd come back to Brown, but give me 2 seconds to find.
Especially where a predicate act doesn't have to be a criminal act. That makes it even harder to show with just there are no elements to put in there. You know, what's the element of a criminal act? Well, it's not a criminal act, it's a predicate act.
Judge, and I do not have this, the entirety of this case in front of me. However, I think this case is cited by the defense. 303 Georgia App 183 at 186.
Hold on a second. 303 Georgia App.
Yeah, yes, sir. 183 at 186. And in candor, I do not have the entire case before me, but I have a quote from
State v. Bear,
Yes, sir.
2010.
on page 186.
Well, You don't like the first sentence of
No, sir.
186.
I do not.
Which is the state's argument ignores important facts.
Yes. That's never pleasant for a prosecutor to hear.
Right. The test for determining sufficiency of the indictment, is that the language you want me to read?
Yes, sir.
The test for determining the sufficiency of an indictment or accusation is not whether the charging instrument could have been made more definite or certain. Agreed, there's perfect and then there's perfect. Or for that matter, perfect, but whether it contains the elements of the offense intended to be charged and sufficiently appraises the defendant of what she must be prepared to meet, and in case any other proceedings are taken against double jeopardy. So this is the same language we've seen. Yes, this is.
Yes, sir, Judge. I'm trying to find the portion of.
Okay. And then it says, thus, if the accused can admit to all the indictment or accusation or citation charges and still be innocent, the indictment or accusation is defective. That's as to a general demur.
Yes. Yes,
The
sir.
argument Mr. Samuel's partner was making was special demurs, saying, hey, where is it? Because general and special demurs to count one, insufficiency. I don't know which of these, he's saying, he's admitting some of these have criminal elements to them, but they don't satisfy the requirements because they don't have the actual elements in them.
Yes, sir. And
And I don't know whether it's a predicate act or not. It's a criminal act. I don't want my guy pleading to that. But is it predicate or is it just a benign overt?
so, Judge, and I'm struggling, but to locate where in that particular case it says this, but I will assert to the court that there is established Georgia case law that says in assessing the sufficiency of the indictment, that you read the indictment and the allegations contained in the indictment along with the criminal statutes. And so, for example, and this goes into...
Although recitation of the statute may, in certain cases, be sufficient, though not may be a sufficient, though not desirable, method of apprising a defendant of the charges arising against him. Recitation of portions of the statute is not sufficient if, reading the accusation together with the statute, a defendant is unable to determine which of his acts are alleged to be criminal in nature.
So that is one of the cases. So that
Insert the word predicate act for criminal in nature. Because there's a requirement of so many predicate acts, right? 2 predicate acts or 1 domestic terrorism, right?
yes, sir.
Okay. So if a defendant is unable to determine which of his acts are predicate acts, or alleged to be predicate acts,
Yes, sir.
is that not problematic?
I think it is not I'm just going to say it. I think it is not the best way. I think that it would be more clear, but I do not think that it is fatal to not identify them. And let me give you Brown, and I do have a copy of that whole case, Judge. Brown v. Friedman, it's a civil case, and so I understand that it's a Rico case, and therefore has, sorry,
Not for nothing.
yes, sir.
You know how I read all their motions?
Yes, sir.
I would have loved to have read some responses. And as Mr. Samuel pointed out, I had nothing to read from the state on this. Nothing.
Yep.
And it's been,
A long time. 2 years.
Yes, sir.
because I kind of pride myself on trying to come prepared.
Yes, sir.
So what's your Brown site?
The Brown site, Judge, is
Daisy.
222 Georgia App 213. And I'm going to,
There she blows. All of these
What?
cases cited by both sides all have big yellow squares, big yellow triangles next to them.
I will tell you that there was not a single one that I'm citing that you don't look, because it's all distinguishing. So it's,
And it's on other grounds.
yes, it's,
Well, again, all right, I'm on it.
so Judge 217, and essentially the reason I am and directing the court to this is this was not particularly the primary issue in the case. However, in that case,
It's a summary judgment case.
it is a
Okay.
summary judgment case. And Brown contends that the trial court erred in granting the summary judgment to the defendant Friedman on the Rico claim, a Rico violation with a code section, and any subsequent recovery through another code section requires that Brown show an injury, a pattern of racketeering activity. A pattern requires at least 2 interrelated predicate offenses. Here's the important part.
In her complaint, Brown does not expressly allege which of the acts she recites in her narrative of events constitute predicate criminal acts for RICO purposes. In her brief to this court and in her response to Friedman's motion below, she alleges theft by conversion, theft by deception, and mail fraud, which constitute RICO predicate acts. Although she does not specify all the acts which she alleges constitute these crimes, at this point, she is not required to do so. Friedman can ask for a more definite statement. So,
Friedman's not going to prison if he loses.
I said that it was a civil case right off the bat.
That's
And so, but my
Well, it
point
needs to
is,
be
Judge, that that's
perfect.
the only case law.
he was in prison. Friedman didn't face prison if you like.
That's correct. That's
The
correct.
last time I checked, there was no mandatory sentence on him.
Correct. Correct. And it's not mandatory on PC. I was about to say. So,
With the agreement of the state. What, on domestic terrorism?
yes,
On racketeering, it's 5 to 20, but the 5 can be probated.
Right.
I was wondering about
It's
that.
not mandatory prison time, but mandatory splitting hairs. It's not relevant.
There's no mandatory incarceration potential mandatory incarceration for Mr. Friedman.
That's true, Judge. I'm not
Okay, so-
disputing that. It started at the very beginning, said this is a civil case. However, there is no, again,
And at this point, she is not required to do so.
they're talking
Friedman
about,
may move for a more definite statement. We don't have that in the civil arena. What we have is a general and a special demur, and they are doing that. But you're not allowed to amend your complaint. You can't amend your indictment. Which is, so I think that's just easily distinguishable. So I'm gonna close that window.
yes, sir, close that window. It was, and it goes back to, I looked hard, there is no case law that requires that they be delineated. I understand what your point
There
is
is
to the
case law
state.
that says they gotta know what they're defending.
Yes, and,
Lots of.
and the state's position is that when you read the statute, which is a limited number of excuse me, when these lawyers or their clients read the statutes, which defines specifically what racketeering activity is, and it defines which racketeering activity, which criminal offenses can be racketeering offenses, and then it defines in subsection B a much narrower limitation of which criminal offenses, acts, or threats involving those criminal offenses can be the basis of racketeering activity, and that from that, when the state alleges that he participated in, and I don't have one in front of me because I just turned the page, but when there's an allegation in a paragraph in those 225 overt acts, and it says he did X, Y, and Z, facilitating an arson, or and the word arson is used, I think any rational person and reasonable person would know that that is an activity or an action or an allegation of an act or threat involving arson. So, yes, I think
Okay, so then it's a criminal act, right?
it would be under B. So no, sorry, we don't have to allege an arson. We have to allege, under B, we have to allege that they committed an act or a threat involving arson. And so when we say, let me find one, Judge, if you don't mind. Will you find
Please.
one of the paragraphs that mention arson that don't charge arson for me, please? And Mr. Fowler's going to give me an example. Actually, 194, hang on, I may have one. Okay. This is an example, Judge. 24 times, on 194 through 217, alleges that on or about March 5th, 2023, insert name, 24 of the different defendants, did join an organized mob and succeed in overwhelming the police force, thereby aiding and abetting in the offense of arson. And then it's with purpose. So, I mean, with the attempt to occupy and prevent. Any person can read that and say,
Is this the arson that occurred back on January 21st?
no, it's on March 5th, that he did join the organized mob to attempt. So reading it says, look, these folks got together, they organized a mob, they succeeded in overwhelming police and aided and abetted in an arson. And that was on March 5th.
Because the arson that's alleged in the indictment is from January 21st.
January 21st. And that is alleged in a different, there are facts, the facts supporting the overt acts and the racketeering activity is alleged for that particular arson.
Abetting the offense of arson. How are they supposed to know which act of arson they're defending against?
So I don't, first of all, I don't think, that's where we get into, I don't think you have to allege that. It's just like that Dorsey case. Well, while I understand people may want us to have to, we don't.
Is aiding and abetting arson not a crime?
Aiding and abetting arson is a crime, but they are not charged with aiding and abetting an arson.
But
And
it's a
they're,
predicate act that is a crime.
we're not,
Yes.
it's,
The judge's
I mean, it can
tone.
technically fall under A, but that's not how we're charging it. And
We
it-
don't know because you didn't say.
I think it alleges the facts
I think-
necessary to put them on notice that those are actions involving arson. And there are others,
What arson is gonna be what they're gonna ask? Which arson did they aid and abet?
the one on
Because the only
the,
one that's listed is the one on the 21st.
that's the only separate offense of arson. But
Okay.
it is not the only arson that's mentioned because it specifically says on March 5th.
Bortlen
that
signing
aiding and abetting
documents.
arson. They're not separately charged with that, but
Can you show me an overt act in the list of 225 that just talks about arson? Because I'm looking, like I said,
It may be.
205, from 194 on.
I don't know if it uses the word arson, Judge. 2 seconds. Is arson used elsewhere in the overt acts? Can you check? I mean,
Well,
and
again,
I
how are they
know-
not guessing that? I'm not trying to be flip, I'm genuinely curious.
So Judge, to the ones I'm talking about, the 24 that I'm speaking of,
Starting at 194.
starting at 194.
Okay.
I will mention, if we look at Dorsey, I understand the court's questioning and point with regard to that, but Dorsey did reject this idea. So in Dorsey, the defendant was charged with acts involving murder. Murder is also an A offense, under where you're actually charging a predicate act that is a criminal offense. Under A, you must set out all of the elements because you're saying they committed the crime.
Hold on a second. I'm looking at page 541 of Dorsey.
Yes, sir.
Dorsey challenges category 5 predicate offenses, each concerning act involving murder.
Oh, thank you.
I'll keep refreshing on X for updates on Bortlen, but there's no action on camera.
Okay, here's the difference though. I don't think I've heard them say, Mr. Garland, correct me if I'm wrong. They're not arguing that that act can't be a predicate act. They're just saying it's,
Two different things. I understand, yes.
he's not challenging that that can't be a predicate act.
Not at this point, no, sir.
Mr. Garland, is that correct?
We need to know.
He's just saying we need to know.
And if it is, the indictment's got to tell us, not the state. The indictment's got to satisfy the requirements of the elements and the facts that apply to
Well,
it.
and what she's saying is, just like this said, an act involving murder, the state has said an act involving arson and terrorism.
Thank you,
And
Mavka.
domestic terrorism.
And, Your Honor, I could wait till the state's done, but I
Yeah,
can
you
have a
can.
response to the
All right,
Dorsey case.
Go ahead. Go ahead.
So, Judge, the other thing you had asked me for other references to arson, another reference to arson is where one of the, and let me not be vague,
Please don't. Well,
you may want.
because I think that's what most of these folks here are accusing you of right now.
We need vague and ambiguous in the chat.
So the word arson is also mentioned in paragraph 130, which is one of the publishing a post on scenesnoblogs.org, claiming for responsibility for an arson and using that as a way of threatening.
So, whoa. Them being in the forest and joining a mob in March is aiding and abetting
No.
an arson that occurred in Portland on January 1st?
No, sir. I am confused as to what your question was. I thought you were asking me to tell you where else in the 225.
How are they
overt
supposed
acts.
to know which arson you're talking about? Because the murders in Dorsey, there was but one murder. There was but one murder. So an act, a predicate act involving murder. Everybody knew which murder they were talking about. We don't know, they don't know what arson you're talking about.
The allegation is that they attempted the arson on March 5th. So and did acts to attempt.
Dorsey's charged with a murder.
Yes, sir.
One body,
Yes.
okay? Some of these defendants are charged with one arson that occurred on January 21st?
Yes.
Okay, and in March, they're accused of aiding and abetting arson.
There's also accounts in the 225 that pertain to.
Those aren't counts.
Sorry, there are also paragraphs in 225 listing of overt acts, which include predicate acts.
Is there even an arson that is alleged on March 5th?
There's not a separate crime of arson on March 5th.
But yet
because
on March
those
5th, they aided and abetted them.
Yes, because the underlying arson, there is no venue for to bring in an indictment in Fulton County. We could not bring that as a separate account because this court lacks, and this county lacks venue over it as an individual or a separate offense. So we couldn't include it as a separate count.
Okay, because the fire was in DeKalb.
Yes, sir.
I want a pair of snappy glasses so bad.
But our position-
That might be information that they would have wanted to know about. Of this thing got burned up in this place. You may be 100% correct. Can't bring it as a separate account because it didn't happen here.
Yes, sir.
But it puts them on notice as to what they've got to defend against.
And Judge, the only thing that I can tell you is that I'm not going to sit here and argue that that more detail could be provided, that it couldn't be better or more perfect, if you will. What the state's position to the court is that there is no legal authority and there is no case law or precedent or persuasive case law that supports the position that us failing to identify which overt acts that are also included directly and specifically in our indictment as including racketeering activity, that by failing to delineate which are overt acts and predicate acts, there's no case law or authority that says that that is a demurrable flaw in the indictment. That's not.
Sounds like no matter which way I rule, there's about to be case law on it.
It's possible.
One of you is going to take me across the street.
Completely possible.
Think about the appeals court.
So that is my position, Judge, and I do understand what the court is saying. I understand their argument. Why are you looking at me like that?
Just the brow is furrowed, that's all.
Okay. I didn't know if that had said something that you were questioning. So with regard to that issue about delineation and articulation, of which I think I've answered that.
Who's a long one? $50, charity of your choice. Send me the receipt.
Get him.
Supposed to take my son climbing.
All these people have climbing gear.
Real guy Rebecton. Just a reaction wall.
Thank you, Judge. I just need to respond to a few more things. Let me make
Before
sure.
he has to go to Stone Summit.
Excuse me. Oh, never gets done somehow.
Too much. I've already presented that to you. Okay, so there was arguments in the defense made that, for example, anything in claim in part one could be a predicate act, and Judge, I just quickly and bluntly, it just doesn't that lacks basis because it's clearly delineated that it says, and the following are going to be or alleged to be overt acts in furtherance of the conspiracy, and some include.
Yo, you're addressing their concern about how do they know they're going to have to defend against stuff coming in out of part one.
Yes, I'm sorry if I didn't say that well. But there was a lot of things said, and I'm trying to make sure I hit them without dwelling. So I'm trying to begin back at the beginning of their argument, and that is where they started essentially. And the point is that it's very clear and is delineated in the indictment when the allegations regarding overt acts, which include predicate acts, of racketeering activity begins, and that is the language that has been stated, but it's
Okay,
part two.
let me read you the chunk of language before part one.
Before part one?
Yep.
Yes, sir.
The end of, you got count one, racketeering. It's all 61 folk. For said accused individually and as persons concerned in the commission of a crime and together with unindicted co-conspirators in the state of Georgia and the county of Fulton on or between May 25th, 2020 and August 25th, 2023, while associated with an enterprise to unlawfully conspire and endeavor to conduct and participate in, directly and indirectly, such enterprise through a pattern of racketeering activity in violation of 1614-4B, as more particularly described below and incorporated by reference as if fully and set forth herein, contrary to the laws of the state of Georgia, good or the peace and dignity thereof. Part one, the enterprise.
Yes, sir.
So all the facts in the enterprise are incorporated into count one. You stand before me saying, hey, Judge, we're just talking about those 225 acts.
For real.
I'll take you at your word. They can't. They got to take the indictment as written.
Which says introduction, the enterprise, and one of the elements we
It
must
says
prove.
part one, the enterprise.
And then it gives an
A,
emphasis.
introduction.
Yes,
B, defend the Atlanta forest.
yes.
Anarchy background of defend the forest. Beginnings of defend the forest.
All right, we do have some
Public safety
action on
training
camera
center,
for Bortlen, you
Chatterbox
guys.
Studios.
You want to hop over?
Pat County land swap.
All right,
These
they're
all
going to
have facts
start.
in
Let me
there.
pull it up.
Facts, yes, sir.
Okay. That.
We
defend
will
the Atlanta forest
continue.
Overview.
I expect that this will be a quick hearing over, this is in relation to the YNW Melly, YNW Bortlen. Bortlen's we're gonna find out if he's taken a plea or not. So let me get the volume up. Share the screen. Where they offered 16 years. And they're dropping both murder charges if he takes the deal. I'm muted, sorry. Put a 1 in the chat if you think he'll take it. 2 if you think he's gonna decline it. I'm putting a 1 in the chat. I'll start it off. That's a good point, Mavka. Kimberly with the shoe watching. He's got on Jordans. Oh, I'm sure testifying is he's going to be called to testify, Anthony. I'm sure of that. No, there's a deal reducing him down to 16 years. And he's already got like 4+ time served. I don't know the exact math, but oh. YSL Kel said Cop City's hearing today is wild. Can't wait.
That's some pins here.
State, are you ready for me to go on the record?
Yes, Your Honor.
Defense, you ready for me to go on the record?
Yes, sir.
All right. Madam Clerk, are you good?
Yes, sir.
Okay, let me go back on the record. This is on the top of my page 5, State versus Cortland Henry, 19-1871 CF10A and 23-10643 CF10A. I've got Ms. Collins, Mr. Griffiths present for the state. I've got Mr. Haddad, Mr. Nascimento present for Mr. Henry, who likewise is present. So I had set this afternoon, put the deadline as to whether or not Mr. Henry wanted to accept the state's offer or not. We were set to go with jury selection tomorrow morning. So Mr. Haddad or Mr. Nascimento, we're going forward with a change of plea this afternoon. And state, is it the same terms that you discussed previously? Is there anything different?
No, Your Honor, that has changed.
There you go.
So the
There you
plea forms
go.
to me look like on the 19 case as to the 2 counts of accessory after the fact, as well as to all 4 counts in the 23 case. These are going to be adjudications, 10 years Florida State Prison, followed by, that's a 6 years probation.
That's correct, Your Honor.
6 years probation. All counts will run concurrently, all sentences run concurrently with one another. And it looks like there's no restitution in the 23 case. In the 19 case, I'm reserving restitution and ordering it payable. That's going to be to Terry Bagley as well as Ashley Phillips.
Yes, Your Honor.
So now have to
We've spoken to them, and they don't anticipate there being any restitution, but it's Quash.
Okay. Okay, well, I'll give you 120 days to tell me an amount. If there's
Yes,
no
Your Honor.
amount, you won't give me restitution.
They are present as well, too, so argumentns has informed them of that.
Okay.
There's no restitution, they can let us know.
Okay.
As of today, they said there is none.
All right, and state, is that the complete term? That's it?
He's also going to be giving it to Proctor, Your Honor, at a later time.
Well, is that part of the negotiated
Yes, Your Honor.
resolution?
It is.
So tell me how that works. Sure.
Logistically,
Sure, come on up. Madam Clerk, this is not on.
Oh my God. Chad, why are they doing this? Why is this happening today? Oh, they just completely muted it. I'm gonna keep it low. Hey, who needs a soundboard when you've got courtroom built-in sound effects? Yeah, the moon landing soundtrack. And yes, he took the plea. He took the plea. We're going to hear a little bit more, but it seems like they're trying to get their act together. But it's the same. The state said it's the same as what was said in court the other day. So 10 years in custody, he'll get credit for time served, and then 6 years probation. Or is this, they're turning it away? This is them cutting us out from hearing it? Starship Test 10 soundtrack. Crazy. Crazy. Well, we'll see. We'll hang on a little bit, see if they come back and say anything else that we can hear. Oh my gosh. And then the snitching and the rat and the plea deal discourse is going to continue, isn't it? Because the time is ripe. This is the time to talk about ratting and snitching. Okay, so in chambers or a sidebar, we got a little noise. Thank you, Kyle.
Okay, so, Mr. Henry, I'm going to put you under oath, and I'm going to ask you some questions. If I ask you
Turning
something you
it up.
don't understand, please let me know. I'll try to ask you a better question, okay? As loud as you can, so the court reporter can get down all the answers, okay? Raise your right hand for me. You swear to tell the truth, whole truth, nothing but the truth? You can put your hand down. Please state your full name. How old are you? How far did you go in school? Do you read and understand the English language? Are you presently under the influence of any drugs, medication, or alcohol? Have you ever been treated for a mental illness? Are they giving you any medication in the jail right now? How are you feeling this afternoon? Your head is clear? You understand what's going on this afternoon? You understand you're resolving 2 pending felony cases this afternoon? Mr. Haddad or Mr. Nascimento, have you seen or heard Mr. Henry say or do anything which would call into question in your mind whether he understands what's going on?
Nothing at all.
All right, so Mr. Henry, it's 2 cases, sir. I'm going to go one at a time. In case number 19-1871 CF10A, this is before the agreement you made with the state, before the deal you made with the state. You were charged as follows. Counts 1 and 2 is murder in the first degree with a firearm. Those are capital offenses. The maximum and mandatory penalty is life in Florida State Prison. Counts 3 and 4 are accessory after the fact to murder in the first degree. Those are each first degree felonies. The maximum penalty is 30 years in Florida State Prison. In case number 23-10643 CF10A, you're charged at count 1, tampering with a witness in a capital felony. That is punishable by life in Florida State Prison. Count 2, directing the activities of a criminal gang. That's a first degree felony. Again, punishable up to life in Florida State Prison. Count 5 is conspiracy to commit tampering. Again, as it relates to a first degree murder charge, that is punishable by a maximum penalty of life in Florida State Prison. At count 7, unlawful use of a two-way communication device as charged. That's a second degree felony. The maximum penalty is 15 years in Florida State Prison. So, sir, again, before the agreement you made with the state, before the deal you made with the state, your maximum exposure here was life in Florida State Prison, followed by 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 75 years in Florida State Prison. Sir, do you understand all the pending charges and the maximum possible penalties involved? And it's my understanding that you want to resolve both cases today. Is that correct? Yes. And that resolution is an agreement you've reached with the state, the terms of which are as follows. Number 1, in the 19 case, you're going to plead no contest to both counts of accessory after the fact. In the 23 case, you're going to plead no contest to all 4 counts as charged. In exchange for that, the state is going to null process, that is, drop the 2 first-degree murder cases. All right, I'm going to adjudicate you guilty. Yes, sir. What's happening with that?
That would be no problem.
So he's only going to plead to the tampering with a witness in a capital felony, conspiracy to commit tampering, and unlawful use of a two-way communication device?
Just the tampering and the unlawful use.
Just count 1 and count 7.
Correct.
State, you're going to null process count 2 and count 5.
Correct, Your Honor.
As it relates only to Mr. Henry.
Correct.
Okay. So, Mr. Henry, what it's going to be is 2 counts of accessory after the fact, tampering with a witness in a capital felony, and unlawful use of a two-way communication device. In exchange for that, I'm going to adjudicate you guilty on the 2 accessory counts as well as the tampering count. I'm going to sentence you to 10 years in Florida State Prison. That will be followed by 6 years of reporting probation. In the unlawful use of a two-way communication device, that's a second-degree felony. The maximum exposure.
It's a third degree, Your Honor.
It's the second as charged, I believe. It's a third, except as it relates to a capital case. But I'm happy to
Our
look it up.
has it as a third, that we discussed, so.
Well, what did you want the negotiated sentence to be for that?
That was just going to be the maximum time served.
5 years? Is that what you want me to do?
Correct, Your Honor.
Okay. All right, so, sir, as to that count, it's going to be an adjudication of 5
5
years
more
in Florida
years.
State Prison. So the 2 accessory counts as well as the tampering count, those come with 6 years of reporting probation after the Department of Corrections sentence. I'll give you credit for all the time that you've served in both cases. All of those counts will run concurrently. All those sentences will run concurrently. All counts in all cases, that is at the same time with each other. I'm going to have to impose mandatory court costs. I'm going to order restitution payable to Terry Bagley and payable to Ashley Phillips and reservists to the amount. I'm going to give the state 120 days to tell me the amount of that restitution. If they fail to do so within 120 days, there will be no restitution. If they come back with an amount and the attorneys agree on the amount, I will impose that as another condition of your sentence to pay back that restitution. If they come back with an amount and the attorneys do not agree on the amount, I will conduct a restitution hearing. Sir, lastly, and I want to make it very clear on the record, and it's unrelated to this negotiated change of plea, I guess at some point after the fact, the state wants to take a proffer from you or have a discussion with you, ask you some questions about whatever that may be. What I want you to understand, sir, is I guess that's part of this negotiated resolution, but your answers to any of those questions, whatever they might be, have no bearing on me and have no bearing on this negotiated resolution. In other words, the deal you've negotiated is the deal you've negotiated, and that's the ballgame. Do you understand all that, sir? Have you had enough time to talk to your lawyers about all that? They've answered all your questions? You're sure that that's what you want to do? Because I want to emphasize, Mr. Henry, and I'm going to do this again at the end of my plea colloquy, whether you resolve the case by way of a negotiated plea or an open plea to me, or you resolve the case by way of a trial, it doesn't matter to me at all. But due to the resources that have been devoted to this case, I have 250 jurors summoned for jury duty starting tomorrow. So I want to be very thorough with you here this afternoon, because if you wake up tomorrow or the next day and you decide you've changed your mind and you want to resolve this case, both cases, by way of a jury trial, that's not going to happen. All right? If you want to have a trial, the trial starts tomorrow. If you want to accept the deal, you can accept the deal today. But there's not going to be any buyer's remorse, in other words, because I've given you plenty of time to think about this, talk to your lawyers about it, talk to your family about it. I talked to you about it last week. Kind of looks like your lawyers probably did something or other to get a better disposition for you as of this afternoon, but this is it today. So understanding all that, you've had enough time to talk to your lawyers about all that, that's what you want to do? So, sir.
It's your yes.
Has anyone forced you, threatened you, or coerced you into entering these pleas? If I accept your pleas, there will not be a trial in either one of these cases. Do you understand that? If I accept these pleas, there's a whole bunch of constitutional rights you are giving up. I want to make sure you understand all of those rights. You have the right to maintain your plea of not guilty and have a trial in each case. You have the right to present defenses, to file motions and other pleadings in support of your defense. You have the right to remain silent. You have the right to have the state prove you guilty beyond a reasonable doubt. You have the right to confront and cross-examine the witnesses against you. You have the right to appeal any decisions that I may have made up to this point or any rulings I might make in a future trial. But understanding by entering this negotiated resolution today, you are giving up all of those rights. The matter is going to be resolved today, right now, this afternoon. Is that what you want to do? Are you satisfied with your lawyers? Have you had enough time to speak with them? Have they answered all your questions? Are you satisfied with all the work that they have done for you? Sir, I've got two identical plea forms here entitled Plea of Guilty or No Contest to Criminal Charges in Circuit Court. Each one has your name on the top, your initials on the left-hand side, front and back, and your signature on the back. Did you go over both of these forms? Any questions about what's on either of these forms? And is that your signature on the back of each form? Sir, there's a few things that I need to tell everyone that I take a plea from. They may or may not apply to you. If you are not a citizen of the United States, these pleas will result in your deportation. Do you understand that? Under the provisions of the Jimmy Rice Act, if the offenses to which you are pleading are sexually violent or sexually motivated offenses, or if you've been previously convicted of such offenses, then these pleas will subject you to an involuntary civil commitment as a sexually violent predator upon completion of your sentences. Do you understand that? If these are the drug offenses, the Department of Motor Vehicles will revoke your driver's license for a period of 1 year. Do you understand that? Sir, paragraph 11 of each form that you sign reads as follows. I acknowledge that my attorney and I have reviewed any discovery disclosed by the state. My attorney and I are unaware of any physical evidence for which DNA may exonerate me. In other words, sir, if there's any physical evidence in the case that we could test for DNA, that DNA evidence would not tell me that you were not one of the people in that vehicle when these crimes occurred. But actually the opposite would be true. If there was any such physical evidence that could be tested for DNA, that DNA evidence would tell me that you were one of the two people that was inside this vehicle when these crimes occurred. Sir, do you agree with that statement? State, do you agree with that statement?
Yes, Your Honor.
Defense, do you agree with that statement? Mr. Henry, understanding everything that I have talked to you about up to this point, do you still want to go ahead and resolve both cases today, right now? Defense, is he stipulating to a factual basis for the purpose of each plea in both cases?
Yes.
And if he's entitled to a PSI, defense, are you going to waive that as to each case?
Absolutely.
State, is there anything else that you need me to do before I take his plea?
No, Your Honor.
Okay. So, Mr. Henry, again, two cases. We're going to do one at a time. In case number 19, 1871 CF10A, As to count 3, accessory after the fact to murder in the first degree. And as to count 4, accessory after the fact as to murder in the first degree. How are you going to plead, sir? Guilty, not guilty, or no contest? In case number 23, 10643 CF10A. As to count 1, tampering with a witness in a capital felony. And count 7, unlawful use of a two-way communication device. How are you going to plead, sir? Guilty, not guilty, or no contest? I will accept your no contest pleas as to each. I'm going to find a factual basis to support each based upon my review of each electronic probable cause affidavit as well as your stipulation in court here today. I'm going to further find that you have freely, voluntarily, and intelligently waived your rights, that you have knowingly entered each plea with the advice of competent counsel who you've told me that you are satisfied with, that you understand the nature of the charges and the consequences of the plea. Accordingly, and pursuant to the negotiated agreement, I will sentence you as follows. In case number 19, 1871 CF10A, as to count 3 and count 4, I will adjudicate you guilty, sentence you to 10 years in Florida State Prison. That will be followed by 6 years of reporting probation. I will impose mandatory court costs. Pursuant to 943.325, I will need a set of your prints and DNA. Pursuant to 938.27, I will impose a cost of prosecution of $100. Sir, I'm also ordering restitution in that case payable to Terry, T-E-R-R-I, Bagley, B-A-G-L-E-Y, and Ashley, A-S-H-L-E-Y, Phillips, P-H-I-L-L-I-P-S, and reserving as to the amount. I'm going to give the state 120 days to tell me the amount of the restitution. If they fail to do so within 120 days, there will be no restitution. If they come back with an amount and the attorneys agree on the amount, I will impose that as another condition of your sentence to pay back. If they come back with an amount and the attorneys do not agree on the amount, I will conduct a restitution hearing. That will conclude that matter. In case number 23-10643 CF10A, as to count 1 and count 7, I will adjudicate you guilty. Count 7 is a sentence of 5 years in Florida State Prison. Count 1 is a sentence of 10 years in Florida State Prison, followed by 6 years of reporting probation. I will impose mandatory court costs in that case as well. I will not impose the cost of prosecution in that case as I just did so in the previous case. Pursuant to 943.325, I will need another set of your prints and DNA. All of these, there is no restitution in that case. All of these sentences, all counts, both cases, will run concurrently, that is at the same time with each other. I will give you credit for all the time that you have served. State, in 1871 CF10A, your announcement as to counts 1 and 2.
The state will be announcing the null process to those counts, Your Honor.
And in case number 23-10643 CF10A, state your announcement as to count 2 and count 5.
The state will be announcing the null process to those counts as well.
Okay. I think that concludes all the matters. State, is there anything else that you need me to do regarding Mr. Henry in either case?
Judge, if we just have one moment.
Oh, one moment. What's left?
I'm looking at the plea forms, the 23 case, they have 707 days credit for time served. In the 19 case, 1,340 days credit for time served.
Nothing else, Your Honor, can be just have in order for you as well.
So listen, my the fee hearing docket is at 3:30 p.m. So
We've already spoken with BSI, I think we're just in an order, because we're about a week.
okay. I mean, I was going to make it available if you wanted to do it now.
I think BSI is probably that.
Okay, well, they're in charge.
Coordinated with us.
Yeah, of course.
Thank you, Judge.
Anything else from the defense on behalf of Mr. Henry?
No, Judge.
All right, Mr. Henry, I'm not quite sure how your lawyers managed to do this, but I wish you good luck, sir. Yeah, he'll be on, Mr. Nesmith and Mr. Haddad. We'll have a probation officer here tomorrow. He'll be on my docket tomorrow morning for the instructions on probation. So I will sign all the paperwork if you want to stick around for that.
All right.
We're otherwise going to be in recess till 3:30 p.m. The fee hearing docket starts at 3:30 p.m., so I'll be in a recess until then.
So we'll jump back over. And I also just dropped Bryson Paul's link in the chat. It's his X account, but anytime there's new filings or any type of updates in the YNW Melly, and he was doing Bortlen updates as well, but those will probably trickle out. Really, really tons of good information from Bryson Paul. So if you use X, make sure you give him a follow. It's a great way to stay up to date with the YNW Melly case. And I'm sure he'll have some updates in the next few days because this plea just happened. So, but yeah, to summarize it, you guys, his sentence is 10 years in custody, 6 years probation, but he got credit for his time served. Because, I mean, this all happened like 5 years ago at this point. So he's got 5 more to serve in custody. And we heard him agree that he was in the car when this all happened, and he's going to sit and he's going to speak to the state about what he knows. And we just have to wait and see if we find out what that is and what they bring into trial against Melly. So that wraps that up. We're going to get back over to the Stop Cop City Rico. Again, we're finishing out the hearing from yesterday. Then we're going to catch up with what happened this morning over in today's hearing. Let me make sure the captions are still good. And it was a global resolution too, by the way. One last thing for Bortlen. It was 2 cases that were being resolved. So, but whatever it is, they did their calculations to figure out his time served to credit him.
Defend the Atlanta Force funding. Now, then we run into the whole money laundering issue. Communication. Talking about Signal, Telegram. Entity amount totaled $48,000. Occupation inside. There are facts, and yes, obviously we're going back to however many centuries. That's a little different than, hey, propaganda and recruitment. Are they going to have to defend against this?
Defend against it in the context of an overt act?
In the context of, is there an enterprise? Did they use these things to build an enterprise? Is there indeed an enterprise?
Then yes, Judge, any and all evidence we have at our disposal to establish and to show that this group of individuals were associated in fact and that they had a common purpose to commit racketeering activities, any admissible evidence to prove that, absolutely, they should be prepared to defend against it. If it's not admissible, the court will say that, they don't have to defend against it. But as far as whether there was an enterprise, 100% the defense should be prepared for every single fact that we can use to establish the association of this group of people, how they were funded, how they recruited, sure, we have to.
But none of that.
Yes, Judge, it is in there. Recruitment, let me let you finish your sentence, excuse me.
I'm now into your 225.
Well, now that's a separate issue, because all of that goes to the enterprise, and the indictment clearly delineates that Part 1, I think is how it says, under count 1, elements of conspiracy, then Part 1, the enterprise. It is defining the enterprise, describing the enterprise, whether eloquently or with violent political rhetoric, depends on who you talk to, but regardless, the bottom line is, in fact, that is where the indictment says each individual charged in this indictment knowingly joined in the conspiracy contained a common purpose, so it fully lays out everything. And while I'm here, it also lays out the nexus. It affirmatively avers that, and I think I've said this, but I'll say it again, defendant in the Atlanta Force is a self-identified coalition and enterprise, blah, 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 and that organization coordinates, advertises, conducts direct action designed to prevent the construction of those things and promote anarchist ideas. This self-proclaimed direct action has included, and then it lists the various things, vandalization of private property, arson, destruction of property, tax on law enforcement. Anyway, so the point is, while I'm there, that is the nexus. It affirmatively argues the nexus. And then we get to all of the other things that are alleged about it, the description, because we must prove and allege enough detail to establish the enterprise. And Mr. Fowler's already talked about why the history and things of that nature are.
So are they going to have to defend against masked folks making statements? That was raised by the defense.
If it's admissible, yes, and the state is going to say that some of those things are admissible, yes, sir. If a co-conspirator that we can establish, our co-conspirator, produces propaganda that talks about different things about this conspiracy, and I know people threw out the confrontation clause, in no way is it testimonial, in no way. So if we can establish, because it's not testimonial, because it's not made, this is well before any type of arrest or prosecution, so there was no possibility that it was gathered for the purposes of litigation. If we can meet the elements of admissibility, that's the reality of it. But that's true to any situation, Judge. The state is going to use any and all fact that the state believes and can show furthers its proof of various facts in the case. And if those are admissible, yes, they should be. Now they're going to argue that they're not admissible. We will argue that they are, and the court will decide what comes in the end. But yes, any and every piece of evidence we have that establishes, well, for one thing, when it began, when the conspiracy started, when they started making plans, when they began the occupation of the force, all of those things for the very reason of what we've been arguing about today, for one thing. It all becomes relevant. So that is part one. And to go back to how they know that part one's not is because part two says it. Part two delineates and specifically says that they committed, you see it, the defendants committed overt acts to affect the object of the conspiracy, which include acts of racketeering as described below. So, and this is no offense to anybody, but I think it's disingenuous to say that, or it ignores the language of the statute, let me say that, or the indictment itself, to say that we don't know whether or not the part one is also the overt acts and the predicate acts, because the indictment, while it could be better and it could specify which one of the overt acts are racketeering activity, definitely it could, and it doesn't. It does delineate what acts we are saying are or could be or they might have to defend against. And then when you look to the statute, it is further limited. Not every act is going to, for example, the money transfers. Those are overt acts in furtherance of the conspiracy, allegedly. That's what we say they are. However, that in no way falls within any definition. It doesn't fall within the statute. It's not an arson. I mean, it's not related to arson. It's not related to murder, robbery, kidnapping. It's not an act or threat. It's not with one of the statutes.
God, she's moving so fast.
One of the crimes under the 5A. And so, no, I mean, but it does require that analysis. So the state's position, Judge, is what I've said. And then as far as whether or not there are other aspects, one of the things that they have alleged is that we have not drawn enough, or we haven't alleged, and they say it in different ways, but one of the arguments is, and Mr. Samuel said it, and I think it's been said multiple times, is they don't even say for example, they don't say my client did an overt act, or did a predicate offense. He or she is not charged, it's not charged in this crime or that crime. And I'll just say, Judge, we don't have to allege or prove that, we'll go back to Mr. Liberto since he's been the star of the day, that Mr. Liberto or any particular defendant charged in this indictment, we do not have to allege or prove that they ever committed a predicate act or that they ever agreed to commit a predicate act. And bear with me, Salinas v. State, and I know I should have agreed, Salinas versus United States. And that is 522. And I do have a copy of any of these you want.
522.
U.S. 52. Figure out what page that is. 1 second, Judge. I need to direct you to the page.
To be fair, this is like a tiny little place to have your paperwork.
Don't have it. Sorry, Judge, for the delay. Another yellow distinguished case. Just want to make sure I reference the correct page number. It's going to be there. It's going to start, Judge, I think on 60.
to get to the correct quote. If conspirators have a plan.
My gosh.
So,
Find it.
Okay.
so there's a portion of it, Judge, that quotes to United States v. Holt, and that's 236 U.S. 140. And the Salinas Supreme Court says, if conspirators have a plan which calls for some conspirators to perpetrate the crime and others to provide support, the supporters are as guilty as the perpetrators. As Justice Holmes observed, plainly, a person may conspire for the commission of a crime by a third person. A person, moreover, may be liable for a conspiracy even though he was incapable, of committing the substantive offense. And that's cited to
Page six, I don't see that on page 62.
I may be on page, let me find it. It's in there.
Conspiracy may exist even if the conspirator does not agree to commit or facilitate
Yes.
each and every part of the substantive offense. The partners in the criminal plan must agree to pursue the same criminal objective and may divide the work. Each is responsible for the acts of the other.
Yes, sir.
If conspirators have a plan which calls for some conspirators to perpetrate the plan and others to provide support, the supporters are as guilty as the perpetrators.
Yes.
Plainly, a person may conspire for the commission of a crime by a third person. A person, moreover, may be liable for conspiracy even though he is incapable of committing a substantive offense.
That's page 63 to 64, Judge. So yes, sir, I apologize. And continuing on, in that same case, Judge, it rejects the concept, in fact, they argue in this case that we should have to prove that connection, that each perpetrator or each defendant, was required to have participated or intended to participate to engage in or commit racketeering activity. And the court directly rejected that. And let's see, on page 65, towards the bottom, it says a conspirator must intend to further an endeavor which, if completed, would satisfy all of the elements of a substantive criminal offense under the federal statute, which is different from ours. But it suffices that he adopt the goal of furthering or facilitating the criminal behavior. He may do so in any number of ways, short of agreeing to undertake all of the acts necessary for the crime's completion. One may be a conspirator by agreeing to facilitate only some acts leading to the substantive offense. It is elementary that the conspiracy may exist and be punished whether or not the substantive crime even ensues, because conspiracy is the distinct evil dangerous to the public. And this is where it, in the state's opinion, has particular pertinence to their argument. It says it makes no difference whether that the substance offenses under the federal statute requires two or more predicate acts. The interplay between subsections C and D does not permit us to excuse, that's the conspiracy aspect of it, does not permit us to excuse from the reach of the conspiracy provision an actor who does not himself commit or agree to commit two or more predicate acts requisite to the underlying offense. So again, addressing the argument being that we had to allege in our indictment that the defendants either agreed to commit acts, predicate acts, or did commit predicate acts, that's incorrect. We do not have to make that accusation in the indictment. We do not have to allege that. We do not have to prove that. As long as they knowingly joined the conspiracy, and the conspiracy itself has the common purpose of committing racketeering activity. And I quoted that to you earlier, or cited that to you earlier. In addition, I cited Thompson v. State to you earlier, which also supplies further makes the state's argument even more secure or more definite, because it does not require, that's the case, Judge, that if you recall, and this is an important thing, we don't even have to prove that they had every knowledge, were involved in everything, that they knew all the facets of it, that they knew what all of the co-conspirators were going to do. As stated, what we must prove is that they intended and knowingly joined the conspiracy, and that the conspiracy had the common purpose. And that's what we have to prove, and we have explicitly alleged that in paragraph A of the introduction. So, as to that argument from the defense, it just doesn't pan out, Judge. They also argue that the criminal purpose to commit
that we have to allege and prove that the enterprise had a criminal purpose, and that, I don't know how much this was fleshed out in oral argument, but I saw it in the written, that the enterprise must have a criminal purpose, and that's just not an accurate reflection of the law. The law that I have cited to you already and read in court already explains that an enterprise isn't a crime itself, and that it doesn't have to be criminal. I mean, the enterprise, this grouping of individuals associated in fact, can be, in fact, illicit or illicit. So, and their activities can be illicit and illicit. So the enterprise itself does not have to be a criminal, does not have to have a, in other words, they have to have the common purpose of committing, we have to prove, and we have alleged.
Wait, illicit versus illicit. Illicit is, we've incorporated, defended land of forest, we are an enterprise. Illicit is, we're just a group of folks. There still has to be a criminal intent there.
Not in the joining, not, they have to have a common purpose. And yes, as a group, as an enterprise,
And as long as that common purpose is a legal, legitimate thing, that's okay, right?
until this group of associates conspires and determines to, or agrees to commit 2 or more predicate acts to reach their objective. Yes, then now we're getting into the Rico, and that's what's alleged.
So they commit criminal acts.
Yes, yes, sir. Took me a minute to get there, but yes, sir. So I've already talked about the nexus. I've already talked about that. If you'll give me 1 second, Judge, I want to make sure. There's a lot of there's a lot of argument, and I've read the and I'm not going to go through every single one, but there is a lot of argument about there's not enough here, there's too much there, there's not enough here, there's not enough there. For example, night of rage, or whatever it may be. The reality of it is, Judge, we have to
night of rage,
the elements of the offense, which obviously for the last several hours I have been arguing that we have. We do not have to allege every fact that they want to know. We do not have to allege how we are going to prove something. We do not. That is we give it, we allege the elements enough so that they understand what's coming against, or that the charges against them, and that's really the point. And the
you saw how she had to add an extra description here. We allege the elements well enough that. Are we getting there?
Charges they're going to have to defend against. And then the discovery, it shows them the evidence we're going to use. How we're going to use it and apply that evidence, what we're going to argue, what our internal mental thought processes are on prosecutors as to what evidence pertains to this and how we're going to prove that, that is simply not required in an indictment. And to give you an example, night of rage. They came down here for a night of rage. If we had gone into the definition and explanation and all the explanation about what a night of rage was, one, it would have no bearing on the fact that that was the overt act was alleged that they came down on a night of rage, which the evidence will explain at trial, and they did X, Y, and Z.
Shout out to Flesh of the Gods rating us
paragraphs talking about
with the night of rage raid.
Night of rage and where it came from and how we know they called it and all the calls to do it and all the things that different co-conspirators, named and unnamed, put out there on social media to stir up and stir violence. Then we have been talking about political violence again, or rhetoric again. So it's not necessary. We made an allegation of an overt act in furtherance of the conspiracy, and that's what we did. And there's no more detail that they're entitled to on those type of issues. So let's see what these.
I'm going to search for night of rage events.
And Judge, I'll give you one last little example. I mean, I need to wrap it up, but the many things that they think they want to know are simply not required to be alleged in the indictment. I'll give you an example. Criminal trespass.
This isn't their argument.
It says that so-and-so did commit a criminal trespass. And there's a lot of motions filed and people arguing about that. He's not charged with criminal trespass. It's listed as an overt act. Criminal trespass is not one of the offenses under 1614.3.5a. So it's not a criminal offense. It's not a racketeering activity under B. And so it's simply a statement, okay? Now, that he committed this in furtherance of. Could it be more specific? Sure. But is he entitled, because we use those words, to a full recitation of the elements of the offense? The state says no, because he's not charged with the offense. If we were charging with criminal trespass.
But you couldn't charge him with the offense because it happened in DeKalb County.
True, but we're not. So we have not alleged criminal trespass in our indictment as a crime, and therefore, and again, what we're talking about is what is demurrable or not, or whether the indictment is valid or not. And that is not a valid basis to invalidate the indictment in the context that he's not charged with it. So the requirements that we set forth, every element of it, just does not pertain. We generally said that he committed a criminal trespass.
All right, chat. We need to go on a group trip. We need to go on a group trip to Pitchfork Pumpkin Patch. They're doing a rage night. Sorry if you're under 18. It's adults only. This is in Royce City, Texas. It's time for a night of smashing stuff, paintball, tacos, margaritas, and trivia. So there we go. There we go. Nights of Rage, Night of Rage.
Now, they can argue whatever they want to the jury at that point, but that is one example. There are many others, but I think the court gets the gist of my argument, which is the details that are necessary, the details that define and prove, or allege, not prove, allege, with sufficient particularity that the all of the elements, Mr. Garland did an excellent job of articulating those elements, that the indictment has done so, and that while it could be better, it is sufficient.
Okay. Your motion, Mr. Garland. You're up.
Not a PowerPoint. All right, Garland is back up. Let me change my banner.
Okay. So even if we were to concede, which we don't, that the allegations of arson and domestic terrorism on January 21st satisfy general demurrer, that does not save this indictment from my special demurrer.
This counts.
What?
This count or this indictment?
Doesn't save that. Even if that was enough to save the indictment from a general demurrer, it doesn't save it from a special demurrer, because the special demurrer doesn't identify those predicate acts in any way, and it doesn't tell us.
Are we talking about counts 2, 3, 1?
Counsel with respect to
Mr. Schwartz, he's up.
Counts
You
after.
delineated him. He's your guy.
Yeah, no, I understand what you're saying, Your Honor. There's counts 2 through.
There's 2 and 3. There's 1, 2, and 3. That's all we
Yeah,
got.
so counts 2 and 3, which allege arson and domestic terrorism.
Yep.
There's an argument under which those could.
Right now, we're talking about count 1 in this motion. Motion number 3.
Okay.
Right?
I'll abandon that because it's not essential to what I'm trying to convey. Is that this indictment fails a special demurrer. State v. Eastman tells us
Count 1, because that's the motion I'm looking at. Count 1
one of this indictment
does
fails.
not survive a special demurrer.
That's correct. And this is State v. Eastman, 911, Southeast 2nd, 484. It's a 2025 case.
Yeah.
By filing a special demurrer, the accused claims not that the charge in the indictment is fatally defective and incapable of supporting a conviction, as would be asserted by a general demurrer, but rather that the charge is imperfect as to form, or that the accused is entitled to more information. That's what I'm focused on, Your Honor. The state, in the information we need, is set out in OCGA 17-7-54 and by Kimbrough. We've got to have the essential elements. It's got to allege the underlying facts with enough detail to sufficiently apprise the defendant of what he must be prepared to meet. And it must allow the defendant to prepare her defense intelligently. So they've got to allege that. They don't necessarily have to do it as a separate count in the indictment, but they've got to do it in the indictment. They can't get up here and argue that they're somehow met. It has to be in the indictment. They've got to allege the essential elements and the facts supporting them. And they failed to do that for many of the potential predicate acts that we've discussed today. Assault, influencing a witness, obstruction, money laundering, and whatever other predicate act the state can dream of.
Can you help me on the quote on the site for Eastman again?
Yes. 911, Southeast 2nd.
No, give me the Georgia one.
Okay. 374, Georgia app.
Yep.
120.
Oh, I wasn't even close.
Would you like me to pause, Your Honor?
Yeah, just
Okay.
sorry.
And that's at page 121.
Okay, so you're saying, hey, these predicate acts are criminal acts, I need my elements, et cetera, et cetera. Whereas I just heard from the state saying they're not charged with those. They don't have to give them the elements of them.
Well,
Because they're not charged with them because they happen in another jurisdiction.
I think that's a red herring, Your Honor. I mean, Kimbrough and OCGA 17-7-54 are clear. We've got to state the essential elements. We've got to establish the underlying facts, right? It's required by Georgia law. It doesn't have to be in a separate count. It could be in the overt acts themselves. They could set out the essential elements. They could set out the essential facts, but they don't do that, Your Honor. They don't do it for assault, influencing a witness, obstruction, money laundering, and whatever else they can dream up. The discussion of Dorsey and these 5B acts, it's not a red herring, but they're putting the emphasis on the wrong syllable in that case. These 5B acts are acts involving murder, kidnapping, gambling, arson, robbery, theft, so on and so forth. The list of crimes listed in 5B that could involve predicate acts involving those crimes. But Dorsey's interpretation of 5B is really just about how we count the predicate acts. It talks about acts, that the acts involving style of predicate acts can be their own separate predicate acts. So a series of acts involving another crime, can all be separate predicate acts, right? So in Dorsey, you've got the murder, right? That's one act. But then getting in the car, that's another act. Buying the gun, that's another act. These are all predicate acts under 5B. But what Dorsey has, that this indictment fails, is an allegation of the essential elements of the murder. Is an allegation of the essential facts supporting those elements, right? Dorsey is like, how many predicate acts are there in a murder, Judge? Well, we've got the murder, and then we've got the other acts involving it. But you got that murder. It's proved, it's alleged. The essential elements are alleged, and the facts supporting it are alleged. We've got it, right, in the case. How do we chop it up? That's what Dorsey's about. Here, we don't have the essential elements. We don't have the facts. There's nothing to chop up. We don't know what these acts are involving. They haven't identified them. They haven't set out the elements as required. They haven't set out the facts supporting it. So Dorsey is not a problem for this demurrer. Had my complaint been there's too many predicate acts, well then Dorsey would be a problem for us. But that's not my complaint. Is that they haven't sufficiently alleged the predicate acts at all. And they clearly did that in Dorsey without a problem. They established elements. They put the elements of murder in and the facts supporting them. So it provides no problem for our special demurrer. There was some discussion by the state about the allegations in Part 1 of the enterprise. I've already discussed how it's both overbroad and lacks sufficient details, but as we've discussed, are those allegations of predicate acts because they're specifically incorporated into the overt acts that include the racketeering acts per the indictment? Does it include George Floyd? Does it include Rayshard Brooks? Does it include the masked man was he involved in an act involving felony obstruction? We don't know. We can't know. The indictment doesn't tell us. And in regards, let's see. And there are certainly things that this indictment doesn't allege that I want to know. And it doesn't have to allege everything I want to know, Judge. But it's got to get across some fundamental threshold so I can prepare a defense for my client. This indictment is a problem with the state's creation. It suffers as a result of how they drafted and indicted it. Georgia law prevents my client and all the other co-defendants from having to fight for their liberty based on an unintelligible indictment. And we ask Your Honor to grant you such honor.
Unintelligible.
All right, ladies and gentlemen, it is 4:45.
All right.
See you tomorrow. Before we go,
Amanda, a few words.
I know Mr. Days and I, you were making some noise over there. Well, I want to do something next. It was my intent. Number 4 was the back to prosecutorial authority.
Your Honor, I can wait till number 10. We're listed for number 10.
We'll go over to today. Again, and I want to recommend to everybody, we're doing a catch up, and really a huge reason of why I'm doing this stream, even though I watched this, not the hearing that happened today, but I watched yesterday's hearing already. But I wanted to do a stream because it was like 100 of us hanging out having a good time instead of the usual. Like, I feel like a lot of you didn't know about this case, and I think it warrants our attention. I think it's something that you guys would be interested in based on how you guys reacted to the YSL trial. But I won't be able to cover live real time every day. And whether or not you want to watch with me or without commentary, I'm going to keep, if you can, if you want to support monetarily, if you just want to watch their streams, the Atlanta Community Press Collective, they are providing access and giving, you know, content that lets us know what's going on with not just Cop City Rico, but other cases as well. So I just dropped their link again in the chat. It's in the description of this video. Wanted to do that reminder before we get caught up watching what happened today. And then Happily Angry Lawyer, we're going to be redirecting over there when we get through this. Again, if you don't want to listen to me, you want to wait for an actual attorney to give his commentary with, he's way funnier than me too. Jim is hilarious. He will be going live in under an hour now at this point, but we'll redirect over there. I'll be watching things twice to see his reaction and insights as well. Crap, I thought I had his link up. I closed like 800 tabs, and he must have been one of them. Jim says, I'd rather listen to you. We're going to do that Wii Sports meme with the tennis players going, no you, no you, no you, back and forth. So, and let me see, do you actually have it scheduled? All right, let me link. I just linked to Jim's channel. Oh my god, look at the thumbnail, guys. Let me show you the thumbnail. So this is the direct link to the stream. Oh my goodness. Hilarious. So there we go. Without further ado, and unfortunately no closed captions have loaded yet. If you're on Replay Crew, usually this video, like YouTube will generate it for my video and put up closed captions for you. But currently there's no closed captions for this one, so sorry. But if YouTube doesn't get it for the live stream replay here, I'll run it through my program that I use for work and upload subtitles for you guys. So I always check that with like an hour, 45 minutes or so after the stream publishes. That way everyone can hear what's going on. Or read what's going on. Oh, and volume boost. Let me turn it down in case it's really loud.
Mr. Mariscano. There we go. We have Mr. Polly. Sir.
Doing a roll call.
Absolutely not least. Still there. They are all accounted for, Mr. Fowler. Okay.
We love both of you.
Yes, Your Honor, stage right.
Okay, let's see that one thing stage on. I'm on perfect. Okay, the next motion we have is, this is Mr. Carroll's motion to dismiss the Quash indictment / plead indictment for lack of prosecutorial authority. Very interesting read. Mr. Schwartz?
Was it good, Judge?
It was a very interesting read.
Mr. Hall,
We'll find out.
Mr. Hall, Mr. Finley, take credit for that. Mr. Hall will be arguing.
Mr. Schwartz has the best ghostwriter around. What do we have, sir?
Good morning, Judge. Andrew Hall. I, along with
Oh my gosh. Sorry, this has been an all-day thing. We'll turn that down a little bit. Judge is quiet, but this guy is not. He is booming.
Finley Center represent Tom Jurgens. Mr. Francis Carroll, through his attorney, Mr. Michael Schwartz, has kindly agreed to allow me to present the argument with respect to this motion to the court.
And just to save you a little time, Mr. Hall, I have read the motion. I understand you're saying didn't get a letter from the governor, gang and domestic terrorism, legislature gave the AG authority to do so, did not do so in Rico, get rid of the judge.
Right.
Okay.
And so I guess to cut the chase then, I mean, because
I'm a big fan of that.
I'm here in the morning and hear Your Honor quite clearly. So kind of fast forwarding just to set things up, as Your Honor's already noted in reading the brief, under the Georgia Constitution, the district attorney is the constitutional officer who generally has authority to prosecute criminal cases in Superior Court. In contrast, under the Georgia Constitution, from our perspective, that's the important part of this, is the constitutional limitation. The Attorney General has limited constitutional authority to prosecute criminal cases. And there's 3 instances the Constitution contemplates. Supreme Court for capital felonies, not applicable here. Skip on by that. In all civil or criminal cases in any court required by the governor, as your honor has already noted. Well, I'm unaware of that existing. It certainly was not pled in the indictment. It's certainly not part of the record of this case. And then the last one is shall perform other duties as shall be required by law. Georgia Supreme Court has said is that as shall be required by law means as required by the Constitution or the statutes of Georgia. So, fast forwarding, the Rico statute does not grant the Attorney General concurrent jurisdiction. As your honor noted already, some statutes do grant that authority. Domestic terrorism is an example. Gang statute is an example. Or maybe other ones. I just use those as illustrative examples. But the Rico statute does not. Now, that's not the only way that the Attorney General can prosecute a case. What I would refer to as more colloquially as statutes of general or general statutes granting jurisdiction to the Attorney General. And those are mostly found in Title 45, 45, 15, and 3, and 6, and 18, and 10, and different ones along there. So most of those require the governor, again, back. The legislation comes in the constitutional limitation that all civil cases and criminal cases require the governor's authorization and has expanded that in some ways. That's a lot of that last provision of the Constitution. And so in civil cases, the Attorney General enjoys a lot further latitude in representing the state in cases and pursuing civil cases. Criminal cases still largely limited by the governor's authorization. Right? The one that I'm going to focus on, since we're jumping to the meat, at least what I believe is going to be the issue for the court to decide, is OCGA 45-15-10. Right? And that statute authorizes the Attorney General to prosecute a criminal case without the governor's authorization when the defendant violates a criminal statute. And this, in my, I respectfully submit, is the key language here, quote, while dealing with or for the state or any of its officials, employees, departments, etc., etc. What I submit to the court is the court's decision is going to turn on what does, quote, while dealing with or for the state mean. It's a specific criterion. The way I'm reading it, and the way I would ask the court to read it, is the defendant must be, quote unquote, dealing with or for the state when he or she violates that criminal statute. It does not, I submit to the court, simply mean relating to the state or pertaining to the state. The legislature could have said that. Much more of a term of art that they're using. So it's while dealing with or for the state, which means that the defendant could be either side on what appears to be some kind of relationship equation. The defendant could be dealing with the state and being on one side of that relationship, and the state or the state entity is on the other side of that relationship. And in the course of that dealing with the state, commits a criminal violation. That would authorize the Attorney General to get involved. But the or for can easily get skipped. But it's a complete phrase. It's dealing with or for. And the or for, I respectfully submit, means that the defendant could be dealing on behalf of the state. So in the relationship equation, the first one was defendant one side, state the other side. This one, defendant's over here dealing for the state in some kind of relationship equation. In that situation, the Attorney General can also get involved. It would suggest, I think, and strongly support that there's an ongoing relationship, and during that relationship is when the defendant violates the law. I'll pause. I'll tell you right now, if Your Honor, at the end of this, when we look at it, you decide, no, this means relating to or pertaining to, right? Which is what I say it does not mean. Right? But that's all it means. It's a much more broad, expansive jurisdiction for the Attorney General than we believe is supported by the statute. But that, to me, Your Honor, is fundamentally the issue that the court's going to have to decide. And we know from when interpreting a statute that the court will start with the plain meaning of words as they're commonly used and understood. So, in looking at Black's Law Dictionary, dealing means, and I quote, this is the 6th edition of Black's Law Dictionary, means transactions in the course of trade or business, close quote. According to Merriam-Webster, dealing means, quote, method of business, manner of conduct, and dealings in the plural means friendly or business interactions. These definitions, both from Merriam-Webster, which is commonly recognized as an authoritative source for the English language, as well as Black's Dictionary, that again is commonly recognized by courts and jurists and lawyers as an authoritative source for interpreting meanings of words. None of it's definitive, because the Georgia courts have also taken a look at it in this context, but certainly persuasive, I would submit. All of them are consistent with the phrase, dealing with or for the state contemplates some sort of business or transactional interaction between two persons or entities, and it's during the existence of those dealings the defendant violates a criminal statute. It is not, I think this is important, that the dealing with or for the state is in and of itself a criminal act. Right? It presupposes that some kind of relationship exists in some form or fashion. Now, legal research I've done, I don't know if I should say surprisingly or unsurprisingly, but it's neither here nor there, there's not cases that decide this issue that I have found, right? There's not really much case law out there at all. Right? One case that I have brought to the court's attention in brief is Brown versus State, 177 Georgia App 284. Right? It's an example of an employee of the State Department of Labor who was prosecuted by the Attorney General for obtaining fraudulent payroll checks. That seems to be an example of someone dealing with the state, although as an employee, perhaps it was dealing for the state. The Court of Appeals does not address that language. Principally, the Court of Appeals does not address the language I submit because the record in that case reflects that the governor had authorized the prosecution. And again, when the governor authorizes the prosecution, then there's no motion for this. This motion doesn't exist, right? Once the governor authorizes the prosecution properly, then the Attorney General allowed to go forward. We're here because there is no governor authorization, and so now we're looking at the meaning of statutes, and really the one statute that may permit, or that I believe the state will argue permits it to proceed without governor authorization. We would submit it does not. Another case that's cited in the Brown case is Meredith versus State, 148 Georgia Appeals 853. It's another case, this one actually involves a private citizen, but it's another case in which the governor authorized the prosecution for the Attorney General. So although dealing with this issue in some form or format, it doesn't deal with it does not address the specific language of the statute that we're looking at, because in both cases, the governor had authorized a prosecution. So in preparing for this hearing, I then started looking at some other statutes that may have similar language to see if I could find anything that may aid the court, may aid all of us in deciding how to look at this issue. Right? And there's a couple cases I've come across that, as an officer of the court, I want to bring to the court's attention. I'm not sure that either one of them provides us much in the way of dispositive information, but I think, Judge, in looking at this issue, if I know about the case and I think it pertains to it or relates to it, I need to let the court know about it. So one is Williams versus Bortlen, it's a 1971 case.
Wasn't there a case, forgive me, I don't have people subbing in for me very much. It was, I think it was a woman, I want to say it was Abatement. The Attorney General brought the action against her, and I think the court reasoned that because it involved a grant from, like a grant from the state money, that authorized that was be dealing for or with the state.
So I'm going to do a little guessing here, but this may be the second case I was going to tell Your Honor about, and I think different about Brown versus the state. That is at 268 Georgia Appeal 629. It is a Gwinnett County case, and it involved, in fact, a woman who was investigated by the Attorney General. She had been running a nonprofit and received a grant of $10,000 from the governor. So that's the second of the two cases. That's a different statute. So it's not 45-15-10. It's 45-15-17 and 18.
That allowed them to investigate. He or she
Yes, Your Honor. Yes, Your Honor. But to me, it's a fair case to look at, and that's why I'm bringing it to the court's attention, although it looks like the court already knew about it, because it's within that same realm of statutes that deal with the statutory authority of the Attorney General. So 45-15-18 has to do with the prosecution, and she challenged the case saying, well, they investigated me without receiving a governor's authorization. Now, before they indicted me, they got the governor's authorization. And so at that point, we're no longer dealing with a non-authorized case because the governor authorized it before the indictment, but after the investigation had already gone forward. And in that case, and this is what I want to bring to the court's attention specifically, and I have a copy of the case if Your Honor would like a copy. Okay. So in addressing that issue, it says Brown, and Brown in this case is a different Brown with the defendant, obviously, maintains that because the governor did not issue the directive in this case until shortly before she was indicted, the Attorney General's investigation was unauthorized. All right, and then it goes to OCGA. OCGA 45-15-17A authorizes the Attorney General to commence investigation into matters related to the state, and the investigation to Let's Act began with the governor's grant of $10,000 to that organization on September blah, 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 blah. Okay? And it says thereafter the Attorney General's investigation was permitted in this code section. Finally, we reject Brown's argument that the Attorney General should not have been allowed to prosecute the case as, and it says the code section 45-15-3, subsection 3, provides that the Attorney General will represent the state in criminal actions when required to do so by the governor, which of course has then occurred in this case. And so it's a different statute, but it has similar language with respect to the investigation. It's dealing with the investigation, not prosecution, but it has language dealing with in there. Now in that situation, Ms. Brown had some kind of transactional business relationship with the state. it's not clear from the facts of the case, but it appears that she had reached out and either applied for or sought or some way obtained a grant from the governor in the amount of $10,000. And the court, in fact, specifically said, I already quoted this to the court, specifically said that the investigation began with the governor's grant of that money to that individual. And it appears because it was a fraud prosecution that there was some kind of fraudulent application or something in the inducement or somehow in obtaining that money, it was subject to a criminal violation. So that's the closest I have found. Again, different statute, but same kind of topic area, and therefore something that the court should consider. Again, it doesn't really fit our facts for two major reasons. One, Ms. Brown had an ongoing relationship of some variety with the state, and in that relationship is some kind of, is alleged to have committed a criminal violation. One. Two, different statute. And really, three, the prosecution was authorized by the governor. So I know what we're really looking for, and I've been unable to find, and I've certainly tried, Your Honor, is some case in which it's not authorized by the governor, and yet the state's allowed to proceed in their theory of just somehow relating to or pertaining to. And that case, as far as I'm aware, does not exist. So again, our position is that the language dealing with or for the state, it has a specific meaning. It is not what I would refer to as language that you would normally use in a statute if you're trying to grant the Attorney General just general criminal jurisdiction anytime the state is an alleged victim of a crime. It has to do something more. It seems much more focused on entities or persons who are doing business with or somehow engaging with the state and during the course of that relationship have committed or alleged to have committed some kind of criminal violation. Based on some arguments that the state raised at the Ayla King matter where I was not present, but my understanding of these arguments is that the state may try to argue, so I'll let it address now in the interest of some brevity in moving this along, that the damage to the Georgia Public Safety Building, which happened back in July of 2020, qualifies as dealing with or for the state, such that that would subject that act to the jurisdiction of the Attorney General. The easiest answer, and the most straightforward one, is that those defendants who allegedly committed those acts were not dealing with or for the state. They had no ongoing relationship or business transaction with the state. That is a situation where the only interaction, as I understand from the allegations in the indictment, was the actual damage done to the Georgia Public Safety Building by those individuals or those defendants, allegedly, and there's no other kind of interaction or connection between the two. That would be much more if Your Honor were to rule against me and say, well, Mr. Hall, like the argument, but this is really, it really means related to or pertaining to. That would fall much more into that category. It does not meet the statutory criteria of dealing with or for. Kind of as a side note, if Your Honor were to go down that pathway and decide, well, I think it's broader than what Paul is telling me here, or the way that Paul is reading it, I would note that the public safety building occurred in July of 2020. That was months and months and months before the Atlanta Public Training Center was ever announced. And so I think that Your Honor had already noted yesterday during the demur arguments, it's really hard to imagine you have a Rico conspiracy, which is defined as a Rico conspiracy to prevent or stop or cease the operation or building of the Atlanta Police Training Center when it wasn't even in existence at that time. I think most of all, and then secondarily what I've noted is that if the Georgia Public Safety Building is the government's theory, or the state's theory, as to why it has that act has invoked the limited jurisdiction of the Attorney General, then it should have been pled in the indictment. It's not pled in the indictment. We're left looking at an indictment that requires you to plead. These are constitutional jurisdictional requirements. We know it's constitutional because the Attorney General has a limited authority. And so if you're going to say that some event qualifies as dealing with or for the state, you must allege, I would submit, sufficient facts and otherwise alerting when this is your basis to invoke the jurisdiction under that statute.
Do you have any cases where it involved pleading it in the indictment?
No cases on point as to this statute. The ones that I would use by analogy, Your Honor, are cases involving venue. We may all know Atlanta Police Department generally, or Fulton County Police Department generally responds to cases in Fulton County. You've got to plead venue. It's not up for debate. Venue's not pled and proven. It's a defective indictment. It fails at trial. Another example would be statute of limitations. If there's an exception to the statute of limitations, then again, it has to be pled and if necessary proven at trial that the exception for the statute of limitations applies if the statute was told. So to answer Your Honor's question is no, I don't have a specific example as to this statute of this invocation, but by analogy, there's other constitutional and statutory requirements where specific pleading is required in order to survive a challenge like this, motion to dismiss or plea in vain.
Well, go back and, did that happen in the indictments in the Gwinnett Brown case?
I don't know the answer because I have not pulled the indictment. I don't know the answer. I also don't know whether that issue was raised, a failure to plead or not.
Well, it didn't appear that, I didn't see that in the opinion.
Yes.
But I also didn't see the charging document was not in, didn't discuss whether or not it was pled. It just said there was a previous authorization from the governor.
Right.
Post-investigation of pre-indictment. Didn't say one way or the other whether it either A, was contained in the indictment, or B, needed to be contained in the indictment.
I certainly don't know the answer as to the former, as to whether it was in the indictment in the second Brown case, the Gwinnett County case that we were discussing. Okay.
Or any of them.
Well, all right. I'm going to add on to that just a little bit, Judge. In the first Brown case, and I'll get you the site right here. So you finish my thought.
177 Georgia Ave, 284.
Okay.
I think that's what you said.
Yeah, in that case, so our position is it needs to be pled or included as part of the indictment. In that case, though, the Court of Appeal noted simply that it had been somehow made part of the record. So certainly with respect to, was it some way, somehow, this is the governor's authorization. Our position is it needs to actually be pled or otherwise introduced into the record. The Brown case certainly does not say that it needed to be pled. They noted that that information had been included in the record. So, did I answer the court's question?
The answer is you don't know.
Correct. What I don't know as to what happened in the Brown-Gwinnett case. As to the second one,
you don't know what those indictments say one way or the other.
Correct. That's correct.
If it was pled.
Correct. That's right. The other thing that they may argue.
I'd be curious to see.
Yes, Your Honor. The other question, or another point that the state may raise, is the Atlanta Police Training Center also somehow provided a general basis for the Attorney General's jurisdiction. Kind of the same response, Judge. There's no ongoing relationship between the defense and the state. So
the law doesn't say in Title 45 or where the state is the victim of the crime. Is your argument?
Correct. Right. I also note that APTC, to use the Atlanta Police Training Center, is not a state entity, it's a municipal entity, and nothing in the indictment alleges otherwise, which again I would submit is important if somehow they're claiming that something about the indictment allows them to invoke the jurisdiction over 45-15-10. It needs to either be pled in the indictment, is my position, or at a minimum under the Brown case that ends with page number 284, it must somehow be introduced into the record, at least with respect to the governor's authorization. And then the last point that they may make is that the Atlanta Solidarity Fund, or some variation thereof, was a 501c3 Georgia Registered Company Corporation entity. And what I would say is that the mere existence of being a registered Georgia corporation does not authorize the Attorney General to exercise criminal jurisdiction over a company. In fact, we stop and think about that. If that were true, then every single registered company in the state of Georgia could be prosecuted by the Attorney General's office, and I respectfully submit that there's no reading of 45-15-10 that would support such a broad expanse of the AG's limited constitutional jurisdiction. And again, as with the points I made with the other one, which I understand Your Honor may or may not agree with, but let me go ahead and make the point, is that no allegation in the indictment makes any reference to ASF being an entity or place that's dealing with or for the state, which I believe and submit as a necessary allegation. So those would be the points I would make. There's one additional point I'd like to make in wrapping up here, and it's more thinking broader about this case as well. So I would say that even if the court were to find that the damage to the Georgia Public Safety Building or the Atlanta Solidarity Fund somehow invoke the Attorney General's criminal jurisdiction, and to be super clear, I know Your Honor already gets this, as I say, being overly redundant, I guess, is we don't agree that it does. But if Your Honor finds differently, to rule differently on that, then we certainly don't think that the AG's limited authority permits it then, based on those discrete instances of jurisdictional authorization through a statute, to glom every other defendant you can think of into this prosecution using those limited charges. Basically what I'm saying is there's no ancillary jurisdiction in Rico cases in this state. The Attorney General doesn't have ancillary jurisdiction. If we have any doubt about that, we can just look at the Rico statute itself. It does not grant the Attorney General concurrent jurisdiction. Could have. We know legislation knows how to do that. It did not do that. And so for that reason, I would say that.
Yet.
Yes, yeah. That's all policy matters. The General Assembly may change something at some point. But as of right now, they don't have concurrent jurisdiction. And because of that, even if Your Honor were to rule against me on the limited basis of those different discrete events, that does not allow them to add in everyone else into this Rico theory. So under all those reasons, I respectfully ask that you dismiss count one of the indictment as to Mr. Carroll, Mr. Jurgens, and every other defendant in this case.
Just out of curiosity,
Yes,
count 2 is domestic terrorism.
yes,
In the code, it says AG has concurrent jurisdiction.
yes.
What does that do with count 3? Arson. Police arson, okay. Does that affect count 3?
No, I would say two things. I didn't move on count 3, number one, but to the extent that they don't have a concurrent jurisdiction over arson, then yes, that would also go out the door.
Okay. All right, state's up.
All right, state's response.
Good morning, Judge Farmer. And if I may begin by saying I'm appreciative of Mr. Hall, my colleague on the other side. He covered a lot of the issues that I was going to go over to, and a lot of the things he said I think were pretty fair recitations of the current status of the law in the state of Georgia. So I'm appreciative of Mr. Hall covering a lot of the things that I took a look at as well. And let me start with this. I agree with him about domestic terrorism. We have obvious jurisdiction over domestic terrorism. But let's turn to 45-15-10, which is the, if you will, dealing with statute. And to read the full statute to the court, and I think the court may have it in front of it right now,
I do.
is that the Attorney General is authorized to prosecute in the criminal courts of this state any official, person, firm, or corporation. So we identified who the accused will be right there at the beginning of the statute, which violates any criminal statute, which could be felony, misdemeanor, whatever that it is, while dealing with or for the state or any official employee, department, agency, board, all of that sort of stuff. So what we have is we have an authorization of a defendant to be prosecuted, and then it lists anybody dealing with, and it's funny because Mr. Hall sort of followed the same logic that I did when looking at what dealing with means.
With or for.
Pardon me?
With or for.
With or for, correct, with or for. And you know, it's interesting because I found other definitions of dealing with as well, which is, quote, conduct in relation with others. That's dealing with as well. So for example, if there was an attorney that didn't like a judge, they may leave the courtroom and say, and someone sees them and said, what's going on? They say, I'm dealing with Judge Smith right now. That doesn't mean that you're conducting some sort of transaction with them. Or you say, you know, you don't look well, what's going on? I'm dealing with the sickness. There's all kinds of definitions. And the legislature did not give us any kind of guidance whatsoever. I looked for legislative history. I looked for all of that to figure out what they meant by that. There's nothing in the history or anything like that. So we have to take the common sense and the natural reading of it. And the natural reading of it in the state's position is that the natural reading of it is that when you're dealing with something or you're dealing with someone, you're dealing with whatever whatever relationship that you have. There are a lot of different relationships that there can be. Now, in that relationship, it is the state's position. I couldn't find a case law about this, but even if it was this way,
We get to be a case of first impression. Yay.
Is that the state can't create the jurisdiction over the defendant. I believe that the defendant would have to invoke the state's jurisdiction. It must be a defendant's action.
Let's start with this. Do you have a governor's authorization?
No.
Okay.
No. And that's why the Brown case doesn't apply. I saw the Brown case as well, and oddly enough, later on I'm going to talk about a different Brown versus the state, even though there were two other ones that. So I'm going to talk about a different Brown versus the state. But here we have multiple times when the defendants invoke the state's jurisdiction. On page 49 of the indictment, the very first overt act, if I can point the court to that, it talks about attacking Georgia State Patrol headquarters. And it says right there, Georgia State Patrol. It's the state of Georgia right there. Now, by doing that, they're dealing with them right there by attacking the headquarters. Now, and it does say as well, it says any department, Georgia State Patrol, agency, Georgia State Patrol, institution, Georgia State Patrol. And so at that point, they invoke that. I would note that council also brought up the Network for Strong Communities, also known as the Atlanta Solidarity Fund. You can kind of use them interchangeably, but that's a discussion for another day that takes a long time to talk about sort of interplay there. But that they did register with the Secretary of State. And they did, and they invoked the state's jurisdiction there as well. Now, the question that I think that was kind of dancing around at Mr. Hall.
So everybody who registers, every business that registers with the state is submitting themselves to the criminal jurisdiction of the Attorney General?
Yes. Yes, because I think the question kind of dancing around there is how much do you have to kind of deal with the state to cross into that threshold, right? That's really what I think the court is getting at. Paul is kind of dancing around a little bit, which is, well, there's not that much here. How much do you need?
Did that 501c3 ever receive state funds?
Not that I'm aware of, Your Honor. But you don't have to.
That would have brought us back to the second Brown case.
Pardon me?
That would have brought us to the second Brown case.
Well, I think it's a difference from the second Brown case.
I want to
But-
fast
but
forward
I
so
don't
badly.
think you need to receive funds to do so. All you have to do is deal with the state. And when you register with the state, when you're a 501c3, you have to send paperwork back and forth. You have to send them information, they send you information back. You have to pay a fee to the state to say, I want to become a corporation. And they send you paperwork back that says you are a
You
corporation.
don't want to become a corporation, you just don't want to pay taxes on money. You don't want to be a 501c3. If people could do it without becoming a 501c3, they sure would.
And I completely agree with the court about that, but that's exactly how the state can assert its jurisdiction over it, right? If people can't do it, is it permits the state not just to regulate, but to assert its jurisdiction over that. I'll give the court a different example when it comes to the Secretary of State. The Attorney General is, for the most part, the lawyer for state agencies. And there are times when they're not, but again, separate issue. But we can represent members, we can represent the state or the Secretary of State's office in civil matters. And so what I'm saying there is this, that if that's true, let's say there's a civil matter that comes up with the Network for Strong Communities, where they're suing the Secretary of State. The Attorney General can represent the Secretary of State. Why is that? Because it's a state matter. Because it's a state matter is the
Well,
reason
the
why.
Constitution gives them the right
Okay, Kiwi.
to do civil stuff.
I agree.
We're not talking civil stuff. We had some analogies to civil cases yesterday. I don't know that those necessarily translate into the criminal arena.
Correct, I somewhat agree, it kind of depends on the situation. But point being though, that what is the threshold of dealing with the state?
So when you register with the Secretary of State, you are submitting yourself to the civil jurisdiction of the Attorney General. You bet, sure. The criminal jurisdiction, on the other hand, different kettle of fish.
It depends, I think, on if, I'm not going to say that if someone who is Saturday driving their personal car down the road, going to, I don't know, Five Guys Burgers and Fries, and commits a traffic infraction that has nothing to do with...
On a state road.
On a state road.
On a state road, not county highway, on a state road.
I'm not entirely sure at that point that you're necessarily dealing with the state.
You're driving on state property.
It's fine. I mean,
Just like the Georgia State Patrol building is state property.
I agree with you about state property, but they also threw a Molotov cocktail into the building while there were people present. And so that's another thing that invokes the statute as well, is it talks about employees of the state as well, where there were people present inside the building that had to go to the hospital.
So you get in a traffic accident with a Georgia State Patrol vehicle on a state road.
I think that's a little bit closer at that point. I really do, because at that point, if you cause the accident, and again, the defendant would have to invoke it, because if you were rear-ended by a state patrolman, then at that point, I don't know exactly what did an open container in the other person's vehicle. At that point, they haven't invoked that jurisdiction. But
If you're speeding on a state highway and Georgia State Patrol pits you, and you get charged with fleeing and attempting to.
I suppose it's possible, but at that point, I'm not sure you're actually invoking the dealing with the state by driving on their road, right? So, but here, they invoke by Secretary of State, by attacking the Department of Public Safety headquarters. And I know they talked about the Atlanta Public Safety Training Center just being for the state of, or just for the city of Atlanta, but it's not. It actually trains state.
Judge, I apologize to my counsel, Mr. Fowler. I am a little worried we're getting to what came up yesterday about proffers I'm objecting to. So I'm going to object to any proffers that are being offered for evidentiary reasons. My apologies to interrupt. I really hate interrupting counsel's argument. If he's just talking illustratively, it's one thing. If these are meant as substantive evidence for the court to consider, I respectfully object to this. And
Whether or not who owns the training center?
Yes. Yes, and what the funding is, none of that's in the indictment, none of that's in the record.
Whether or not it trains people is different than who owns it.
Right, as well as the people inside of the Georgia Public Safety, and we're starting to get all these extraneous facts. So I wouldn't even raise it.
I'm going to accept this proffer that inside the Georgia State Patrol building, there were Georgia State Patrol men and women.
Fine.
I'm going to accept this proffer on that one.
Yes, sir.
So I would also point out to the court another example on pages 99 and 100 of the indictment as well. It talks about different defendants who are engaging with an employee of the state government. That's Trooper Jonathan Salcedo. And again, Trooper Salcedo did not engage them. They went to his house in Bartow County. And so what we have there is, again, evidence of other defendants engaging state employees on their own. And so we're starting to see this constellation of these defendants engaging with the state again and again. And so what we also see is
Could you not have it with the state? I mean, let's say the Attorney General wanted to help the trooper take out a TRO in a civil arena.
well, I don't think that, because that's not prosecuting, and this statute requires prosecuting the criminal courts.
Mm-hmm.
And so I don't think that this statute applies there, because like you said, that's civil.
Mm-hmm.
So I don't think you could do that.
You're subjecting yourself at the very least to a civil action brought by the Attorney General.
Potentially, I'm not entirely sure of our civil jurisdiction, I'll be honest with you, Judge. I would go to one of our civil lawyers. But I'm talking about criminal jurisdiction here, and you're talking about a civil TRO. And so when we're talking about 45-15-10, and maybe I misunderstood the court's question, when we're talking about 45-15-10, we're talking about criminal prosecution.
Right.
And so by engaging with the state, engaging with state officials, engaging with state employees, engaging with state agencies.
What I'm saying is, I agree with you, you're subjecting yourself to the jurisdiction
Right.
in the civil arena, but are you in the criminal arena? Are you dealing with them to the extent that you are dealing with or for
Yes.
the state? Clearly you're not dealing for the state.
No, I don't think there's any instance where any defendant in this case dealt for this.
So you're dealing with.
Yes.
So you want that with to mean pertaining to versus in some sort of contractual or business relationship, which was, I think, Mr. Hall's definitions from Lax and Merriam-Webster's. Which dictionaries did you use?
You know, I wrote down Merriam-Webster. I'm not sure that I did use Merriam. I think it was just sort of and you can look it up now, I think that was just kind of a note to myself, like, hey, it was a dictionary. I may have used dictionary.com. I don't know which one that I used, but I can give the court the quote. But you asked about pertaining to. I think the closer one would be one that Mr. Hall used that I made a note on it. He said engaging with the state would be the closest one.
Somebody just
and
whistled?
so engaging with the state is clearly what happened. They engaged with the state in various ways. And so the question
Engaging with is different. There was certain
the dealing with? I think it would be closer than pertaining to. And I say that with respect to the court, disagreeing with the court.
Merriam-Webster. Dealing. Method of business, manner of conduct. Dealings, plural, friendly or business transactions. See, also. There were reports of shady dealings between the two sides. There's a reputation for fair dealing.
So if I may, you can actually look up the term deal with as well as a phrasal verb on Merriam-Webster. The first definition is to be about something, to have something as a subject. And so I would respectfully suggest to the court that looking up for going to Merriam-Webster would be deal with as opposed to just the term deal. Because I think the term deal with is a term of art that is in 45-15.
Deal with.
And the first there is to be about, to have something as a subject.
The OED makes you buy a subscription. And I do not have a subscription for the Oxford English Dictionary.
I do not either, Your Honor. But again, kind of going back to the notion of how much do you need, one thing I would suggest to the court is that in the indictment, we have multiple instances of what we title in our legally known as overt acts. And so I don't know, there is no case law that I can find on this as to what the standard for how much you need or how much you need to interact with the state, but I would suggest to the court that this is sufficient. An overt act, at least one overt act has to be conducted to engage with the state. Now, again, I don't have any case law to back that up. I also don't have any case law to say that is not enough. But there's more than one overt act in this indictment that suggested that these defendants interacted with the state. When we're looking at how much, though, how much do you have to interact with the state? I did kind of take a little bit of a broader survey of, like you said earlier, we don't like to compare it to civil, but I didn't know where else to look other than kind of those jurisdictional hooks. In the civil world, when you are trying to bring someone into a civil lawsuit, a single event is sufficient to impose jurisdiction over an out-of-state defendant, and that's McDonald versus Roy E. Beatty and Associates. It's 203, Georgia Appeals 807. Behar versus Aero Med International 185, Georgia Appeals 845. In addition to invoke the jurisdiction of the Superior Court, all you need is a single felony. You don't need more than one. Here we have multiple overt acts. When we take a look at the federal criminal jurisdiction, all you have to do is you don't even need to make an overt act. All you have to do to invoke the federal criminal jurisdiction is cross state lines. That's all you got to do. You don't have to commit a crime. You don't even have to commit an overt act. All you got to do is cross state lines. And so when we take a look at that kind of that broader survey, I think what we see is it's a pretty low bar. When here what we have is we have the defendants affirmatively dealing with the state, affirmatively engaging with the state in every way, as not just alleged in the indictment, but also outside of the indictment as well. Now, one thing that I do want to address that I respectfully disagree with my colleague on the other side about is he indicated that it needed to be pled in the indictment. I respectfully disagree, and his examples were that you have to plead venue, you have to plead, and I believe the statute of limitations were the things that you had to plead. And the reason that you have to plead those in an indictment is because they're material elements of crimes. You have to prove venue, you have to prove the statute of limitations. Those are statutorily required as part of an indictment. This is not statutorily required as part of an indictment under the OCGA. Instead,
More analogous to a civil suit, jurisdiction pursuant to whatever statute or whatever code section, or why you're in the Superior Court has jurisdiction for this because of X, Y, and Z, versus, your garden variety indictment doesn't say the Attorney General or the District Attorney has jurisdiction to do this because it says so in the Constitution.
Correct. It doesn't say because there's a felony here, here's your act. I agree with the court. So the final thing that I will move to is I respectfully disagree with
But it does have to be somewhere in the record if there's a governor's authorization.
Yes, there does need to be, in some way, shape, or form, something about that, and that's why we're here today. The final thing is I would respectfully also disagree with my colleague on the other side about the remedy here. And so going back to the first Brown case that we talked about, that's the 177 Georgia Appeals 284. I agree that it doesn't apply insofar as to the analysis under 45-1510, because that involved a governor's appointment and all of that sort of stuff. There is one small area where I do think it is important, and that is the acknowledgement, because the case is almost 40 years old, is the acknowledgement that a plea and abatement is the proper vehicle for this motion. I agree about that, and that is alleged in this motion, but I'm getting somewhere with that, which is this. There's I know there was another Brown versus State that was discussed earlier. There's a third Brown versus State here. It's 295, Georgia 240. It's a Supreme Court case, and it talks about there are two kinds of pleas and abatement. And there's a proper effectum and there's proper defectum. There's two different kinds. And it was in the discussion of a grand jury presentment and whether a grand jury presentment should be quashed or whether it should continue going on with just the problematic part kind of cleavered off, if you will. And what it talked about, it kind of sounds exactly what it sounds like, which is effectum, does it affect the process, or defectum, is it a defect in the process? And there's a difference that results in the remedy. Proper effectum would be something akin to a grand juror that has a vested interest or an inappropriate interest in the grand jury proceedings. So in other words, they can't be fair and impartial. Proper defectum was when a grand juror was not statutorily authorized to be on the grand jury, such as someone who's not a United States citizen, doesn't live in the county, doesn't meet the age requirements, or something like that. In Brown, the Supreme Court said if it's a proper affectum issue involving whether someone can be fair and impartial, and I think the example that they used there was that a couple of the grand jurors were related to the victim or maybe the defendant, something like that. They said the entire thing has to go away because it was taken from the beginning. In the defectum area, which is, I think, more akin to what we have here, because if it's someone who shouldn't have been here, the answer is that in that case, you have to clear that part off, and it just abates, and it's plea abatement. The indictment just stops until someone else takes over, which I believe the proper, if this court were to rule against this, which of course I don't concede would be the attorney's office, and so Bonnie Willis's office would take over and prosecute this case. I believe that under Brown versus the state.
Or Sherry Boston?
Well, she can't because she's not the district attorney of Fulton County.
Evie with the
So,
throwback.
of course, she could bring those charges in DeKalb County if she wanted to, whatever. Then it's over. She could do that if she wanted to. She has concurrent jurisdiction over all.
We heard a lot about why there weren't certain counts, because we didn't have venue yesterday. So, you know, Bonnie Willis has jurisdiction over the crimes that occurred in her, but you're gonna say, well, she could take over the Rico? But does she just take over your indictment? Or does she start fresh?
Under the Brown case, I don't think...
Bonnie could get the Rico?
Or do we cleave count 1 and count 3 and leave you with count 2?
I don't believe so, Your Honor. I don't, because that would be quashal of the counts, which is what Brown talks about is not appropriate under the defect, and it's proper under the defect.
But if the Attorney General didn't have the authority to bring it up, doesn't that make the indictment a legal nullity from the get-go?
I don't know if that's what Brown stands for. And you know, I would point the court to another case, and I don't have the site off the top of my head. It's the Lample case, I believe about 16 years ago out of Clayton County, maybe 12 years ago out of Clayton County, where an individual testified before a special purpose grand jury. The trial court found that the testimony given by Mr. Lample in front of the special purpose grand jury was outside the scope of the grand jury. And when the Supreme Court ruled, they said, you're right. And as a result of his testimony, he was charged with perjury. And so the Supreme Court said, you're right. His testimony was outside the scope of the special purpose grand jury. And they said, you're right, that testimony should not have come before the special purpose grand jury because he couldn't have been there. But the answer that the Supreme Court gave was, but your remedy is not quashal of the count. The remedy was you continue on, and it's not a problem with the indictment. So, yes, Your Honor, go ahead.
I'm reading your Brown case, the 295 to 240. They admit that part of their observations are dictum, so they're pontificating. So that case is about removing grand jurors.
Correct, it is.
So the analogy here would be removing the Attorney General.
I think so. I mean,
But if you remove the Attorney General and say he didn't have the authority to do what he did, I'm having a hard time saying, okay, he wasn't allowed to bring this in. But he did, so we're just going to go. We're just going to hand it off to somebody else. The constitutional officer for prosecuting here, the DA, who may or may not have brought that accusation to start with. So can the AG go in, bring an indictment, knowing he can't do it? I'm not accusing that.
No, I know that.
Knowing he can't do it, but forcing the case upon the district attorney? And therefore making the district attorney make some sort of political decision of whether I'm going to take it and run with it, or do I turn around and look at the AG and go, I'm going to not prosecute him.
If I may just, I don't like, the word isn't take issue, but if I may just kind of
Discuss.
It's a great word. One, I can't imagine, and certainly anybody I would...
I'm trying to ride the slippery slope both ways.
Sure, of course. Would take a case intentionally into grand jury and do that, just to pawn it off. I can't imagine.
Okay, but like I said, that's all the way at the bottom on my slippery slope.
Right,
Okay.
right. I just, because of the way it was worded, I just want to be sure that...
Let's say you accidentally did it. What? I should have done this one. Here you are, Madam or Sir DA.
I think that's what Brown tells us. I really do. And I understand the court's logic. It's not as though I'm looking at the court thinking, how is the court getting there? What is he thinking? But I'm going by what the Georgia Supreme Court has told us is what I believe to be the appropriate thing. But all of that said, we don't need to get there because we have jurisdiction. These defendants have invoked the jurisdiction of the state, not just in the indictment, but also outside of the indictment, by engaging with the state. They've engaged with employees of the state. They've engaged with institutions of the state. They've engaged with agencies of the state. They have done that. They have dealt with every single one of those. And when you take, not just look at deal, but deal with, under Merriam-Webster, to be about something, to have something as a subject. And we talk about it in the indictment. We talk about, just the plain language.
Okay, but dealing with usually implies common meaning. A two-way relationship. There's a one-way relationship here, as alleged by the state. These folks did these things to the state. Okay? There's no dealing with it. It's doing to.
Well, I don't.
You're not dealing with. You're not looking for an exchange of ideas, an exchange of commerce, or any kind of exchange. That was a one-way exchange.
Let me give the court the first example on Merriam-Webster of how they use it in an example. The one is to be about something or to have something as a subject. It says, here's the sentence. Her speech dealt with healthcare and the nation's economy. And so that's that they're not engaging necessarily there, but it is a single one-way street in the example that Merriam-Webster gives us, which is exactly what the court said just a moment ago, is it's a one-way street. And so that one-way street, under the Merriam-Webster definition of deal with, actually is exactly what the court is talking about.
But if we take that definition, their act of throwing fire at the GSP building dealt with the state?
I mean, in a lot of ways, Judge, as I said,
that doesn't deal with the state.
I mean, in some ways, if you actually read the indictment and talk about anarchy and all of that sort of stuff, they are dealing with the state in the same way that if your kid makes you mad, and in some way, shape, or form, you say just colloquially, I'm going to go deal with this. That's exactly what they're doing right there by dealing with the state. And so, yes, I mean, we can talk about it in a number of different ways, but I think the plain language way that we talk about it under Merriam-Webster and without any further definition, that yes, this is exactly what this means. The plain language of the statute is exactly what it means. It can be one way, it can be two ways. It includes doing business. It does. If they had said, does business with, then I think we would probably have a completely different analysis here. But they didn't include that language. Instead, they chose the language deal with. Deal with, not do business
But you
with.
want that analogy to be any instance where the state is a victim of a crime. You would say any time the state is a victim of a crime, that's what your definition of dealing with is.
Yes.
But if you read it, and if it just said dealing with the state, maybe, but what's dealing with or for?
Yes. If you shoot a state trooper, you bet.
Dealing with or for, well, then you got a capital crime. Okay, and well, you're at least going to get there in front of the Supreme Court because the Constitution said so. But dealing with or for, I think both of you kind of focused on dealing with, but if we're dealing with or for, that isn't that more of an analogy to a business relationship?
No, I think what that does is it kind of flips around, you're dealing for the state, so at that point, it makes you an agent of the state. So for example, if I were to go out and commit a crime on behalf of the state in my job, I start, a little more difficult for me as a prosecutor, but if I was somebody who worked over in budgeting and had access to money, and I started doing some sort of illegal contracts and bid rigging with somebody, I'm dealing for the state, because then it would be a little bit more difficult. So you're dealing with the state as a state agency, or as a state agent. I think dealing for the state covers that, where state employees are doing something wrong as well. So that's what that is. And so, yes, if you, and when I said shoot a state trooper, I understand the court talks capital, that the court's aware the trooper was shot in this case. He's survived. After multiple surgeries, he survived. Because he's deceased now, but someone who was camping in the woods shot a state trooper. And so, yes, we're dealing with that as well. And so, when
Well, no, this is that or not.
well, partially because Mr. Toronto's dead, who shot the state trooper.
Okay.
But it will be relevant in case.
Well, I mean, under your theory of conspiracy, doesn't that make all 61 of them?
In theory. But it comes in any ways relevant to explain why some of these crimes were committed in response to it. But anyway, engaging with the state. If you shoot a state trooper, yes, you're dealing with the state. So long as he's within the course of his duties, all of that sort of stuff, absolutely. You're dealing with the state, and I don't see how you wouldn't be dealing with a state official or a state employee, right? And I'll give the court another good example. Let's say that there is a traffic stop. You talked about transactions. There's a traffic stop, and someone tries to pay off the state trooper. There might be a transaction there. Let's say the state trooper cheats. You'll be able to prosecute that, certainly, because it was dealing with the state. And so it doesn't, and this is not limiting anybody to any kind of economic transaction. It doesn't limit anybody to any sort of business transaction, nothing like that. It simply says dealing with the state. And the legislature meant what they said and said what, or I'm sorry, meant what they wrote and wrote what they meant. And here, that's what they wrote. They wrote dealing with the state. So if you are dealing with the state, and going back to kind of you don't have to have much at all. There's no standard here to say you have to have 2 overt acts, you have to have this, you have to have that. You only have to have small of them. Just like if you're committing what would otherwise be a federal crime, you drive all the way up to Trenton, Georgia, and then you step over into Tennessee, and then you come right back, suddenly you have invoked the federal jurisdiction by crossing state lines. You don't have to go 100 feet, miles, 6 miles, 12 miles. You only have to do it a little bit. Here they did it, not just a little bit, they did it quite a bit. GSP headquarters, shooting a trooper, Trooper Salcedo's house, as alleged on page 99, 100 of the indictment, and page 49 of the indictment. These defendants dealt with the state. That's what they chose to do. And when you deal with the state, you invoke the jurisdiction of the state.
Okay, so what about counsel's argument regarding the ancillary jurisdiction?
Regarding?
Bringing in the instance of primarily the GSP headquarters, and I understand you have later on with the trooper, using that as a catch-all for all of these other folks. Same calculus, same argument?
Yeah, I mean, it's the same argument, right? It's a conspiracy, and it's the enterprise that it's engaging with. As part of it, they are conspirators, and that's the way it's alleged. It's co-conspirators as part of the enterprise engaging with the state here. I mean, it's a pretty straightforward argument. I think I can expand on that. I know the court probably understands what I mean by that. But if you take a look at I'll take a look at what page it is, and I was looking at earlier, page 49. I meant to scroll.
The overt acts start on page 49.
Exactly where I'm headed, Judge. The defendants committed overt acts to affect the object of the conspiracy, which include acts of racketeering as described below, including all defendants. And those include all acts of racketeering, because when you're responsible for one, you're responsible for all. And so, for that reason, it includes all the defendants here. And they did in multiple instances, and I think that's helpful. I mean, is it required? No, but I think it's helpful that they did in multiple instances engage the state themselves. Not the state engaging them, but they engaged the state on multiple instances. And so, I don't think it would work to say that, oh, there was only one incident where they accidentally engaged the state. I don't think that would survive, but I do think it's helpful for the state's argument to add on to say that they engaged the state multiple times. So there's no accident here. They intentionally engaged the state, they intentionally engaged state employees, institutions, agencies, all of that sort of stuff. All in the name of, as alleged, as part of the conspiracy, in the name of anarchy and all of that sort of stuff. And so they do engage the state for that reason. And so for those reasons, we would ask that the court deny the defendant's motion. I know I'm kind of wrapping it up right now before we have any further questions. I'm not trying to avoid them, but happy to sit down.
No, I want to hear back from Mr. Hall. Thank you, Bill. Mr. Hall?
Yes, sir.
All right, back to Andrew Hall.
You're not dealing with the state when you make the state a victim of a crime?
You are not, Judge, if that statute is used, and the state is not powerless in any of those situations. The easiest answer is the district attorney, constitutional criminal prosecutor for that county can prosecute, or you solve all these problems with the governor's authorization. In fact, every single example of the cases that both I and Mr. Fowler on behalf of the Attorney General's office have brought to you involved exactly that. The governor stepped in and authorized it. So this is not a situation where, if Your Honor does not follow the state's reading, that while dealing with or for, the state has to mean relating to or pertaining to, or the state is a victim, the state is only powerless to fight crime or combat injuries. They have all kinds of tools for that. You get the district attorney to prosecute it, you get the governor to authorize it. And every single example we've seen on reported decisions about the governor, in fact, has authorized it. Not just involving state employees, including attorney general prosecutions against private individuals. So it's not like it's hard to do or difficult to do. It wasn't done in this case. So I would urge you to avoid taking the statute and expanding it beyond its plain meaning. On that note, I would say,
Well, I mean, yes, dealing with has a much more, it has an expansive array of plain meanings.
so yes, if you include the colloquialism deal with. I agree. If this phrase, and the phrase again, the complete phrase is while dealing with or for. And so, as Your Honor's already pointed out in talking with the state, and I'll just reemphasize this, that phrase has to be taken as a whole. You can't just take the deal with and ignore the or for, because all part of how it's defined to give what's otherwise limited constitutional jurisdiction to the AG through a statute. But if you look at, if you just were to take the colloquialism, deal with, then you can say it all the time. I dealt with my child today. I played soccer and I dealt with a difficult attacker, defender, coach, whatever the case may be. We use deal with as a colloquialism in all kinds of ways. When it comes to a statute, I respectfully submit, however, in the statute where it specifically says while dealing with or for, it has to have a much more narrow meaning and one more akin to the definitions I provided to the court from Merriam-Webster and Black's, which it envisions some kind of ongoing relationship, a business relationship, a transactional relationship. I'm seeking funding from the governor to get some grants. I mean, on that note, you know, Georgia corporations are not generally subject to the Attorney General's criminal jurisdiction. Now, if that entity is engaging in some kind of business or some kind of ongoing transaction with the state, and while dealing with or for the state in that capacity commits a crime, that's a different proposition, but that's not what we're dealing with here. The mere status of being a corporation does not make you while dealing with or for. Your Honor asked briefly, I'm going to keep going, if I did not answer the first question, I want to make sure I answered it. Okay. So the court had asked a question, well, I don't know if the court asked a question or it just came up in the discussions with the state about the civil jurisdiction versus the criminal jurisdiction. And that's addressed by the legislature in OCGA 4515.3. Specifically, the Attorney General has been granted the authority by the legislature to represent the state in all civil actions tried in any court, period. In contrast, in that same, that's subsection 6, in contrast, in that same statute, when dealing with criminal cases, it says when required to do so by the government to participate in, on behalf of the state, all criminal action in any court of competent jurisdiction. So it's a very different granting of power. I mean, in the absence of the governor's authorization, which is undisputed, does not exist here, we're left with 4515.10. And again, if deal with the colloquialism is what this means, then yes, it's much more pertaining, relating to any time you even sneeze towards the state, it would probably qualify. That's not what the statute says. It's not a colloquial phrase. And I think it's not a colloquial phrase for a few ways. We can look at that. But it specifically focuses on while dealing with, or as John has noted, or for. And it's not two different meanings. It's the same thing. And it has to mean, it has to be too strong, but I certainly believe it means some kind of business or relational transaction relationship going on. Other point I'd like to make is...
Okay, Mr. Fowler's point.
Yep.
Somebody shoots a state trooper, and it's not capital.
Yep.
Okay? Can the Attorney General prosecute that individual?
Not under 4515.10. No, they cannot. It is not while dealing with or for the state. It is not. Can they prosecute them? DA can ask, Attorney General, we'd like you to come in. Happens all the time. Across all the counties in the state, happens all the time. Metro counties, rural counties, governor can authorize them. They can come in that way. The Superior Court judge of that, Chief Judge can ask them to come in. There's multiple statutory vehicles to get the Attorney General in. But the Attorney General, in that situation, in the hypothetical, where the Georgia State Patrol officer has been shot, not killed, and is alive, or subject to an aggravated assault.
So we don't bring the capital issue.
I've just avoided that based on the hypothetical, but yeah. But just, there's no issue of capital, anything involved in it. The Attorney General cannot use 4515.10 and say, I'm just going to prosecute it. Lots of ways for the Attorney General to prosecute it, and certainly if they felt like the DA was not up to the task, lots of ways that they would prosecute it. But no, under 4515.10, that is not while dealing with or for the state. Otherwise, it would just be anytime relates to the state, or anytime it causes an injury to the state. And the legislature, we would say, generally knows what it means and means what it says. And so we would say, in that situation, if they wanted it to be broader, then they would have made broader language. And again, we start with the proposition that this all starts with a limited constitutional authority for the Attorney General. I mean, one way to solve all this is the Constitution could have given the Attorney General concurrent criminal jurisdiction as with district attorneys. It doesn't. General Assembly could have gone in as they did with civil actions and given concurrent jurisdiction with the Attorney General for district attorneys in all felonies, all misdemeanors, all criminal actions. They did it. And so they certainly know how to do that when they want to give a broader expansion of jurisdiction. We know that multiple ways. One of the easiest ways is under 4515.3, subsection 6, where they give the Attorney General the jurisdiction to represent the state in all civil actions in any court. That's an easy fix. And therefore we can say, because they didn't do that, they intended a more limited, much more limited grant of jurisdiction to deal with situations where someone has some kind of ongoing business, transactional, whatever it is. I mean, charitable, transactional relationship with the state, and while that is ongoing, commits a criminal offense. And then at that point, the Attorney General can come in. It doesn't require the governor's involvement. That the General Assembly said, no, that's enough. We just get the Attorney General in on its own initiative. Otherwise, the governor can always give authority for anything that he or she deems proper and appropriate. I would also say, Judge, that I do not agree with and would object and dispute this idea that jurisdiction, in this case, can be based on overt acts under Rico. So if the court were to find that the dealing with, while dealing with or for the state is more like pertaining to or relating to, and not what I'm asking the court to read it as my reading of that statute, it nonetheless, there's no, first I would ask the court not to find that, but if the court finds that no, it's more relating to or pertaining to, then that still doesn't allow them to bring those cases, that's jurisdiction over crimes, not over acts. And all that's been alleged in this indictment are a variety of over acts. And we went through yesterday, Some of them are crimes, some of them are not crimes, some of them are probably pled as crime, but I think none of them are probably pled as crimes, because they don't have elements and,
Okay, you're losing.
sorry.
Because if the Attorney General has the authority because somebody dealt with throwing a firebomb at a GFP.
Yes, sir.
Okay, so they now have jurisdiction over that. If that person is part of a conspiracy, you're saying the AG then doesn't get jurisdiction over the conspiracy, just over that one individual act?
Yeah, yes, if we're talking about the conspiracy, yes, assuming that we're past this whole while dealing with or for business, we're past that. You said no Hall, it's regarding or touching upon whatever.
Right. So if he's got jurisdiction as to one, does he not have jurisdiction as to all in the conspiracy?
Well, I would say the answer is no, okay, number one, because, excuse me, let me back up.
If the person who throws this thing
Yes.
is part of a corrupt organization,
Okay.
okay, how does the Attorney General then not have jurisdiction over the other folks in that corrupt organization?
What I would say is that if you find if you find that with the dealing with or for,
Am I asking that right?
yeah, you're asking right, I'm not answering right, you're asking perfect, I understand your question. So in that situation, the bomb thrower would be subject to, or Molotov cocktail thrower, whatever you call it, would be subject to jurisdiction in this way that we're talking about, hypothetically. And two, I would agree that people who are part of the conspiracy to throw that bomb, Molotov cocktail, whatever it is, would also be fair game because as co-conspirators of that act, they would be within the umbrella or ambit of that authority. I would not agree, however, that that would extend to include everyone in a Rico case, because in that situation, all we have is this ancillary jurisdiction that I'm objecting to, where they're saying, we have this act over here that gives us jurisdiction.
That is part of a broader conspiracy. So we're going to take jurisdiction over the whole conspiracy.
Yeah,
That's your argument.
Yeah, I would
Mr. Fowler?
It is your honor, yes.
I would draw the line there. As to a traditional conspiracy, as to the act itself, yes. As to the fact that that act is pled as not even as a predicate act in this case.
Well, we don't know.
We don't know, right. But let's assume hypothetically, it was properly, to get to what I think the court's asking, if it had been properly pled as a predicate act, then yes, I would say that that would not extend to the entire.
To the other overt acts?
Yeah, that's correct. That's why I would draw the
You
line.
only get parts of the conspiracy where the state is the victim?
Correct, yes. I understand you may not agree, but otherwise what you're doing is allowing them to just say, we have one thing over here in July 5, 2020, the Georgia Public Safety Building incident.
And members of this conspiracy, by committing an overt act against the state, have given the state, the Attorney General, jurisdiction over the whole conspiracy.
Okay.
I think you're in an all or nothing situation.
Okay.
I don't follow you.
Fair enough. I appreciate your candor to me. That's fine. I'm going to move on to that point. And
Okay.
I just respectfully, I draw the line there. I understand you disagree with my point.
You disagree with me, I get it.
Yes, sir. There's a comment that was made about whether there should be pled in the indictment, the Attorney General's.
How they came to have jurisdiction.
Yes, and I don't have a case on that point. I would say, though, that in the example that I believe the state gave, I'm making this mention, maybe Your Honor gave, whoever gave the example of a traditional indictment with the district attorney involved.
That was me.
Yes, sir. So, of course, the district attorney has general constitutional authority, so it's not an issue, right? The only reason this would even be an issue with respect to pleading is that there's a limited jurisdiction for the Attorney General, and it's a constitutional limitation. And so when you're saying that my constitutional limitation doesn't apply, then I would say, Your Honor, respectfully, it has to be pled in the indictment in some form or fashion.
So you're saying that when that indictment, after the investigation, where there was a government authorization, that indictment would have had to have said, the Attorney General is bringing this action pursuant to authorization from the governor.
Yes. I don't know if it did. I don't think it was raised. I can't tell you what it says, because we discussed, I don't know what it says. But yeah, my position would be, if you're trying to expand your constitutional limitation on jurisdiction, we can't just assume because you show up with an indictment, it's okay. It's got to be pled, no different than venue or statute of limitations or anything else. Not true for the district attorney, because they have a general criminal jurisdiction.
But you have no law or case law to back that up?
Zero. It's by analogy only, Your Honor.
I think as long as
I could be blurring things together, because we're at like 7 hours almost here, you guys. But when Hall first got up to make his argument, he's doing his rebuttal now, but didn't the judge make like a candid comment that this would end up being an argument of first impression. Perhaps that was another issue, and I'm just forgetting.
They can show it so that it survives the challenge. That's. I'm not convinced as of yet that it has to be pled in the indictment.
Definitely in a bemoaning way.
To see a couple of those evidence. We all are a little curious now,
Right.
To see was that even done? Because if it wasn't, and it wasn't raised, then you are the first brilliant man thinking this. Because the other folks missed that issue entirely.
It wasn't even my idea. I'm just, managed to
You're that man.
idea. So I'm just one showing up with the argument. And then the last point I wanted to address, and now again, happy to answer any questions the court may have, but nor do I want to overstay my stay, which I feel like I've already done. But let me just end on this.
I'm here every day, Monday through Friday.
Yes, sir. I do not agree. I do not agree that a plea and abatement motion to dismiss was refiled. That the remedy, if Your Honor were to agree with us, is to keep the indictment active and bring in the district attorney for Fulton County. The analogy, to use the Brown case that Mr. Fowler cited, I believe would be that if it's an analogy I would use is that we were challenging the AG's office for bias. First of all, I think that the Brown case deals with grand jurors and the constituency of the grand jurors. We're dealing with the constitutional authority of the prosecutor.
We're dealing with the charging document that came out of it.
Yes, apples and oranges, okay?
Who was allowed to be in the room? Who was,
Okay, but even secondarily, if we were challenging the Attorney General for bias, that might arguably be more of a effectum, or whatever the right word is. But this is one where the AG lacks constitutional authority, and that's clearly much more akin to a defectum, which the remedy would be dismissal of the indictment. John has already noted, we're dealing with the Brown case over grand juries, we're dealing with the constitutional authority, the prosecuting authority to begin with. So I don't think you have to get to that level. If you did, the analogy is much more, this is a plea of defectum, not affectum, and therefore the remedy would be to dismiss respectfully.
Well, I'm leaning more toward that if someone's brings something that they're not allowed to bring, they brought illegal nullity.
Yes, I agree. I think the indictment is a nullity. For that reason, we ask you, Your Honor, to grant the motion and dismiss count one.
Okay. Mid-morning break. 10.
That completes my business. Your Honor, allow me to see this.
You are free to go.
Good to see you, Your Honor. Thank you. We adjourn.
Oh, is that it? Oh, no, they come back. They come back. All right, so they come back like around here. Oh, that was a good little... I'm so proud. Look how good that jump was. Hal had something come up, you guys. So his stream is now...
Positive of this case.
Hal's stream is now 5:45 p.m. Eastern, so we're still going to redirect over there, but I think this will carry us over, well, not all the way, but if we blather on and on long enough, we can redirect nicely when Hal starts his stream.
If I grant it, it goes away. If I don't, you keep on trucking. At this time, I do not find the Attorney General had the authority to bring this Rico case. The legislature can fix that. They did with gangs. They did with domestic terrorism. I think it would be logical for them to do so with Rico, given that Rico, corrupt organizations, rarely stay in one jurisdiction. As this case, they cross jurisdictional lines. The Attorney General has constitutional duties, has statutory duties. And I think it would have been real easy to just ask the governor, let me do this, give me a letter. The mechanisms were in place, and the steps just weren't followed. It's not that he couldn't have gotten that letter. There are mechanisms in place whereby he could have brought this. Now we have the question of count two. There's no question he had the authority to bring. I think the defense even concedes that in their brief. So, the remedy, and I'm going to chew on this, I'm going to adjourn for the day, because I need to figure out where I'm going with this, is the remedy, does the whole indictment die? Or just counts 1 and 3, and we proceed with an indictment that has count 2 on it, and we go from 61 defendants to, is it 5?
Wow.
5. I have no question that the state's going to appeal it. And I may be wrong. The folks across the street will tell me if I'm wrong. This is, and I welcome their opinion. And if I'm wrong, we come back down and we keep on going. But that's where I'm at right now. And I don't see, I mean, I don't even get to, given the fact that I don't find he had the authority in this particular instance, not that he can't bring a Rico charge. He just didn't do it correctly in this instance. I gotta go figure out what I'm right now. What would be the state's, you're gonna want, even if we go forward on count 2, you're still gonna want to appeal this. Obviously, to the extent that you need a certificate of immediate review, I obviously will write you one. I don't think redaction is, I don't know if it kills the whole indictment, because he had the authority to go in there and bring count 2. So, do we redact it? Then where are we with, do we now have 56 unindicted co-conspirators in 225 overt acts? As to, because all those overt acts are part of count 1, so they go away. Do we just go with the 5 defendants? Mr. Fowler, you clearly got something on your mind.
I do, because I already thought about what happens if this does happen. You know, as a lawyer, you have to do that. I mean, this with all due respect, we disagree with the court.
I didn't expect you to agree with me, Mr. Fowler.
Right, and the court knows I've known this court for a long time. We respectfully disagree. We believe that the court's analysis is wholly incorrect.
Flawed.
Wholly flawed as well. But I think that if a certificate is granted on this, which I do think a certificate has to be granted because it's not a final order.
I mean, can I throw out the whole, the entire indictment?
I don't think so.
Well, if I throw out the entire indictment, then it is a final order.
Correct.
And I can bring it up and they can tell me, hey, Farmer, you got it wrong. You should have gone forward on count 2.
Correct. I agree. If you quash the whole thing, yes, that's a final order, no doubt about that. But if it's just count 1, I think at that point we have to have a certificate of immediate review from the court, in which case would, of course, deprive the trial court of jurisdiction, I believe, over the entire indictment. I don't think you can cleave off one, send it up, and then handle the other one. You're going to have double jeopardy issues.
Right. Well, and if I just go forward with count 2, I don't even get, I'm not going to rule on the demur issues, given that I found he didn't have the authority to bring it. Because if it's, in my mind, it's a legal nullity because it never existed, so I don't have to, if they send it back down and say you got it wrong, and I've got it, then I have to look at, okay, now I've got a valid indictment as far as these 2 counts are concerned, then I have to address the special demur issues. So I don't know that I'm not going to write anything on that because it's not right, given my ruling on the abatement. So we're done for the day, folks.
And so will the court sua sponte issue if I presume for a moment that the court only limits it to count 1, will the court sua sponte issue the
certificate?
Thank you, I was wondering. Or does the court need to move forward?
I'll grant you one. For the record, the court is going to grant
We miss you, Cass.
a review to the extent that it is necessary for the state. Yeah.
For sure, they'll be in order.
And now, I know this motion didn't concern count 3, so I'm going to go chew on that, because count 3 is arson, and it is in the same legal boat as Rico, in that there is no statutory exception allowing the Attorney General concurrent jurisdiction to bring that crime, or that count. So, thank you.
Judge, are you planning to enter an order
Yeah.
today?
I'm not going to promise today.
I appreciate that there's a threshold issue of if there's no authority, can they bring count 2 in the same way with the other counts? And just being the one representative of the defendant who's facing count 2 here in these 4 cases.
I would like the opportunity to chew on that and think about it before the court enters a ruling, because if you were to conclude before we talk again that count 2 can survive, I just think for everybody's interest, sending up the count 2 certificate, if that's what happens, whatever certificate might be, because we've got count 2 issues coming up that are good issues.
As Mr. Fowler pointed out, once his certificate goes up, I'm not gonna, so you want me to rule on count 2, and hey, while you're looking at how Judge Farmer got it wrong on count 1, let's look at how he got it wrong on count 2 as well?
I don't mean that, Judge. What I'd like to ask for is, could we...
These challenging constitutionality of count 2.
Sure, and I guess if I may, I apologize for kind of jumping in. If this court's ruling, and if this court's ruling is incorrect, which we don't believe it is, how can we go forward on anything else? Mr. Simpson, I can't get up and argue.
Pardon?
How can we get up and argue if we're getting a certificate of review, we're depriving the trial court of jurisdiction?
Okay, but he's saying right now, before I do that, I still have jurisdiction until I put my name on a piece of paper, correct?
I agree. Okay, right now.
So he's saying, hey, while we're all here, can we be heard on the constitutionality issue of the domestic terrorism statute?
Maybe not even, Judge. There's a fork in the road coming up that's on your desk. Are we just going to say they have no authority, and so the
I
certificate
think
goes
it's
up?
more of a T-junction, not a fork.
Sure, we are fully stopped for the moment.
Yes.
Junction, Judge. But you may, and I think what I understood is, there's a chance you could consider this afternoon and decide, count 2 can survive, and we can live with it here and move forward. And maybe the state would want to do that. It sounds like they might not. My request is, could we meet back here in the morning to just be heard on what our position is for how we go forward next? We have a lot of good minds on this issue.
Well, here's, as soon as I sign, are you asking for me to have a hearing on the constitutionality? Because once I sign the certificate of immediate review, we don't go forward. As Mr. Hall said, now I literally lose jurisdiction until they make a decision. So then we can't keep going and talking about count 2.
Understood. If before that certificate were issued, while you still have jurisdiction, you were to determine that they do have the authority to litigate count 2, even knowing that they're going to take the certificate as soon as they can. While the jurisdiction is here, if they have the authority to do it, theoretically we could have litigation on count 2.
Right, yeah, I could go forward on litigation.
And I'm not suggesting that's what we should do or we should not do. I just would like a couple hours to think about it. And the reason I'm asking is,
Right, yeah, if I rule, I would rule one way or the other, it's either constitutional or not. And you're saying judicial economy, send both issues on.
judicial economy, and for people, my client in particular, has been sitting here for 2 years, stuck on what our position is. It's essentially allegations of misdemeanor conduct. But now we'll sit here for that much longer while the certificate does its thing. Maybe it would be...
They may turn it around and say no.
My request would just be to come back in the morning and we state our position, how we think we proceed from here.
Well, and does the state want to have some time to think about, hey, if we're going across the street, do you guys want to go across the street on both issues, seeing as how you're going to have to get, one way or the other, they're going to be hearing about, either you're going to, if I rule, hey, it's constitutional, you're going to have to litigate it over there because these folks are going to want to appeal it. And if I find it's unconstitutional, you're going to be over there anyway. Do you want to make it, for lack of a better term, one-stop shopping? And you do not have to answer that question right away, just like Mr. Schwartz doesn't really want to answer that right away.
And I also understand Mr. Schwartz is from out of town, and I don't want to delay him in town any longer than he has to, but I would like a little bit of time to think about that if that's okay.
Well, that's what he's saying.
Yeah.
It's just tomorrow morning, you guys want to come back and reconvene at 9:30?
We have all week with the court.
Yes, please.
I'll see you all at 9:30 in the morning.
Great. Did he say 9:30 or 8:30?
Yes, please.
I'll see you all at 9:30 in the morning.
9. Okay. So chat, I'll try to do that live. Pretty excited to hear that. It was honestly a bit complicated. I get the general gist of it, right? The investigation was started by this one thing, and that's not really pled in the indictment. And several other issues were raised. Does the Attorney General really have the authority to bring this prosecution? Seems like the judge is leaning that he does not think the Attorney General had authority, at least as far as count 1, which is the racketeering, and then count 3, which is the arson. Indictment is linked in the chat and in the description if you want to take a look at the whole thing. But now they're wanting to make this record on... Oh, and sorry, I hate that Google added AI and now it's like, it makes everything super tiny. So let me add it in a separate window and go all the way down to count 2. They want to make their record on this, on the domestic terrorism. And we heard the judge, and that might have been a guesstimate, but I think he's right. He said that there were 5. There would be 5 remaining without this Rico count. These would be the 5 we're looking at. So, and very interesting because, remember, they're trying to break this trial into different groups, right? But they invited Don Samuel to come argue today. I don't believe any of these 5 are clients of Samuel. Samuel was representing, what was her name? Adele. I believe these 3 are the clients of Joel McDermott, Don Samuel, and their law firm. So Marlon Kotz, Adele McLean, Savannah Patterson. We heard Don say earlier that he already made motions about these other counts and that the only remaining count against these 3 was the racketeering. So if that's successful, if it's not reversed on appeal, I think Don Samuel, I think his clients would be out of the race, but he got to make his arguments today, even though this trial set isn't involving his clients. So super, super cool to have seen him make his arguments. Maybe we'll see him again in this case. Maybe we'll have to wait till another case to see an appearance. And count 2 is the domestic terrorism. So let's go back down, or up, is the domestic terrorism here. So, but what's interesting is, if you guys can see, it's like tiny up here, but we're on page 83 of 92. And count 1 takes up all the rest of this. So when we get rid of this racketeering, we'd have it'd be slim pickings. Because these are gone. This is already gone. I believe all of these are gone. Straight, all of these Marlon Kotz, Adele McLean, and Savannah Patterson ones are gone. Just straight down. Gone. Tons of counts of this money laundering for those same 3 Don Samuel's clients. And then we're at the bottom. And yesterday's hearing was the joke, well, it'd be problematic to throw out 25 pages of the indictment, and yet here we are. Peach Milkshake says that the domestic terror is the only one with weight, in my opinion. And it seems like the judge mentioned, let's go read it. Why not just have, since that would have been in Fulton, why not just have the district attorney bring it? Right? So yeah, City of Atlanta. So who knows? I mean, if this crumbles down as far as the attorney general prosecuting this, maybe we'll get some Fani. Who knows? And Happily Angry Lawyer, the racketeering, the judge wants to dismiss the racketeering and the arson. And yeah, whittling it down. And then tomorrow they're going to get together for a hearing at 9:30 Eastern in the morning to let the defense make their record on the constitutionality of count 2. And the state will obviously have their chance to respond. So, oh yeah, does that say one of these? Yeah, so we heard the mention of like the hot dogs, the veggie hot dogs. Yeah. Money laundering, the amount here is $27.62, $52.22, $256. Now we're talking. $27.62, $12.52, $68.81, $93. What are we at? Like 500? $99, 68, 140, 61, 48. I mean, and then 38. Yeah. I mean, is that under $1,000? I'm not gonna do stream math, but like, oh man, what a great money laundering operation. And what kind of veggie dog? High rollers. Cashback rewards could clear that right up. Heck yeah. I love using my card for stuff to get cash back. Love the rewards. And then guys, we're gonna do a redirect over there. It's gonna be a little early, but that's okay because I have a surprise for you as soon as you arrive. When we do this redirect over to Jim's stream, we will start this back up at 9:30. Do you guys want to end here with the objection, "You're ruining my case" song? Do you feel like this is a good time for it? Because I do. I do. Oh wait, one more thing. I wanted to pull over to this. Jumping over to Bortlen coverage. Again, let me drop Bryson's link. Let me drop it to my Twitch friends. Calling this one Bryson. But we have some quotes here from YNW Bortlen's attorneys Fred Haddad and Joe Nascimento. So on the deal and the ruling, Haddad says, "I feel good for the kid. I've been on the case 6 years. It's a fair resolution for him. The state was fair." I can make this a little bigger, I think. On what Bortlen will serve. Well, he gets 1,000 days, and then in the other one, he gets 700 days. Remember, there were 2 cases. It's going to be concurrently served. On the message, this sets for Melly's case. Well, there's no message that I see. They're 2 different people, 2 different cases. Facts are different for both. On what Bortlen will have to do, and will he have to testify against Melly? Haddad said, "A couple questions, that's it. He's not going to be a witness." On did Bortlen admit to the crime with a no contest plea? This is the other attorney, Nascimento, speaking. I think it's important to know that, 1, today you did not plead guilty. He's pled no contest, and so he hasn't really admitted anything. And there's no anticipation that he's going to be called. He has a witness. He has a witness? I don't know what this is supposed to say, but it reads he has a witness by the state or the defense at the Melly trial. So nothing that happened today or will happen in the future, I think, will change. I think that's will, not wheel. Importantly, he hasn't admitted anything. So although the court found him guilty because of his no contest plea, no one could say that he has admitted that he committed tampering or accessory after. Certainly not murder, because that was dismissed. And I think that's important, you know. It was a no contest on the laundering, the tampering and accessory. On why accept a plea 24 hours before trial. And I think this just goes to human psychology, but Nascimento says, "I think just naturally that happens in these types of cases. Both sides are putting in a lot of work. Fred's been working on this for years," that's the other attorney, "for 6 years. The parties, you're ready to go, but we all know the strengths and weaknesses of the case." And then Haddad tag teams in and says, "The state knows what their strengths were and what our strengths were. And that's how you resolve it. I've got the same thing going on in other places. You know, we resolve cases before trial, sometimes with a very favorable outcome. I prefer to be in trial, but what are you going to do? There are some things you can't turn down. The state said, we're going to drop 2 counts of first-degree murder if you want to resolve it. In order to plea, people have to do jail time, but the alternative is very difficult." So then Nascimento jumps back in, says, "Yeah, so Cortland's 26 years old. With this resolution, he could be out at 31 years old. If he's found guilty of one of many of those counts, and it would have been mandatory life. So just on balance, you look at that, and sometimes someone in his position, it's a hard decision to make, regardless of what you think about your chances at trial, regardless of how strong your case is. You're looking at life. It's multiple counts and 2 different cases." And again, remember, the state offered him the very bottom limit minimum on the 2 counts that he pled no contest to. So it's like, even if he went to trial, if that's what they had the best evidence against him for, and he went to trial and was convicted of those things, it really would have been none the better. So, and then Haddad concludes with the following. "Every lawyer can tell you horror stories, cases you thought you couldn't lose that you'd lose. Cases you thought you couldn't win that you win. It happens all the time. You can't figure out a jury." So there we go. There we go. I see Late Night Mookie Mookie in the building. Good to see you. Hello. Oracle Cat, you're welcome. Thanks for hanging out with us. The surprise is that the chat's being put on notice that we did a Rico. We did a Rico. Yeah, stream math, guys. You know, I like math, but I get sweaty. I get like, you know, I know we've done hours and hours of streams, but I still get up here like, suddenly can't think. So, It was small amounts. We'll leave it at that for that wonderful, wonderful money laundering. They were using an RV washer to do the laundering. Oh, man. Yeah, Keisha E., a lot of us are also confused. You know, they name an organization that's supposed to be this enterprise, but then they name a bunch of other organizations that are actually doing the things, or overheading the things. And then the state's argument today was they're part and parcel. They're one and the same, but not really that clearly laid out in the indictment. So we're going to end with the song. And Road Dogg says the attorneys are saying they don't anticipate that he'll be called as a witness. So, I mean, that's very surprising to me. Honestly, we'll see how that plays out, but that's what they're saying. That's what they're saying. And perhaps because he's offering a proffer, that will allow them, I don't know if this is how it would work, but maybe because he's going to sit down and sit for however long to tell the state, whatever, even if they don't call him as a witness, perhaps they'll be able to use what he's telling them to introduce something as evidence that otherwise is not admissible at this point in time, right? So that proffer, I think, could be useful if it works that way. I'm just guessing. I'm not a lawyer. But that proffer could be advantageous in a way that would not require somebody to take the stand. I could be entirely wrong on that. So, but I think that's how you'd get the a little bit for the state and a little bit for Bortlen to both get something that works out for them. Yeah, Keisha, being charged for providing hot dogs is crazy. Yeah. So, when we do a chat get-together, we do a meetup, guys, we got to be careful about how we cash up each other for shared expenses. We don't want to be wrapped up in something like this. And then I'm going to mute this out. The song's like 3 minutes long. If you have any closing thoughts or recommendations in the chat, but this will redirect us over to Happily Angry Lawyers' upcoming stream. I think he might have some great news to share. We'll see. We'll leave it up to him. But I have something immediately after we redirect that's going to be a surprise in the chat. So make sure you stick around for the redirect. Have a good one, you guys, and see you in the morning.
Objection! You're ruining my case. State keeps spinning stories all over the place. From source to letters, they got no trace. Objection, you're ruining my case. Can't rule it out, rule it out. That's reasonable doubt, doubt. State says anything goes, spinning theories around. Can't rule it out. That's reasonable doubt. can't rule it out.